House will come to order. Members, please register. Have all members registered? Have all members registered? A quorum is present. The House and Gallery, please rise for the invocation, which will be offered by Pastor Scott Wall from the Capitol Commission in Austin.
Thank you, Mr. Speaker. Good morning, members. Since today is called by many a day of worship, I thought today the word for today would be worship. And in Greek, the word worship, proskuneo, means to kiss forward or kiss the ring or kiss the foot as a symbol of loyalty and submission and reverence. And so I just thought today's prayer ought to be focused upon that kind of worship. So please join me in worship this afternoon. God of heaven, creator of the universe and all that's in it, you are the God who is always there. Your love never fails. Under your command, nations rise and fall, and we thank you for the privilege of living in America that you created and within America, Texas. And we thank you that our forefathers who saw the wisdom in following your laws and commands. But we acknowledge that we need you to change us from within so that we don't have to write so many laws that control us from without. Please forgive us of our sins and grant us the ability to forgive others. Give us the mercy to allow our differences under you to become our greatest asset and strength. And as leaders of the state, please give us the wisdom to lay down our prejudices and differences to promote freedom and liberty for those we serve. As we bow before you, please surround this body with your peace as we work. In Jesus' name I pray. Amen.
Chair now recognizes the Honorable Barbara Gervin Hawkins from Bexar County to lead us through the pledges of allegiance to the United States and Texas flags.
Mr. Speaker, colleagues, members of the gallery, please join us in an honorable pledge to our U.S. flag as well as the great state of Texas. I pledge allegiance to the flag of the United States of America, and to the republic for which it stands, one nation under God, indivisible, with liberty and justice for all. Honor the Texas flag. I pledge allegiance to thee, Texas, one state under God, one and indivisible.
Please excuse Mr. Reynolds because of important business in the district on motion of Ms. Ward Johnson. Please excuse Representative Wally because of important business in the district on motion of Representative Rosenthal. Is there objection? Chair is none so ordered. The following bills on first reading and referral, the clerk will read the bills.
SB 823 by Middleton, relating to labeling representation of imported shrimp, authorizing administrative penalty for the Committee on Culture, Recreation, and Tourism. SB 1380 by Paxton, relating to healthcare benefit plan, pre-authorization requirements for participating physicians and providers providing certain healthcare services for the Committee on Insurance. SB 3074 by Birdwell, relating to the communications between the Texas Commission on Environmental Quality and the Governor and Lieutenant Governor or a member of the legislature for the Committee on Environmental Regulation.
Mr. Guerra moves to defer the remainder of the reading and referral of bills until the end of today's business. Is there objection? Chair is none, is so ordered.
Okay. Mr. Lambert, for what purpose?
Parliamentary inquiry.
Please state your inquiry.
Is the chair advised that there's an actual work zone right in front of the speaker stand when you are sitting in the when you're standing in the chair?
The chair is not advised.
Would you be okay if we provided some protection for the ladies that work directly in front of you where the Yes, that's what we wanted. Thank you, Mr. Speaker.
It's probably a good idea. Mr. Buckley for an announcement.
Thank you, Mr. Speakers. Members, just want to notify you that we have the LBB runs based on House Bill 2. They're upstairs in 3W9. make your way up there today, take a look at those runs, and see me if you have any questions. 3W9 just upstairs. Thank you.
The chair lays out the following privileged resolution. The clerk will read the resolution.
HCR number 156 by Noble, instructing the enrolling clerk of the House of Representatives to make a correction in HB number 140.
The chair recognizes Ms. Noble to explain the resolution.
Thank you, Mr. Speaker and members. This resolution authorized technical corrections on House Bill 140. I call up, do I need to call it up? Sharon, do I need? Section 2 of this bill was repealed by legislation passed previously this session, so technical correction removes that section and renumbers the remaining sections of the bill accordingly. I move adoption.
The question occurs on the adoption of HCR 156. This is a record vote required by the Constitution. The clerk will ring the bell. Show Ms. Noble voting aye. Show Ms. Jones of Harris voting nay. Show Mr. Little voting aye. Ms. Fairley voting aye. Have all voted. Being 116 ayes, 7 nays, the resolution is adopted. Members, we're about to go on the calendar. If you have a bill on the calendar, please be ready. The chair lays out SB 37 on third reading. The clerk will read the bill.
SB number 37 by Creighton, relating to the governance of public institutions of higher education, including review of curriculum and certain degree and certificate programs, the powers and duties of the faculty, council, or senate, training for members of the governing board, and the establishment of the Office of Excellence in Higher Education.
The chair recognizes Mr. Shaheen for a motion.
Mr. Speaker, I move to postpone further consideration of SB 37 until 4 p.m. today.
Members, you've heard the motion. Is there objection? The chair hears none. So ordered. The chair recognizes Mr. Bell of Montgomery for a motion.
Thank you, Mr. Speaker. Members, I move to suspend Rule 8, Section 5D to designate as joint authors and co-authors for Senate Bill 8, all joint authors and co-authors for House Bill 5580.
Members, you've heard the motion. Is there objection? The chair hears none. So ordered. The chair lays out on third reading Senate Bill 8. The clerk will read the bill.
SB number 8 by Schwertner, relating to agreements between sheriffs and the United States Immigration and Customs Enforcement to enforce federal immigration law.
The chair recognizes Mr. Spiller to explain the bill.
Thank you, Mr. Speaker. Members, this is the 287G bill that we talked yesterday. I move passage.
The question occurs on final passage of Senate Bill 8. This is a record vote. The clerk will ring the bell. Have all voted? There being 86 ayes, 47 nays, Senate Bill 8 is finally passed. Chair lays out on third reading Senate Bill 10. The clerk will read the bill.
SB number 10 by King relating to the display of the Ten Commandments in public school classrooms.
The chair recognizes Ms. Noble to explain the bill. Please excuse Mr. Cortez because of important business in the district on a motion of Ms. Perez of Harris. Is there objection? The chair hears none, so ordered. Ms. Noble to explain the bill.
Thank you, Mr. Speaker. This bill requires donated Ten Commandments to be displayed in Texas classrooms, and I believe Representative Hinojosa has a perfecting amendment.
The following amendment, the clerk will read the amendment.
Amendment by Hinojosa.
The chair recognizes Ms. Hinojosa to explain the amendment.
Thank you, Mr. Speaker. Members, this amendment, I've worked with the author in the Senate and the author here, and all it does is add the same language that's in Senate Bill 11 that says if there's any challenges to the lawsuit, it is the state that defends and pays any kind of attorney's fees and liability, and not the school districts. I move adoption.
Ms. Hinojosa sends up an amendment. The amendment is acceptable to the author. Is there objection to the adoption of the amendment? The chair hears none. The amendment is adopted. The chair recognizes anyone wishing to speak on, for, or against Senate Bill 10. The chair recognizes Ms. Noble to close on the bill.
Okay, I move adoption.
Mr. Speaker,
Ms. Goodwin, for what purpose?
I would like to ask some questions.
Will the lady yield for questions?
I can see your expression,
Well,
but
we
I know
discussed
we
that.
had a lot of
The lady
conversation
yields.
about the bill yesterday, but some things occurred to me after the facts. You know, I've really thought about this bill quite a bit, and there were some questions that were remained after all the conversation yesterday. So I hope you'll bear with me a little bit. You said you answered someone else's question saying this is not an unfunded mandate. So I guess my question is, who is paying for the 10 Commandments that will go on the wall of every single classroom in the state?
If they are donated, they will go on the classroom walls. It's up to the donor whether they want to do that or not. I'm assuming it would be individuals who felt strongly about it, or maybe even an organization that felt strongly about it. But we definitely don't have anybody waiting in the wings to do it, if that's your question.
Okay, I appreciate that. That does clear up something. In other words, it may not go on every classroom if a donor has not provided it. So let's say a donor wants it to go in a particular school that their child is attending. It's up to them to give a certain number for every classroom, or if they gave one and said, I want it on my child's classroom wall, is that how it would work?
We didn't prescribe that in the bill itself, but I assume that that is how it would work. That is how the In God We Trust worked when we did that last session. So I assume it's going to do a similar
So in
type
other
of an
words, just to make it as clear as possible for everyone who's paying attention, if a parent said, hey, I want this to be in my child's classroom, I'm giving the school one to go in that particular classroom, that's what would happen.
That is my understanding. I believe that is completely in compliance with the law.
Okay. So let's say that same parent wanted it to go in all the classrooms in a school. Please bear with me. Would it go in a pre-K classroom or classrooms where students aren't yet able to read?
Yes, it would, if that is the donated purpose.
If-
And my grandchildren read as preschoolers. I don't know about all preschoolers, but mine did.
Well, there's some lengthy words in the Ten Commandments. I just, they might be able to sound out
Well,
some.
I would invite you to come read the New England Primer. They did not assume that their little ones couldn't read lengthy words. So
Okay.
that is the reason we're doing this is because it does have an educational history in our nation.
And again, if this parent or donor gave enough of the Ten Commandments to go on walls, would it go on a band hall wall,
Yes.
a gymnasium?
Yes.
Um,
As those are classrooms where classes take place.
So it could go even in a Spanish classroom, the English version.
Yes.
Do you have advice for school districts when complaints come in from parents or teachers? I mean, there might be the one parent that really feels strongly and makes this donation, but there could be another parent who makes a complaint. How should that be handled?
I think you should refer to the amendment that I just accepted from Representative
Well, that's about
Hinojosa
a
on it.
lawsuit. That's not really about a complaint.
That's true. You're right. I assume that the schools or the school districts will find their own way to handle it, and that is not in the bill itself.
I just think that puts schools and school board members and teachers and principals in a tough position to have to defend something that they had no ability to determine.
They do that every day with laws that we pass in this room.
That is very true. And actually, this amendment does answer one of the questions that I was going to bring up about Louisiana having a lawsuit and who would pay for it. So I appreciate you accepting that amendment. And I understand, I do appreciate you taking the amendment. I don't want to do anything to jeopardize that. But I will say that I also give a lot of thought to what is happening in the world. My son has been in the Army for 5 years.
Thank
He
you
is
for his service.
there
So
to
grateful for that.
defend our freedom. And that freedom includes freedom of religion. And I just think if I were giving a speech, I would say this just seems like we are trampling over the freedom of religion by passing your bill. Thank you, Representative.
I move passage.
The question occurs on final passage of Senate Bill 10. This is a record vote. The clerk will ring the bell. Have all voted? There being 82 ayes, 46 nays, Senate Bill 10 is finally passed. The chair lays out on third reading Senate Bill 227. The clerk will read the bill.
SB number 227 by West relating to the application review process for certain delayed birth certificates.
The chair recognizes Ms. Rose to explain the bill.
Thank you, Mr. Speaker. Members, let's make it easier for seniors to obtain their birth certificates and IDs. Move passage.
The question occurs on final passage of Senate Bill 227. This is a record vote. The clerk will ring the bell. Have all voted? There being 133 ayes, 0 nays, Senate Bill 227 is finally passed. The chair recognizes Mr. Metcalf for a motion.
Thank you, Mr. Speaker. I move that the House grant permission for the Committee on Culture, Recreation, and Tourism to meet while the House is in session today at 2:45 p.m. in room 1W.14 Agriculture Museum to consider pending, referred, and committee business.
Members, you've heard the motion. Is there objection? The chair hears none, so ordered. The following announcement, the clerk will read the announcement.
The Committee on Culture, Recreation, and Tourism will meet today at 2:45 p.m. in room 1W.14 Agricultural Museum in a formal meeting to consider pending, referred, and committee business.
The chair lays out on third reading Senate Bill 261. The clerk will read the bill.
SB number 261 by Perry, relating to the prohibited manufacture, processing, possession, distribution, offer for sale, and sale of cell-cultured protein.
Chair recognizes Mr. Gerdes to explain the bill.
Thank you, Mr. Speaker. Members, SB 261 is about protecting Texans from being a science experiment. And I move, Pat. Go ahead.
Mr. Speaker, question for the author.
Will the gentleman yield?
Yes.
The gentleman yields.
Mr. Gerdes, I was reviewing the votes on this bill yesterday, and I know people probably don't want to hear me talk, but we need to talk a little bit. I'd like you to explain a little more about the things that are behind this, the people who are behind this, the true agenda of this, our colleagues who really understand what's going on. This isn't about food freedom. Maybe I'd actually say that it's the opposite. It seems like they actually don't want us to be free to eat meat. Do you know anything about that?
Yeah, so as I kind of alluded to yesterday, this bill is just about a 2-year pause to talk about fairness in a market. Our meat producers have strict guidelines and regulations they have to follow in this state. And we have a new food product that's emerging. And this bill doesn't stop the emergence or innovation or research of that. But what it does is put a 2-year pause so the state of Texas can have some time to create a fair and equitable regulatory framework for this type of new cell-cultured protein, i.e.
But
fake
can you tell
meat.
me about who?
But
why?
the folks that are the opposition behind this, their end goal, and I quote from a Food Tank article, "I don't think we're too far away from a world in which 100% of meat is either plant-based or clean," which is what I said yesterday about the big idea of getting away from our agriculture industry, which is the backbone of Texas.
But who are these people? I mean, what are their names? I'm seeing one that's called the Good Food Institute.
The Good Food Institute, yes. And the president of the Good Food Institute, Bruce Fedrich, that was a quote from him from a Food Tank article. And
Members, please take your conversations outside the rail.
All right.
So the big idea here is Texas is not going to be getting rid of its agriculture industry, our cattle.
Did you say Bruce Frederick?
Yes.
Is that the PETA guy?
Yes, he spent 13 years at PETA.
Okay. Seems pretty weird. Look, I'm looking right here. It says we've tried to convince the world to go vegan, and it's not worked. It seems like their agenda really is that they don't want us eating animals, or maybe they just love animals more. But I don't think that it's more sinister than that.
And come hell or high water, if anybody gets in the way of a grass-fed beefsteak.
I think you're probably right on that. Now, also, they're trying to claim that we're going to save the world. We're going to save the environment by getting rid of the cow farts. I'm trying to understand how by going to some
Well, I'm pretty sure this country has cut our greenhouse emissions by a substantial margin versus everybody else in this world. And to say that we need to get rid of our cows because they're contributing to this is
great. Well, look, I hope our colleagues maybe who had not listened yesterday will have listened to you today. Understand that not only do we need to support our ag industry and our cattle raisers, but the real agenda behind this isn't for freedom, that it's actually the opposite. So for freedom today to vote yes on this bill, and to support our farmers and cattle raisers. Would you say
That's
that?
right. A vote today is in support of our cattle raisers and our meat producers, and I urge you to vote with me, and I move passage.
Thank you, Representative.
The question occurs on final passage of Senate Bill 261. This is a record vote. The clerk will ring the bell. Show Mr. Ashby voting aye, Mr. Bell of Kaufman voting aye, Mr. Van Dever voting aye, Mr. Shaheen voting aye, Mr. King voting aye. Have all voted. There being 99 ayes, 36 nays, Senate Bill 261 is finally passed. The chair lays out on third reading Senate Bill 12. The clerk will read the bill.
SB number 12 by Creighton, relating to parental rights in public education and to certain public school requirements and prohibitions regarding instruction and diversity, equity, and inclusion duties, and the loss of funding for public school that fail to comply with those provisions.
The chair recognizes Mr. Leach to explain the bill.
Thank you, Mr. Speaker. Members, this is the Texas Parent Bill of Rights, and I move passage.
The question occurs on final passage of Senate Bill 12. This is a record vote. The clerk will ring the bell. Show Mr. Leach voting aye. Have all voted. There being 88 ayes, 47 nays, Senate Bill 12 is finally passed. The chair lays out Senate Bill 15 as a matter of postponed business on second reading. The clerk will read the bill.
SB number 15 by Betancourt, relating to size and density requirements for residential lots in certain municipalities, authorizing a fee.
The chair recognizes Mr. Gates to explain the bill.
Thank you, Mr. Speaker and members. This bill will help address the housing affordability crisis in Texas by increasing supply of residential homes being built. The price of land, which makes up as much as 25% of the price of a single-family home, by lowering the size and type of residential housing.
Mr. Romero, for what purpose?
I raise a point of order against further consideration of Senate Bill 15 under Rule 8, Section 10B, House Rules of Procedure on the grounds that the bracket impermissibly limits application to a political subdivision by means of artificial devices.
Please bring your point of order down front. Mr. Romero raises a point of order against further consideration of the committee substitute for Senate Bill 15 under Rule 8, Section 10B, on the grounds that the bill is impermissibly limited in application to one or more political subdivisions by means of artificial devices. The bill is reported from committee, exempted from its application a location that is, among other things, within 1 mile of a campus of the perimeter of a law enforcement training center in a county that has a population of 2.6 million or more, but less than 2.7 million. The chair notes that the rule permits the use of minimum or maximum population in a bill to limit its application, but not both. Here, the bracket includes only Dallas County. The chair would be required to find a reasonable basis between the location of a law enforcement training center in Dallas County and the bill's purpose of increasing the housing supply. The chair can find no such basis. Accordingly, the point of order is well taken and sustained. Members, please take your seats. We have a memorial recognition. Please take your seats, members. The chair recognizes Mrs. Weiner for a memorial recognition.
Thank you, Mr. Speaker, members. The San Marcos CISD community received sad news in the early hours this morning. There was a high school graduation party held by some graduating San Marcos High School seniors, and an unknown person fired a gun at that party and killed a recent graduate, Andrew Furious. There's still not a lot of details about the incident, so I won't go into that. But what I will say is that Andrew was part of a tight-knit family. He was a mentor to his younger siblings and his younger cousins. He played for the San Marcos High School Rattlers football team, and he was scheduled to start at Texas State University in August, where he hoped to pursue a degree in construction engineering. Members, all of the community of San Marcos is grieving for this young man right now. And I ask you to take a moment with me to honor his too short life and to think of his family and loved ones and our community.
Members, please rise for a moment of silence. Thank you, members. Is Mr. Capriglione on the floor of the House? Chair recognizes Mr. Capriglione for a motion.
Mr. Speaker, I move to suspend House Rule 8, Section 5D for Senate Bill 438 to designate the following member as joint sponsor. Representative Guerra.
Members, you've heard the motion. Is there objection? Chair hears none, so ordered. The chair lays out SJR 27 as a matter of postponed business on second reading. The clerk will read the resolution.
SJR number 27 by Huffman, proposing a constitutional amendment regarding the membership of the State Commission on Judicial Conduct and the authority of the Commission and the Texas Supreme Court to more effectively sanction judges and justices for judicial misconduct.
The chair recognizes Mr. Leach to explain the resolution.
Thank you, Mr. Speaker. Members, the State Commission on Judicial Conduct is the commission in Texas created to protect the public, to promote public confidence in the integrity, independence, competence, and impartiality of the judiciary, and to encourage judges to maintain high standards of conduct. SJR 27 by Senator Huffman, passed by the legislature and then approved by the Texas voters, if passed, I should say, would amend our state constitution to adjust the membership of the State Commission on Judicial Conduct and to adjust the authority of the Commission and the Texas Supreme Court to more effectively sanction judges and justices for judicial misconduct. Members, the SJR before you changes the makeup of the Commission to be 13 total members, 6 appointed by the Texas Supreme Court with the advice and the consent of the Texas Senate, and 7 appointed by the governor with the advice and consent of the Senate. SJR 27 also allows for 1 private sanction to be issued for non-criminal offenses. Further, the SJR adds a requirement that an appointed master that hears and takes evidence on the matters to report back not only to the Commission but also to the Supreme Court. Further, if after a formal hearing or after considering the record and report of the master, if the Commission finds not only good cause but also that that person engaged in willful or persistent conduct that is clearly inconsistent with the proper performance of a judge's duties, that they shall issue a public reprimand and may recommend to a review tribunal the removal or the retirement of the person. I do have a floor amendment.
Mr. Speaker,
Mr. Wu, for what purpose?
would the gentleman yield for questions?
Will the gentleman yield for questions?
Yes.
The gentleman yields.
Representative Leach, the change in this SJR would put 7 of the 13 commissioners in the hands of the governor. This is a commission that oversees a different branch of government. Why is putting that much power in the executive branch to oversee a different branch of government, why is that a good public policy?
Well, you're actually not correct about that. While they are appointed by the governor, or I should say you're not telling the whole story, to be fair to you. While they're appointed by the governor, they have to receive the advice and the consent of the Senate.
Sure. How often has the Senate not approved the governor's choices?
The author is not advised.
Okay, it's not very often, or at all.
That's because he makes good appointments.
Or at least appointments that the senators are afraid of contravening.
I think he makes, having been a former judge himself, former Supreme Court justice, former Attorney General. I think the governor, when it comes to the judicial system and the appointments that he's made, by the way, not only Republicans but some Democrats all across the state have been resoundingly positive and successful.
Of the 13 seats, only 2 of the seats will actually be held by trial level judges or appellate level judges. Is that enough peer oversight? I mean, most of the complaints about judges are of their actions in trial. Why shouldn't there be a majority of trial judges in this commission?
Because that's the way we wrote the bill, and that's the way Senator Huffman and our counterparts in the Senate thought that it should be, and so...
No reason, just because?
I'm sorry?
There's not a specific policy reason, it's just that's the way we drafted it.
I think that's the proper... I think that's the way it should be. I think that's good public policy. I believe that this SJR is necessary, not only necessary, but beneficial for the state.
Sure.
In the way that it's written now, and would encourage members to vote for it today and the people of Texas to vote for it in November.
So, just to be clear, that this commission will review the actions of judges. Most, if not the vast majority of the complaints about their actions are based on decisions at trial, but having only 2 of the 13 judges be trial experienced judges, trial judges, you're saying that is good policy?
Yes.
Okay. This bill also says that 2 of the members will be appointed by the state bar, but these must also be cleared by the Senate, right? What's the point of letting the state bar choose their own members if the legislative branch has to approve it?
Where are you reading that, Representative Wu?
I'm sorry, I'm just working off the questions. I don't have the bill in front of me.
Well, I'm sorry, did I understand?
Is there a provision that says the state bar of Texas is allowed to appoint
Show me where in the bill you're talking about, Representative Wu.
What? I'm sorry, I don't know your bill as well as you do.
You're asking me questions about a specific provision of the bill. I would like to know what provision of the bill you speak of, because I don't believe that provision exists.
Okay. So you're saying there's no provision in your bill that allows the state bar to choose 2 of the commissioners?
Correct.
Okay.
Show me where you're talking about.
Okay.
No, Representative Wu, if you want to show me where you're talking about, it's not in the bill before the body right now.
If I'm mistaken, then I'm mistaken.
You're mistaken.
SJR 27 also requires the commission to suspend any judge who is indicted for a felony or even some misdemeanors before guilt is proven.
So Representative Wu, I'm going to ask you respectfully, because I don't believe you've read the joint resolution. So as you continue on in your line of questioning, which I'm happy and eager to answer your questions, but I'm asking you to point me to the specific provision of the JR that you're talking about.
All right. Very good. Look, you can answer my questions. You can not answer my questions.
I don't think you know what you. I don't think you.
That's fine. That's fine.
I don't think you've read the bill.
That's completely fine. You can answer my questions or not answer my questions. It's totally your prerogative.
You can read the bill or not read the bill. That's
SJR
totally
27
your
requires the commission to suspend judges if they have been indicted for felonies or some misdemeanors. What are the safety procedures to make sure that for people who have been politically persecuted, for people who have been indicted but their charges have been dropped, what are the safeguards and make sure that their rights are protected in this process?
The JR speaks for itself, Representative Wu.
Okay.
You should read it.
So there's no provision.
You should read the bill,
okay,
which you clearly have not done.
Okay. The commission would now impose public sanctions without first sending a case to a formal master to review. How does this proposal reconcile faster discipline with the judge's right to a full evidentiary hearing?
Asked and answered. You should read the bill, which you clearly have not done.
Okay. No worries. SJR 27 also tweaks the 3-judge tribunals that review commission decisions. Are those panels still randomly selected, or could a partisan leadership exert more control over them, meaning that maybe just all of the judge Abbott's appointees decide that they want to do one thing? What is the protection against that?
Representative Wu, I've answered the questions that you've asked. I'm not going to get into a political debate about your feelings regarding Governor Abbott.
Very good.
You can go to Twitter for
all the current commissioners' terms would end on December 31st, 2025. The Supreme Court would appoint an entire new slate that starts January 1st, 2026. Why does this bill wipe the board completely clean instead of staggering the turnover so that not all the appointments are made at the same time?
So, Representative Wu, I think why I'm taking issue with your line of questioning is because the bill is very simple. You have clearly not read the JR, and there are other members that want to ask questions who have read the JR. And what I would suggest, if you're willing to do, is to go sit at your desk, read the JR, and come back to the mic if you have questions about specific provisions of the bill. I am not going to waste the body's time engaging in a political debate with you about your feelings, personal or political, regarding Governor Abbott.
Okay. With the 7 seats that are for lay members, What vetting will prevent political influence or activists from turning public membership into a partisan echo chamber?
I've answered your questions, Representative Wu.
I'm sorry?
I've answered your questions.
Okay. The existing bar on commissioners hailing from the same Court of Appeals district has been stricken from the bill.
Gentleman's time has expired.
Thank you.
For what?
The following amendment, the clerk will read the amendment.
Amendment by Leach.
Mr. Leach to explain the amendment.
Thank you, Mr. Speaker. Members, this amendment addresses concerns brought to us with the language of the committee substitute. First, the amendment clarifies that the 6 individuals appointed by the Supreme Court might be or must be a judge or justice. Second, the amendment reorganizes Section 1 of the bill so that the bill language flows correctly. And third, the amendment in front of you adds language in the temporary provision of the bill to provide a transition window of a 6-month phase-out to address existing complaints and commissioners to help ensure an easier transition and to mitigate any potential backlog. I move adoption of the amendment.
Ms. Gervin Hawkins, for what purpose?
Will the gentleman yield for a couple questions?
Yes, I'd be glad to.
The gentleman yields.
Thank you, Representative Leach. I just want to be clear. Today, the governor appoints the members of the commission without Senate approval. What this does, this HJR, it says that the governor now has to get the Senate's approval.
That's not accurate.
Okay,
They all receive
help me
Senate.
understand.
They receive, it's the same process. They receive consent and approval by the Texas Senate today.
Awesome. Does your amendment speaks to a jurisdictional spread? So can we say that all these members, say, would come from Austin, or do it address that at all in terms of being more statewide so we can have representation across the state? Does it address that at all?
That's a great question, Representative Gervin Hawkins. The bill does not speak to the geographical location of the who would be appointed to serve on the commission. I can't imagine that they're all going to be from one location, whether it's Austin or Dallas or Houston. They will be, as they are now, spread out across the state. But there is no geographical restriction or requirement in the JR in front of you.
And it doesn't address any type of specialization and/or demographic profile. It's just who it has to be a judge or a justice that applies. Is selected, interviewed and selected, I'm assuming.
They don't apply. They don't fill out an application.
Oh, they're appointed.
They're appointed. Right.
Okay, thank you for that. And so they're appointed, and then once they're appointed, they get Senate confirmation. Senate confirmation. I kept reading in there that it was a Senate approval.
That's correct.
Okay. And so, based on your knowledge of this process, would you say that the justices that have been selected, or do you know, you may not even be advised, have they been across the state of Texas? I'm looking at the historical context.
Yes, and I do know, the committee that I serve as chair on, we have jurisdiction over the State Commission on Judicial Conduct and have worked very well with them in the past. This chair in front of you now, in front of the body now, is meant to strengthen the JR and so, but yes, if you look at the commissioners now, I don't have a list, but there's a good spread of geographical representation from across the state.
Thank you, Representative, for answering my question.
Thank you so much. Move adoption of the amendment.
Mr. Leach sends up an amendment. The amendment is acceptable to the author. However, a record vote has been requested. The clerk will ring the bell. Show Ms. Holt voting aye. Show Mr. Little voting aye. Show Mr. Leach voting aye. Have all voted. Show Mr. King voting aye. Have all voted. There being 118 ayes, 20 nays, the amendment is adopted. Anyone wishing to speak on, for, against SJR 27? Mr. Wu? The chair recognizes Mr. Wu in opposition to the resolution.
Thank you, members. I want y'all to pay attention to this, because this is what we were afraid of when we created this commission last time, that this would be used as a political tool in the future, that we would turn this into a political toy, that in the past, the way the law is currently written, you have provisions for a number of people to be on this committee, to be on this commission that represents a broad swath of judiciary. You would have members of the bar, selected by the bar. You would have one person from the district court, one person from an appellate court, and people picked by the Supreme Court, people picked by other places. And instead now, we're taking all that, throwing it out the window, and we're saying, well, we're just going to let the governor pick the majority of the commissioners. Here is the problem. If you have talked to your judges, and I guess this really only applies to Democratic judges because they're only going after Democratic judges. If you talk to your judges back in your hometowns, you talk to the judges in Harris County and Dallas, what they will tell you is Democratic judges face more ethical complaints, more scrutiny for doing the exact same thing as every other judge. That every little step that they take is being watched like a hawk, and that the slightest thing, people file complaints on them, people use this to go after them, and they are deadly afraid of making any comments, making rulings, whatever it is. This has been brought to my attention again and again by our local judiciary. This is the culmination of that. This is the point. This is the point, to take a separate branch of government that is supposed to be independent, that is supposed to be independent from us, supposed to be independent from the executive branch, and say you are now beholden to both. That you now are going to be overseen by people who are handpicked by the legislature and by the governor. This is very dangerous.
Mr. Speaker.
And if
Mr. Leach, for what purpose?
Will the gentleman yield for question?
I do not yield. Not to you.
The gentleman doesn't yield.
And this is a dangerous path for all of us. That we continuously take things that are not supposed to be political and we're making them political. Judicial branch, their oath of office, their ethical obligations under their rules tell them that they're not supposed to be political, they're not supposed to do all these things, they're supposed to stay out of this arena. And they absolutely try to do that as the best of their abilities. If you ever try to campaign with judges, you go to events and then they talk, and you say, well, why aren't you being a little harder on that issue? Why aren't you talking more about this or that? And the judges have to tell you, that's part of our ethics. All judges are forbidden from taking political stances and doing those kind of things because they're not supposed to, because they're supposed to be judges, they're supposed to be impartial. But here we are interjecting politics into it, giving the governor more and more power. How many times this session have we amended commissions, changed committees, and done all these things to hand increasingly more power to a single individual? Power that used to belong to us, power that used to belong to the courts, to the bar, to the Supreme Court. And it keeps happening. One day, it will come back to bite us. I urge you to vote no on SJR 27.
Mr. Speaker,
Mr. Leach, for
will the
what
gentleman
purpose?
yield for questions?
The gentleman does not yield. The chair recognizes Mr. Little for the bill.
Thank you, Mr. Speaker. Members, I had not planned to speak on this. I had not planned to speak on this Senate joint resolution today, but what I want to take a little bit of time to tell you a personal anecdote as a practicing lawyer, and a reason that you should very carefully consider voting in favor of this bill. Several years ago, I submitted several years ago, I myself submitted a complaint to the State Commission on Judicial Conduct. I'm not going to say what county this district judge was in, but this district judge had placed a shock belt, if you know what a shock belt is, on a defendant to control his conduct while he was in the courtroom, and had administered very painful shocks repeatedly to this defendant. I submitted a complaint to the State Commission on Judicial Conduct. 3 years later, I got a letter to my house that said, "Thank you for your complaint. We're looking into it." That was it. We have a process on the State Commission for Judicial Conduct that is not working. It is itself now a star chamber. There is no way to know what is going on inside that commission, and there is no way for you to actually have some accountability about the decisions that commission is making. SJR 27 introduces some very needed reforms. And for those of you who are concerned this is a Republican power grab, it is most certainly not. If you take a look at who would be appointed to this commission, 6 of the individuals will be appointed by the Texas Supreme Court. They're going to be jurists, judges at all different levels. And then if you're concerned about who the governor is going to appoint, well, there are appointments already being made to the State Commission on Judicial Conduct. The concern is that the work product that is coming out of the State Commission on Judicial Conduct is not what it should be. Oftentimes, we have complaints that are going unresolved for extended periods of time, and judges are not facing discipline for things that they do that are wrong. In the Dallas-Fort Worth area, we had a judge who violently choked and kicked his girlfriend out of his car while it was moving. It goes to a complaint process, and that complaint process is completely obscured from the public. There is no public accountability. It's not a meaningful system now. We have Representative Janice Hull, who before she served in the chamber, she served on the State Commission on Judicial Conduct. Our current Court of Criminal Appeals Judge, David Shank, also served on the State Commission on Judicial Conduct. The reports back from those who have served are that the process is simply not working, and SJR 27, I believe, represents some very meaningful and needed reforms.
Mr. Speaker?
Mr. Dutton, for what purpose?
Will the gentleman yield for a question?
I certainly will.
The gentleman yields.
Thank you. How many members are on this commission?
Currently 13, I believe. Yes, 13.
13. I guess my concern was I looked through the bill, and I wondered, do we need a DEI amendment on here?
I don't know what you mean.
Well, I didn't think so.
I'm sorry. Thank you, Representative Dutton.
The chair recognizes Ms. Holt in favor of the resolution.
Thank you, Mr. Speaker and members. I rise today not only as a legislator, but as someone who has held the solemn responsibility of serving on the State Commission on Judicial Conduct. That experience gave me a front row seat to the strengths and the shortcomings of our current system of judicial accountability. And it's from that perspective that I speak in support of SJR 27. This bill is not just a set of procedural tweaks. It's a bold, necessary step toward restoring public trust in our judiciary by ensuring that judges are held to the highest standards of integrity, transparency, and timeliness. Let me be clear, the vast majority of Texas judges serve honorably, but when misconduct does occur, the public deserves a system that is swift, fair, and visible. This bill delivers on that promise. It imposes clear timelines for how courts must handle motions for summary judgment. As someone who has received complaints stemming from judicial inaction, I can tell you delay is not a neutral act. It erodes confidence, it harms litigants, and it must be addressed. Secondly, this bill strengthens the Commission's ability to act decisively. It defines willful or persistent conduct with clarity. It empowers the Commission to impose administrative penalties for knowingly false complaints, protecting judges from abuse while preserving the public's right to be heard. Third, and perhaps most importantly, it brings sunlight to a process that too often operated in the shadows. By requiring public notice of certain reprimands, by mandating annual reports on judicial performance, and by creating a statewide judicial directory, we are making the system more transparent, more accountable, and more accessible to the people it serves. Colleagues, this bill reflects the lessons I learned on the Commission. that accountability and fairness are not in conflict, they are partners. That transparency is not a threat to judicial independence, it is its foundation. Let's pass this bill not just as
Mr. Speaker?
not just
Ms.
as
Gervin
lawmakers.
Hawkins, for what purpose?
In just a moment.
Not at this time.
Let us pass this bill not just as lawmakers, but as stewards of justice. Let us send a message to every Texan that their courts are worthy of their trust. Thank you, Mr. Speaker, and I yield for questions.
Ms. Gervin Hawkins, for what purpose?
Will the gentlelady yield for questions?
The lady yields.
Thank you, Representative Holt. Your service was as a justice or a judge?
No, ma'am. I was a public member for 5 years.
So you're a public member. So this bill or amendment doesn't eliminate public members?
No, ma'am, it does not.
So it just add of how the judges will be.
It adds one more public member to the commission.
And so your service allow.
Excuse me, 2 more. It's 7 public members and 6 judges.
Awesome. So your service offered that external insight.
Yes, ma'am. We were assigned to view it from the public's perspective and to listen to the complaints accordingly.
So the demographics of the 13 members, could you share that with us?
Yes, ma'am. They strove in every instance to spread it out across the state of Texas according to districts, you know, so that only 1 per district judge. It didn't always work out that way because of just the availability of people, but that was the intent behind the appointments.
Right, but my specific question is, the demographics when you served was what? Gender-wise, ethnicity-wise,
I'm
and
sorry, I
statewide?
misunderstood your question. No, ma'am. I do not work in the governor's appointment office, so I cannot answer to that. I'm sorry.
So y'all didn't come together for meetings?
Yes, ma'am, we did.
So
Yes, I'm
what
from
did
the
you see?
Southeast Texas regions where I'm from.
So what did you see when you saw all the members coming together, all 13?
I'm sorry, clarity?
When all the members came together, what was the demographic breakdown? Or you never
Are you
saw...
asking male, female, black, white? Is that what you're asking
Yes,
me?
yes, ma'am.
Well, it's hard to pin it down because people were coming in and off of the commission. I would have to say it was predominantly male. And then the demographics as far as race, we've had Hispanic members, we've had African American members, Anglo members. I believe those are the 3 ethnic demographics that, since I was on the commission.
So you're not advised until at any one time what that body looked like?
Well, yes, ma'am. I can tell you what it looked like while I was on the commission, which was from 2019 until December of this past year. In 2024, I resigned to join this body. And how many females? When I got off the commission, there were 3 females out of 13.
Thank you for answering my question,
Yes, ma'am.
Representative Holt.
My pleasure.
Mr. Speaker.
Ms. Flores, for what purpose?
Would the gentlelady yield, or perhaps my questions would be better reserved for the author when he closes? Would I have an opportunity to do that?
Yes, ma'am.
So I should wait? Okay, so thank you.
The chair recognizes Mr. Leach to close on the bill, on the resolution.
Thank you, Mr. Speaker. Members, to address Representative Wood's comments, Representative Wu's comments, I encourage you not to be hoodwinked and led astray by someone who has not read the bill and has no idea what they're talking about. Representative Wu stood up here and said that we created this commission last session, and in fact, this commission has been established since 1965. And regularly, the legislature tweaks how the commissioners are appointed, what their jurisdiction is, what their authority is, and that's all we're doing here. Members, I haven't spoken to the governor or the governor's team about this. I've spoken with Senator Huffman, who drafted this. I've spoken with other senators, Republican and Democrat, in the Senate, where this bill was voted out 27-4, who are in support of this. This JR in front of you now is not partisan. This strengthens the judiciary. The Supreme Court members I've talked to, the other judges across the state at all levels are in support of this. And so, members, just don't be led astray by someone who has not read the bill and simply put, has no idea what they're talking about.
Mr. Speaker?
And is just reading talking points, giving them to
Ms. Flores,
giving them by someone else.
Will the gentleman yield
Yes.
for a question?
Yes.
Thank
Gentleman
you.
yields.
Speaking to that point, Chairman Leach, I got confused with the dialogue, and then I think you read some provisions in the committee substitute that
Right.
made some changes. What is the status of the State Bar of Texas appointees? Can you clarify that for me? Because I got a little
Yeah,
confused.
so there are no State Bar of Texas appointees. They're appointed by the Supreme Court and by the governor, 6 and 7.
But there used to be State Bar of Texas appointees, correct?
Yes.
And those are no longer, and
Correct.
they normally appoint the public members, or who is in charge?
I'm not aware of that. I don't have the answer to that.
Okay, so now the governor has 7 and the court has 6. Okay, so, okay, well, that clarifies it for me. I'm a strong believer in the separation of powers
I am
and
too.
Supreme Court having power, and I realize, I agree with the public member, Representative Holt, in that transparency and making sure that it's efficient and that it works well, and changes are obviously needed, but I'm a little bit concerned about the imbalance of that power and giving more authority to the governor to appoint more appointees than the Supreme Court. So I'm really.
Well, again, even right now, Representative Flores, and you've sat on our committee, you've heard the testimony, we've talked extensively about this. Even right now, the Senate has consent power over the nominations to the State Commission on Judicial Conduct. As much as sometimes I might disagree with senators or wish they treated my own legislation differently, I trust our senators on this, all 31 of them, to review the candidates to the State Commission on Judicial Conduct and to get them right. And so, again, this is not partisan. It should not be partisan. It's not partisan to me. I don't know why it is to Representative Wu, but that's the first complaint I've heard from him reading off someone else's talking points. The JR is very straightforward. I believe this strengthens the judiciary. It serves the people of Texas well, and I would hope to have your favorable consideration and support.
Well, thank you for answering my question. I'm going to have to really think hard about this.
Thank you.
Now, I get it that the legislature is having, the Senate has confirmation authority, so that brings in a third branch of government into it. So, and I know that I worked at the State Bar a long time, and there was comedy between the court and the legislature and how the State Bar, which is part of the judicial branch, was, worked. So I agree that there should be balance and sometimes tension between the branches of government.
I don't disagree with that at all. I think that's well said. And maybe what this does is it creates some tension. That yes, there are separate co-equal branches of government, but in all cases, the branches can and should hold. If there's another branch of government that is usurping the rights of the people and/or willfully neglecting their duties and not serving the people of Texas and not doing their job and not showing up for work, then there ought to be guardrails in place to hold those people accountable, whether it's executive, legislative, or judicial, and that's what this JR does. And remember that the people of Texas still have to vote on this in a constitutional amendment, the statewide proposition election in November.
That is true. I do have some concerns about partisanship because obviously certain branches are a certain party, and that's a concern for some folks. But maybe the tides will change and things will be different. But nevertheless, I'll reserve my right to
Thank you.
To breathe before I press
Thanks,
my button.
Representative Flores. Appreciate you.
Mr. Speaker,
Ms. Gonzalez, for what purpose?
does the gentleman yield?
Will the gentleman yield for questions?
Yes.
The gentleman yields.
There is a clear indicator that we need to make sure our judicial system works very functionally and effectively and fairly. Is that correct?
Yes.
My only ask is that if you're going to get up there and ask members to vote for a bill, that you don't say something like, that we should not be hoodwinked by another member that said who didn't read the bill. I don't think being offensive to another member of our colleagues is helpful to this conversation, and my ask is that you stop saying those words, because you've said them 3 times already from that front mic.
Thank you, Representative Gonzalez.
Mr. Dutton, for what purpose?
Would the gentleman...
The gentleman yield for questions.
For questions, yeah, thank you.
Yes.
I know that's not the subject of this bill, but we have been for some time trying to increase judiciary pay. And does this bill
Go ahead, sorry.
Does the passage of this bill in any way relate to that?
No, there's nothing, there's no judicial compensation aspect to the JR in front of you now.
In front of-
There are other bills that we will hear today that will deal with judicial compensation and accountability.
And so they're not, those bills aren't tied to this bill either directly or indirectly?
I'm hopeful that this JR will pass so that our Senate counterparts will take our judicial compensation proposals seriously and work collaboratively with us to deliver on both.
All right, thank you.
Mr. Speaker, will the gentleman yield for questions?
Yes.
The gentleman yields.
Yes.
Thank you, Chairman Leach. I did want to go through a couple of things, and kind of like Representative Little said, as lawyers, some of us are familiar with Judicial Conduct Commission. Just to clarify, currently there are, as we've heard, there are public members already on the commission doing evaluations of our judiciary.
Correct.
And in this section, one of the things that seems to me is the definition that the judge is engaging in willful or persistent conduct that's clearly inconsistent with the proper performance of a judge's duties and or other good cause, the commission effectively can issue a public reprimand. Is that right?
Yes.
But it looks to me like every judge is given one chance that if they have not engaged in that conduct or actually been before the commission, there's still the opportunity for a private reprimand or the ability to go through training or whatever things. So am I correct that this bill is not a public gotcha in all circumstances?
No, it's not a public gotcha. This is now look. There are some judges, Representative Johnson, as you know full well, that need to be got. That need to have a public reprimand from the Commission on Judicial Conduct. But there is an opportunity for a private. I would say reprimand may be too strong of a word. It may be a course correction if the Commission determines that there's a judge that needs.
And that could still be private.
Correct.
Right.
One
So
time.
if the commission and the membership of the commission finds that this judge is in a situation where they want to work through something with them, and there's the ability for them to be able to maintain and continue the functioning of the position, that does not have to be put in a public setting.
Say that again, Representative Johnson. I'm sorry.
Again, I just want to clarify that one of the things I had heard at some point about this legislation was that everything was going to become public. And I want to make sure that I'm reading this right, that is not accurate. There's still the opportunity for some private action, which may be appropriate in many circumstances,
So
correct?
if you look at the, if you look at page 1 of the JR, lines 14 through, I mean, it's really lines 9 through 16, but specifically line 14 relating to the order of private admonition.
Okay.
And so
And then-
I think that's the legalese, but I think of it more as a course correction privately. Because, Representative Johnson, if there is a judge that needs to be publicly reprimanded that is intentionally not doing their duty or has willful neglect of their duty or something more egregious than that, then the public ought to know. The public ought to know, and I believe the people of Texas have a right to know, just
And-
like they do about the legislative and the executive. That is true for the judicial branch as well.
And this bill still maintains those levels of, if you will, due process
Yes.
for the judge, for all the appropriate parties to do that review.
Yes, 100%. Yes.
Thank
The gentleman's time has expired.
Thank you, Mr. Speaker. Members, I move passage of SJR 27.
Members, strict enforcement has been requested on all SJRs. Members must vote from your desks, and you cannot vote for any other member. The question occurs on the adoption of SJR 27. This is a record vote. The clerk will ring the bell. There being 97 ayes, 33 nays, The resolution passes to third reading. Mr. Leach. The chair lays out SB 552 as a matter of postponed business on second reading. The clerk will read the bill.
SB number 552 by Huffman relating to changing the eligibility of certain persons to receive community supervision, including deferred adjudication community supervision.
The chair recognizes Mr. Leach for a motion.
Thank you, Mr. Speaker. Members, I move to postpone further consideration of Senate Bill 552 until 9 a.m. Monday, May 26th.
Members, you've heard the motion. Is there objection? The chair hears none, so ordered.
Chair lays out Senate Bill 835. Clerk will read the bill.
SB number 835 by Paxton relating to the enforceability of certain non-disclosure or confidentiality provisions with respect to an act of sexual abuse committed against a child.
Chair recognizes Mr. Leach.
Thank you, Mr. Speaker. Members, shifting gears, appropriately so. It is my tremendous honor to lay out before you Senate Bill 835, Trey's Law. Members, over a month ago in April, I stood on this floor with many of you and told you the story of Trey Carlock and of Cindy Clemshire and how their stories inspired House Bill 748 and Senate Bill 835, which has the identical language of House Bill 748. Many of you stood with me. We stood together and we voted unanimously in this body to prohibit the use of non-disclosure and confidentiality agreements in civil settlements for sexual abuse, regardless of whether or not the victim is a child, to the extent that it would prohibit a victim from speaking out about an act of sexual abuse or any facts related to those acts. Members, I know we've got a lot going on and we've got a busy calendar today. I'm asking you, you can stay seated if you want, but I'm asking you to stand with me again, to stand with victims, with survivors, to bring the darkness into the light, and to prohibit anyone from hiding behind one of these egregious, awful, I believe evil agreements ever again in the state of Texas. It does not matter if this is a House bill or a Senate bill. It doesn't matter if we have to vote on it 100 times. It's critical that we pass this legislation, and that's what we're about to do, so that this becomes the public policy of this state. And I believe you're with me on this, will never stop fighting to protect survivors, to be the voice for the voiceless. We cannot back down now, and we will not back down ever. I believe, members, that this bill that I've worked with many of you on, Representative Meyer, Little, and Johnson, David Cook, so many of you, our Senate author, Senator Paxton, and Lieutenant Governor Patrick, and our Speaker, Speaker Burrows, who has made this a cause of this House this session. I believe very strongly that this bill that we're about to vote on is one of the, if not the strongest bill for sexual abuse survivors and victims anywhere in this country. And with that, Mr. Speaker, I proudly move passage of Senate Bill 835, Trey's Law.
Members, the question occurs on passage third reading. I'll give you time to vote from your desks. Record vote. Clerk, ring the bell. Show the Speaker voting aye. Mr. Anchia voting aye. Mr. Leach voting aye. Have all members voted? Have all members voted? There being 144 ayes and 0 nays, Senate Bill 835 passed third reading. Chair recognizes Mr. Anchia for recognition.
Thank you, Mr. Speaker and members. It is my extreme good fortune to welcome to the House Gallery today a really, really good, close, and longtime friend, Stephanie Fung, her son Jasper, and her parents who have joined us in the Capitol. If you could please rise and be welcomed to your Texas House of Representatives. Thank you, Mr. Speaker and members.
Chair lays out Senate Bill 3070. Clerk, read the bill.
SB number 3070 by Hull, relating to the abolishment of the Texas Lottery Commission and the transfer of the administration of the state lottery and the licensing and regulation of charitable bingo to the Texas Commission of Licensing and Regulation, creating a criminal offense.
Mr. Guerin for a motion.
Thank you, Mr. Speaker. Members, I move to postpone for further consideration SB 3070 until 5 p.m. today.
Members, you've heard the motion. Is there any objection? Chair is none, so ordered.
Chair recognizes Mr. Gates for a motion.
Mr. Speaker, I move the House grant permission for the Committee on Land and Resource Management to meet while the House is in session today at 4 p.m. in room 1W14 Ag Museum to consider pending referred and committee business.
Members, you've heard the motion. Is there objection to the adoption of the motion? Chair is on. The motion is adopted. Following announcement, the clerk will read the announcement.
The Committee on Land and Resource Management will meet today at 4 p.m. in room 1W.14 Agricultural Museum in a formal meeting to consider pending referred and committee business.
Chair recognizes Mr. Metcalf for a motion.
Thank you, Mr. Speaker. Members, I move to suspend House Rule 8, Section 5D for SB 22 to designate the following members as joint sponsors: Martinez, Fisher, Cole.
Members, you've heard the motion. Is there objection to the adoption of the motion? The chair is on. The motion is adopted. Chair lays out on second reading Senate Bill 22. The clerk will read the bill.
SB number 22 by Huffman, relating to the Texas Moving Image Industry Incentive Program and the establishment and funding of the Texas Moving Imagery Industry Incentive Fund.
Chair recognizes Mr. Hunter for a motion.
Mr. Speaker, I move to postpone further consideration of SB 22 until 6 p.m. today.
Members, you've heard the motion. Is there objection to the adoption of the motion? The chair is on. The motion is adopted. Chair lays out on second reading Senate Joint Resolution 59. The clerk will read the resolution.
SJR number 59 by Birdwell, proposing a constitutional amendment providing for the creation on funds to support the capital needs of educational programs offered by the Texas State Technical College system and repealing the limitation on the allocation to that system and its campuses of the annual appropriation of certain constitutionally dedicated funding for public institutions of higher education.
Chair recognizes Mr. Lambert.
Thank you, Mr. Speaker. Members, this is the endowment for Texas State Technical College. You might remember that earlier this session we passed a similar resolution to fund TSTC's long-term strategic growth. However, as higher education funding has come together, we've determined that we can fund this growth more efficiently. I can get into more detail with my amendment.
Ms. Gervin Hawkins, for what purpose?
Mr. Speaker, will the gentleman yield for questions?
Gentleman, yield for questions.
I'd be happy to. If you'd let me pass the amendment or speak to the amendment, then I think it might answer a few questions.
I will let you do.
All right.
All
Thank
right.
you, Representative.
Not at this time. The following. Full transparency, Ms. Gervin Hawkins, once the amendment is laid out, he will not be able to answer questions until he closes.
Well,
Is that
then
okay?
he need to answer my questions right now.
Oh, okay. Does the gentleman yield for questions?
I yield for questions.
The gentleman yields for questions right now.
Thank you, Representative Lambert. So this is an endowment created. How much is that endowment?
The endowment is $850 million.
$850 million. And with that $850 million, the Texas State Technical College will be able to have some dollars to do what? What will the funds be spent on?
The money will be used to expand campuses, some of the existing, as well as new campus locations across the state to provide more programs for more workforce education.
So we as a body do fund our technical colleges for bricks and mortar projects as well as programming, correct?
That is what the intent of this resolution is for.
And so if we bring forth the historically black colleges for this same thing, you're going to vote on it?
I'm not aware of a bill that's going to be addressing that, but I'll certainly look at it.
But when that bill comes forward, you will be immensely supportive of it, correct?
I will be very open-minded to looking at the bill and see how it can expand our workforce. Yes, ma'am.
Thank you, classmate. I appreciate that.
Yes, ma'am.
The following amendment, the clerk will read the amendment.
Amendment by Lambert.
Chair recognizes Mr. Lambert on the amendment.
Thank you, Mr. Speaker. This amendment does a few things. First, it adds a $52 million limit on total capital appropriation between HEF and endowment, or HEAF, as many of you refer to it. Excess funds are routed back to general revenue. Second, it adds an inflationary adjustment to the distribution limit. And finally, it removes Section 4, which repealed the 2.2% HEAF cap for TSTC, and it now keeps that cap in place. With this amendment, we ensure TSTC has adequate funding to achieve the long-term growth required to address the growing need for a skilled workforce in Texas while guaranteeing that we are not overspending. I move adoption.
Mr. Lambert sends up an amendment. The amendment is acceptable to the author. A record vote has been requested on the amendment. The clerk will ring the bell. Show Ms. Harris-Davila voting aye, Mr. Lambert voting aye, Mr. Curry voting aye, Mr. Patterson voting aye, Mr. Shaheen voting aye. Have all members voted? Have all members voted? There being 133 ayes, 6 nays, the amendment is adopted. The chair recognizes Mr. Lambert to close.
Thank you, Mr. Speaker. TSTC is one of the great success stories in our state. Their efficiency and responsiveness to market demands make them more than worthy of our investment. Move passage.
Members, strict enforcement has been requested on all SJRs. Members must vote from your desk, and you cannot vote for any other member. The question occurs on the adoption of Senate Joint Resolution 59. This is a record vote required by the Constitution. The clerk will ring the bell. Have all members voted? Oh. Show Mr. Harris voting aye. Nope, that's right. Never mind. Harris, you got to push your button. Have all members voted? Have all members voted? There being 110 ayes, 16 nays, Senate Joint Resolution 59 is adopted. The chair lays out on second reading Senate Bill 25. The clerk will read the bill.
SB number 25 by Colcourse relating to the health and nutrition standards to promote healthy living.
Chair recognizes Ms. Hull.
Mr. Speaker,
Mr. Canales, for what purpose?
I'd like to raise a point of order against further consideration of Senate Bill 25 under Rule 4, Section 32C1 of the House Rules on the background and purpose is substantially material misleading.
Please bring your point of order down front.
Point of order has been withdrawn. Mr. Canales, for what purpose?
Mr. Speaker, I raise a point of further consideration against SB 25 under Rule 8, Section 1A1 of the rules, House rules, on the grounds that it fails to give reasonable notice of the subject to the bill.
Bring your point of order down front.
The point of order has been withdrawn.
Mr. Speaker,
Mr. Canales, for what purpose?
I raise a point of order on the proposed under House Rule 4, Section 32C3, in that the bill analysis incorrectly states that rulemaking authority is delegated in the bill.
Mr. Canales, please bring your point of order down front. The point of order is withdrawn. Chair recognizes Ms. Holt.
Thank you, Mr. Speaker. Members, I am so excited to be laying out SB 25 today, and I am so proud to partner with Senator Kolkhorst on this bill. This is something that has been a passion of mine for nearly 2 decades. Becoming a mom to my son has only fueled me to want to make Texas and this country healthier for the generations to come. In 2014, the U.S. life expectancy peaked at 78.9 years. We are now experiencing the sharpest decline in more than a century. In countries like Spain and Switzerland, the average lifespan is 5 years longer than Americans, and the Canadians will outlive us by 3 years, despite significantly less healthcare costs per person. The U.S. ranks 60th in average lifespan, and of course, first in healthcare spending. In the U.S., we spend $4.5 trillion annually on healthcare, with 90% of those expenditures on chronic and mental health conditions. For comparison, the food industry grosses $1.46 trillion, with 45% of that as gross profit. There is a 79% increase in early onset cancers for Americans under 50 and a drastic increase in heart and liver related diseases. 42% of adults and 20% of children are obese, compared to 5% in the 1960s. On Thursday, President Trump read findings of the MAHA Commission that show more than 40% of children have a chronic condition, and childhood cancer is soaring by over 50% since the 1970s. According to the CDC, 1 in 3 Americans aged 17 to 24 are ineligible to serve in the military due to their weight. This is now a national security problem. We hear these statistics and continue spending money to prescribe medications to treat chronic illness and obesity instead of combating the causes. Recent studies have shown the link between an increased ultra-processed foods diet and an increased risk of early mortality, and links to depression, obesity, type 2 diabetes, cancer, and cardiovascular disease. Ultra-processed foods are 73% of the U.S. food supply and 52% cheaper than minimally processed alternatives. But that doesn't include the healthcare spending, lost productivity, and societal effects of disease. For those who have traveled abroad, you know that in many other countries, the food doesn't lead to weight gain or the same digestive issues that plague so many Americans. In other countries with socialized healthcare, they require rigorous testing to permit food additives because those governments know that they will pay for the long-term health consequences. If anyone has looked at our state and federal budgets lately, you'll see that we are also paying to treat chronic disease caused in part by our food in both Medicaid and Medicare. Currently, we don't permit food additives. Instead, for decades, we allow food manufacturers to self-report, to self-certify the safety of their food additives as generally recognized as safe or GRAS. It's a true situation of the fox guarding the henhouse. Some of these manufacturers also own pharmacies or want to become Medicaid providers so they can sell you the food and profit off the health conditions they cause, all on the taxpayer's dime. For decades, DC has been lobbied to prevent real change in our food system. As I'm sure you're all aware, the lobby has picked up and moved to Austin, and you've probably met them all right outside those doors. We should probably rename this bill the Lobby Employment Act of 2025. Entire associations have formed against this bill because Big Food doesn't want to inform consumers. Just like decades ago, Big Tobacco didn't want warning labels either. I'm sure you've all seen the opposition letter with tons of Big Food labels on it, simply fighting transparency. This truly is a David versus Goliath. This is about the average Texan in the grocery store wanting to make healthy choices against a multi-trillion-dollar industry. Members, we need to break the system and address chronic disease. Here's how this bill will help do that. Number one, by establishing a nutrition advisory council with a focus on metabolic health, functional medicine, and chronic disease. Number two, requiring daily PE and prohibits the removal of recess and PE for disciplinary reasons and returns middle school PE to 3 years with a new exemption allowing for middle school opt-out of PE for out-of-school activities. Number three, it updates health curriculum for K through 8 to include nutrition instruction and creates a high school elective in nutrition and wellness. Number four, requiring updated nutrition training for all Texas physicians, PAs, nurses, dietitians, medical residents, and medical students. And number five, as I'm sure you have all heard, requiring food labels to inform and empower consumers about certain ingredients not recommended for human consumption in other Western countries so that we can be informed about the food choices we are making. People assume because it's on a shelf in the grocery store that it's safe to eat. There is a drastic difference in what is produced to sell to Americans and what is sold in other countries by the exact same companies. Canadian cereals and British ketchup have entirely different ingredient lists than the American versions because other countries have determined that these products aren't safe to eat and are linked to chronic disease. Texans deserve to at least know what the products they're buying. Texans deserve to at least know that about the products that they're buying for their children. So manufacturers have a choice to label it or remove it. This bill is not a ban. They have complied with other countries' outright bans and warning labels on the very same products they sell to us here. I am proud to partner with Senator Kolkhorst to make Texas healthy again. Together, we are two moms on a mission who want Texas to lead the way for the nation on combating chronic disease. This is a bipartisan problem that needs a bipartisan solution, which is why this bill passed the Senate 31-0, with Democrats and Republicans giving emotional and moving speeches on the floor. Every single senator loved this bill. This is about the Maha parents and the crunchy granola parents coming together to say we are sick and tired of being sick and tired. This is Republicans and Democrats coming together for Texas kids. With this bill, Texas will lead the nation. Other states and the feds are looking to us to see Texas get this done and inspire positive change across the nation. I have personally spoken to the White House, who said they are looking to us, to Texas, to get this done, to stand for our children and our future.
Mr. Speaker,
Ms. Isaac, for what purpose?
does the lady yield for questions?
Yes, I yield.
The gentlelady yields for questions.
Representative Hall, would you agree that improving children's physical activity and nutrition is not just a health issue, but is also an educational and an economic one for our state?
Yes, I do agree with that.
Is it fair to say that many of our current health challenges, like childhood obesity and rising diabetes rates, are preventable through better habits established early in life?
Yes, exactly.
Does this bill help ensure that Texas students receive meaningful education in nutrition rather than relying solely on reactive treatment after disease has taken hold?
Yes, that is the entire goal. Yes.
Prevention.
Yes, prevention.
Would you agree that transparency in food labeling empowers parents and consumers to make better decisions for their families?
Absolutely. This is pro-consumer, transparency, and more information for Texans.
Are the nutrition guidelines developed under this bill based on scientific consensus and free from the industry influence?
Yes, and that is the entire goal of this bill.
Would you agree that training medical professionals in nutrition and metabolic health fills a major gap in how we currently approach chronic disease?
Yes, I would agree with that.
Are you aware that many countries, I believe you already said this, but already ban or label some of the ingredients this bill targets, yet U.S. consumers often remain uninformed.
Yes, that is completely accurate. The food that the same manufacturers make for U.S. is very different than what they make for Canada, UK, etc.
Would you agree that a healthier Texas workforce starts with healthier Texas schools?
Absolutely, yes.
Would you also agree that this bill advances both personal responsibility and fiscal responsibility?
The gentlelady's time has expired. The following amendment, the clerk will read the amendment.
Amendment by Hull.
Chair recognizes Ms. Hull.
Thank you, Mr. Speaker. Members, this amendment, we have made many changes to this bill already. We narrowed the health majors required to take the nutrition curriculum, changed the required high school course to an elective, created an exemption for middle school PE, created defined lists of ingredients, removed items from the list, delayed the implementation 2 years, and required the labeling only of labels designed after 2027, so no products would be pulled from the shelves. This list currently has 52 items that is based on over 200 ingredients that HEB has created on their own select ingredients list, and concerning ingredients that they have removed from their line of products with the green check mark. Senator Kolkhorst took several amendments for HEB on the Senate floor. We made additional changes in the committee sub, and I am making several additional changes at their request and at the request of Blue Bell and many others. This amendment addresses the infamous Section 9 of the bill, the labeling requirements. It clarifies that the bill is only required for items that are disclosed as an ingredient. For those who don't know, titanium dioxide, a whitening agent, isn't required to be disclosed in dairy products. It is a whitening agent that is used for low-fat dairy products. This is another example of a successful DC lobby effort. So titanium dioxide and any other products like pesticides that is not listed as an ingredient will not have to be labeled. It also explicitly exempts products with alcohol, prescription and over-the-counter drugs and dietary supplements, and pesticides or chemicals used in agriculture, which also wouldn't have to be disclosed as they aren't an ingredient. Finally, it removes ACE-K, aspartame, high fructose corn syrup, potassium sorbate, saccharin, and vanillin from the list. Let me be clear.
Mr. Speaker,
Ms. Gervin Hawkins, for what purpose?
would the gentleman yield for questions?
When I'm done.
Not at this time.
Let me be clear. These are still bad for your health, but the removal of these items comes from many meetings and conversations with stakeholders who still don't want the bill, but we are working with them anyway. I appreciate that Blue Bell is already working to remove many of these ingredients from their products, and of course, HEB already doesn't include any of these in their select green check mark products.
Mr. Speaker,
Ms. Gervin Hawkins, for what purpose?
will the gentlelady yield for questions?
Yes.
The gentlelady yields for questions.
Thank you, Representative Hall. I'm glad to hear that your amendment fixed some of the challenges that our stores have shared with you. So when you say that you're working with it and through, are you postponing your bill, or you're saying that?
No, my amendment is doing this, and then there's going to be 2 amendments to the amendment.
To work on this?
Yes.
So my question is, and I may have missed this, in doing this amendment and the bill, was your goal to create a more healthy eating environment?
Yes.
You know the bill, would you agree that is wide-reaching?
Wide-reaching as far as the labeling?
The labeling, as well as, I mean, we're talking public schools, we're talking about grocery stores. I mean, there's just so many moving pieces. So to me, that's wide-reaching when you engage so many entities in one bill.
Okay.
And so the goal is to change the nutrition dynamics for the entire state of Texas?
Yes, the goal is to make Texas healthier and to be an example for the nation.
do you believe, and you correct me if I'm wrong, that this isn't somewhat of an infringement on individuals who make their own selection and choices on how they want to eat and what they buy?
No, I don't at all. This is pro-transparency. This is more information. This is pro-consumer.
Thank you, Representative Hall, and I'll listen to the other amendments and see how we can continue to work with the stakeholders involved, because what we don't want to do is destroy anyone's business and or create such a burden or financial cost that the cost of food will continue to rise
That
because
is
of the
a pretty,
changes.
I have heard that, and that is one of the biggest lies from the lobby. This will not increase the price of food. This will not clear food from the shelves. That is a flat out lie that the lobby is spreading. They have until 2027. We have extended the runway for them to comply with the labeling requirements. If they don't ever change their label after 2027, then they do not have to. They are using they still know all of that, and they are still lying. The point is they change their label all the time. All the time.
Oh, so you said something that caught my attention here. So you're saying if they don't do it by 2027, they don't have to, or are there penalties associated?
No, correct. And that's the point, is Big Food is well aware of that. We extended the runway. They know this. They are still spreading the lies like you have heard and you just shared.
So, but if they're not up and running by 2027, is there any penalties?
No.
Okay. Thank you, Representative Hall, for answering my questions.
Thank you.
Does the gentlelady yield?
Ms. Harris-Davila, for what purpose?
Does the lady yield for
yes.
questions?
Gentlelady yields for questions.
Thank you. I just wanted to get some clarification. I know the labeling piece of this has garnered a lot of attention, but would you agree with me that if the ingredients are not in these foods, they wouldn't need to label them anyways?
That would be correct, which is why I appreciate the conversations that I know have been taking place with Bluebell, where they have said that they are already working to start removing some of these from their products.
And are you aware that a lot of manufacturers sell food in Europe and in the United States, but they have different formulas for what they sell in Europe or other countries than what they sell in the US? And so they actually already have better formulas without some of these ingredients already included in their business model. Would you agree with that?
Correct. They are perfectly capable of making the same product for the US, and they should.
And when we were working on our other Make Texas Healthy Again bill about banning certain ingredients in our school lunches, we had a conversation with some of these similar manufacturers, and they said that they were already working on changing these formulas for the United States, given what the federal government's push is to remove some of these ingredients. You're aware of that?
Yes, and I love to hear it.
And one other point that I'll add, and I don't know if you're aware of this, in our Healthy School Lunches bill, we require implementation by the 2026-2027 school year. And so some of these ingredients in your bill will be banned from those school lunches earlier than your implementation date in your own bill. Are you aware of that?
Yes.
So they will already be starting that work, and so even giving that runway to 2027, they'll already be able to have most of this implemented by that point, given other laws and potentially what the federal government might do between now and then.
Yep, exactly.
And then another clarifying question, we heard some comments about how far-reaching this bill is, but I've read the bill. I think it's reasonable approaches to fixing what we're seeing going on in this country, especially when it comes to doctors learning more about nutrition and wellness. And can you speak a little bit more to how important that is to kind of righting the ship, making sure that doctors have that information? I mean, I've spoken with my own doctor, and they're sometimes surprised by what they don't know and what they weren't taught, and sometimes wish they were taught that. Can you speak to that a little bit more?
Yes, I mean, all of these chronic health conditions that are plaguing Americans, it would be the role that food has in our health is significant. And if more doctors and healthcare professionals were taught about that and could then tell their patients, it would be transformative.
And then just to go back to the labeling piece one more time, I think, and would you agree with me that the existence of stores like Whole Foods and natural grocers that have all these other options are there for a reason? They're there because consumers want those choices. Would you agree with me on that?
Absolutely. I love natural grocers.
And that's what we're trying to provide. We're trying to provide transparency and what consumers want. Would you agree with that?
Yes, this is transparency. This is pro-consumer. This is information for Texans.
Thank you. I appreciate you answering my questions.
Thank you.
Mr. Speaker,
Ms. Goodwin, for what purpose?
will the gentlelady yield for a couple of questions?
Yes.
The gentlelady yields for questions.
Thank you, Representative Hull. I noticed that your amendment addresses pesticide chemicals, and I had an amendment as well. Does your amendment require the committee to examine the effects of harmful pesticides and chemicals used in the production or development of food on human health?
This bill is about ultra-processed food. So while I agree with what you are saying,
The gentlelady's time has expired. The following amendment to the amendment, the clerk will read the amendment to the amendment.
Amendment by Ashby.
The chair recognizes Mr. Ashby.
Thank you, Mr. Speaker. Members, first off, I want to thank the bill author for working with me on this amendment to her amendment, which I believe is acceptable. What this amendment does is it strikes atrazine and glyphosate from the bill's warning label list. These two herbicides have been proven over and over again, not only by our country's EPA, but by over 50 other countries, as being completely safe and vital to crop production, food security, and weed control in each and every one of your lawns. And so, again, I believe it's acceptable to the author, and I move adoption.
The chair recognizes Ms. Hull. Mr. Wilson, for what purpose?
Yes, is Representative Ashby available for questions?
Always.
Gentleman yields
Happy
for
to yield
questions.
questions.
So, sir, if you could help me out here, and I appreciate you laying out the amendment.
Sure.
What does it hurt for people to know that these things are is in their food?
Well, again, what we're doing here is proving all we're doing is saying what has already been proven by science and studies both in this country and across the globe, and that is that these two herbicides are completely safe.
Sir, and I do appreciate that, but there's also science that says that they're not. And so, and I understand that there's concern about crop yield, but Texas State in their research, as well as others, has already identified that there are already alternatives to these two pesticides.
Well, the alternatives that I'm aware of, Representative Wilson, are actually used on less than 1% of cropland just in this country alone. And if I could, let me just mention one thing here. I mentioned earlier that not just in the USA, but in other countries, it's being used, and as I said, it's been approved from a safety aspect, from a health aspect, looking at carcinogens and other factors as being completely safe by our best scientists. And so, again, we're standing on that research that has been done with this amendment today.
And I do appreciate that, sir, but are you also aware that there's far more than 50 countries who say that it's not?
Well, that's actually not correct. Actually, I think most people would agree that Europe, the European Union, has the most stringent standards when it comes at looking at herbicides and pesticides. Yeah. And this has actually been approved in the European Union. And so I think when you look at the terms of the safety aspect of this, yeah. Again, just setting aside the efficacy issues, the facts lay out that I think in what I'm presenting to you is that it is a completely safe herbicide.
Yeah. Well, sir, I appreciate that, but I beg to differ. And when sir, do you farm? Do you farm, sir?
I do.
Okay, sir, I do too. And do you know even ag agents are showing us the alternatives to pesticides There is a place for pesticides, but when you look at the ones that you're suggesting, that there are alternatives that they're now teaching farmers to use so that they can get the crop yield that they're looking to, but also they're taking other things into consideration, our droughts and all those other sorts of stuff. And I appreciate the respectful debate here, but
Sure.
we're talking about things that potentially are impacting our youth. When you look at ADD, ADHD, autoimmune, when you look across the board in terms of the population that's skyrocketing, that's costing us in public education on special 504 allotments and all those other sorts of stuff, it's just going through the roof. And so when you look to what President Trump is trying to do and RFK is trying to do in terms of trying to limit what is in and on our food, I know that this bill doesn't do that, but let me ask you, what's the harm for those who are conscious of it to be able to see it, be it our code or a label or whatever that may be?
Well, I want to go back and address something you said, Representative Wilson. You talked about the risk to children. And again, there's nothing, zero evidence that either one of these herbicides relates whatsoever to what you just referenced in terms of ADHD or any other type of childhood disorder. But I would bring your attention to, again, the EPA, which is what we rely on in this country. In 2020, atrazine, and in 2022, glyphosate, they looked at specifically were there any impacts on child safety, child health, and again, they found no risk to these children if they're used at approved levels.
I do appreciate that. And realizing that we're talking about labeling, again, if it's no risk, then what's the harm of placing it on a label?
Well, I would, I guess, turn the question...
I'm sorry, I don't mean to talk over you,
No, go
sir.
ahead, finish.
So that purchasers can be informed purchasers and consumers.
Yeah, so I understand that line of thought, and I appreciate what you're suggesting there. But again, if we already know that there is no safety risk, then why put it on there?
Well, simply because the President of the United States and others have made this a priority for us to understand what is happening to the quality of our food. And I think the state of Texas, standing by our president, should be looking forward to helping them in that endeavor in terms of the health of people. People basically could be healthy, can also have adverse reaction and so forth to any sort of ingredient. So I would say that if it ends up on a plant, that it should be considered as something labeled. And I do appreciate the dialogue, sir. Thank you.
You bet. Thank you for the questions.
Chair recognizes Ms. Hull to speak on the amendment to the amendment.
Thank you, Mr. Speaker. Members, atrazine and glyphosate aren't food ingredients, which is why I am accepting this. But they are banned in other countries because these pesticide and herbicide residues end up in our food. The amendment I just offered not only exempts chemicals in the agriculture industry, but it also stipulates the bill only applies to ingredients required to be disclosed in the ingredient list, which these are not. The ag industry knows this bill wouldn't affect them with my amendment, but they don't even want the words listed in the bill. I'm still going to accept this amendment anyway, because this bill is about food additives, not about the pesticides and herbicides that are in our food. Again, other countries have banned both of these. Atrazine is owned by a company that is a subsidiary of the Chinese government. Other states don't even allow it to be sprayed in their state. Our farmers don't want China to own our land, but are here advocating to spray the Chinese government's chemicals on it. Atrazine and glyphosate are toxic, and studies with no conflicts of interest show the health effects that the residue in our food has on our bodies. Because they are so toxic, instead of looking at the long-term effects, we have genetically modified our food to withstand more of this poison so that our food is harder to digest and causes further health effects. This is a conversation for another session. For now, I move adoption.
Chair recognizes Mr. Ashby to close on his amendment to the amendment.
Move adoption.
The
Question occurs on the adoption of the amendment to the amendment. The amendment to the amendment is acceptable to the amendment author. However, Mr. Lowe has requested a record vote. The clerk will ring the bell. Show Ms. Holt voting aye. Show Ms. Harris Davila voting nay. Show Mr. Ashby voting aye. Have all members voted? Have all members voted? There being 99 ayes and 25 nays, the amendment to the amendment is adopted. The following amendment to the amendment, the clerk will read the amendment to the amendment.
Amendment by Busey.
Chair recognizes Mr. Busey.
Thank you, Mr. Speaker. Members, this is a simple cleanup amendment. The current amendment exempts products with a warning label issued by the Surgeon General. These warnings are not actually issued by the Surgeon General. They are issued by TTB. This corrects the amendment, changing the language referencing a warning with the recommendation by the U.S. Surgeon General. It is acceptable to the author, and I move adoption.
Mr. Busey sends up an amendment to the amendment. The amendment to the amendment is acceptable to the amendment author. However, the question is on the adoption of the amendment to the amendment. Mr. Lowe has requested a record vote. The clerk will ring the bell. Have all members voted? Show Ms. Hull voting aye. Have all members voted? There being 113 ayes and 19 nays, the amendment to the amendment is adopted. Chair recognizes Ms. Hull to close on the amendment as amended.
Move adoption.
Ms. Hull sends up an amendment as amended that is acceptable to the author. However, a record vote has been requested by Mr. Lowe. All those in favor vote aye. All those opposed vote nay. The clerk will ring the bell. Show Ms. Hull voting aye. Show Dr. Buckley voting aye. Have all members voted? Have all members voted? There being 128 ayes and 8 nays, the amendment is adopted. The following amendment, the clerk will read the amendment.
Amendment by Buckley.
Chair recognizes Dr. Buckley.
Thank you, Mr. Speaker. Members, first of all, let me say that I appreciate the intent of this bill, and I certainly agree with most of it. But I can tell you that this amendment is necessary if we're going to maintain the ability for our young people to have educational options. What this amendment does is simply maintain current law that requires our middle school students to have 4 semesters of physical education. While certainly there are those that would say that 6 semesters is preferable, let's talk about the unintended consequences of that. And so if I'm a young person and I'm not involved in athletics, and I want to pursue fine arts, if I want to pursue a foreign language, I will often do so in the 8th grade so that I can bank those credits so when I attend high school, I have a clear pathway, whether it be for CTE, where I can have a coherent sequence to earn a credential of value. It will also open a pathway for advanced math and STEM pathways in some high schools. It also is necessary that a student have that ability if they're trying to attend a high school of choice, one that is a fine arts magnet school, one that is for STEM, one that's for healthcare. All these specialized high schools in Texas often require that a student have elective credits that count towards high school that they achieve in middle school. Now there is an exemption, but the exemption only works if you're a student that can participate in an out-of-school day activity like travel ball. Let's think about so many of our students in Texas that play travel ball, and that's great. But there are many other students, especially those kids that may not have the resources that could participate outside of the school day. So what I ask is that you vote for this amendment. Let's keep it as we have it now in law, that we have four semesters of PE required. I believe that other parts of this bill will educate our kids better, will improve the food supply, will do the things that are necessary, but for their academic achievement, this is mind and body. mind and body requires that we adopt this amendment to give more options to our middle school students.
Mr. Speaker,
Mr. Van Dever, for what purpose?
will the gentleman yield for questions?
Absolutely.
Gentleman yields for questions.
Thank you. Chairman Buckley, thank you for bringing this amendment. You and I were both in this chamber a few sessions ago when we passed House Bill 3, is that correct?
Yes, sir.
And a major part of House Bill 3 was to extend career and technology to the 8th grade, is that correct?
That is correct.
Yeah, so would this bill, as written, without your amendment, would it have any impact on the implementation of that part of House Bill 3?
Absolutely. It creates a conflict, you know, and it takes an option off the table. And there's never been a more important time for young people to have that option. And that option is to complete this coherent sequence of courses that requires banking credit in the 8th grade so that you can receive that credential of value. And that was an important part of House Bill 3 in 2019. We have extremely strong programs in our public schools for this. And I believe, though well-intentioned, I think this bill and this section of the bill is very well-intentioned. It simply is in conflict with something that this body has supported and knows is very important for our students as far as achieving those levels of career and technical education, but also advanced courses that can lead them to dual credit and other things that we've also agreed are important.
And we also have a funding model now that rewards schools for students who complete a credential of value. Is that
That is correct. That is an outcome-based funding model that we have, and without this amendment, that funding model is in jeopardy because it takes that off the table for young people in 8th grade.
So if your amendment doesn't get on, it could actually lead to reduced funding for our local schools. Is that correct?
It certainly could.
Thank you.
Yes, sir. Yeah, I move adoption.
Chair recognizes Ms. Hull to speak on the amendment.
Thank you, Mr. Speaker. Members, I love the fine arts, and I'm so glad that there's expanded CTE, but I also want healthy kids. And I know it was already talked about, so until 2017, PE was required for all 3 years of middle school. This is returning to 3 years. As I said in my layout, 1 in 3 Americans aged 17 to 24 are ineligible to serve in the military due to their weight. This is now a national security problem. I know Chair Buckley is in Killeen, so I know he understands that. This bill doesn't take away the ability for marching band or show choir or anything else that currently counts as PE to continue to count. The group that I think is behind all of this, because I don't know who exactly they are, because they have never talked to me, not once. If they had, I would have told them that in the committee substitute, we added a PE exemption for middle school, so that parents can opt their kids out of PE for out-of-school activities, just like they currently can in high school. And I want to thank Representative Busey for bringing that suggestion. I thought that had addressed any possible concerns because only one person testified on that issue in the committee no one's ever contacted my office. Middle school PE is the first time most students learn to use gym equipment, how to develop a fitness routine, and learn lifelong skills. For many kids, this may be their only opportunity to learn those skills. Kids will still be able to participate in fine arts and CTE because they did before 2017, and there are multiple elective spots in a school schedule. I have a sample schedule here if anyone is interested. Kids will still have room for electives in PE under this bill, just like they always have. When these kids are adults, it would be great if they're still participating in community theater or making pottery, but at the end of the day, I really hope that they're staying active and using those lifelong gym skills. This group never came to talk to me. I only saw this amendment as of yesterday, and I believe in helping kids stay active and healthy. I'm going to leave this to the will of the House because I know everyone feels differently. I have to vote no because I believe in healthy kids, but members vote your district.
Mr. Speaker.
Mr. Patterson, for what purpose?
Will the gentlelady yield for questions?
Yes.
Gentlelady yields for questions.
Thank you. Representative Hull, you mentioned that there is an exemption already in the bill now for extracurricular sports or activities that are done outside of the school hours. Can you speak a little bit more about that? I know Dr. Buckley mentioned travel ball, but I mean, I don't think that requires that you travel across the state or across the country to participate.
No, it could be anything. And this all came from Representative Busey, which I, again, very much appreciate him helping out with this. And like we had talked about, no one wants to harm fine arts or CTE. So the suggestion was to allow the same exemption that high school parents have, to allow it for middle school as well.
So it could be participating in sports, let's say in your local community,
Yes.
could exempt you from the PE course.
Yes, so like my son plays ice hockey, that would count. I know another member, Dr. Oliverson, said his daughter is a ballerina. Those are all things that would count, that middle school parents would be able to opt out.
Okay, and then the group that brought this amendment forward, in part, they want this amendment because it would increase CTE courses in middle school.
Yes, so, and Dr. Buckley did talk about that, and that's why I'm leaving it to the will of the House for members to vote their district. I know people feel differently about this.
Do school
So-
districts get paid more?
They do,
If their
yes.
students take CTE courses?
Yes.
Okay, so really, this is an exchange between keeping kids healthier by participating in PE more semesters, and instead of doing that, they want the additional dollars that come with the CTE courses. Is that the way that you would, is that fair?
I guess it's fair.
Okay, thank you.
Thank you.
Mr. Speaker,
Mr. Van Dever, for what purpose?
would the gentlelady yield for a couple of questions?
Yes.
Gentlelady yields for
Thank
questions.
You. Thank you, Chair Hull. Thank you for this bill. I'm proud to be a joint author on this bill and work with you to make our kids healthier. But would you disagree with me if I said that it's really unfair? It's really unfair to say that schools are more interested in funding than in healthy kids. Was that a fair assessment?
I don't know. I think it would probably depend per person. I don't know.
Yeah. So have you been involved in, you mentioned your son, have you ever tried to get a waiver for PE from a local school?
No, I have not.
Okay. Would it surprise you to learn that schools apply this in different ways and have different standards?
Yes.
And that some schools might require that the child be in a really high-level gymnastics program to exempt them from their PE?
Again, the bill does not touch what is currently allowed or not allowed.
But is it accurate to say that the bill does include what's currently done? You included that exemption in your bill, is that correct?
Yes.
Because that exemption is not currently in place for middle school.
For
is that
middle
right?
school, right. High
Yeah.
school parents have that, middle school parents don't.
Okay. I'm just curious, do you not think that it could be a fairly high bar to clear for these middle school students to qualify for this exemption?
Well, I think people should talk to their school boards if they don't like the exemption policies.
Yeah, okay. Thank you. And again, thank you for bringing this bill.
Yes, and again, that's, members, I am leaving it to the will of the House. I know everyone feels differently about this, so everyone is free to vote your district.
Chair recognizes Dr. Buckley to close on his amendment.
Thank you, Mr. Speaker. Members, first of all, I appreciate the dialogue back and forth and certainly appreciate the work that Chairwoman Hull has done on this bill. And overall, I think it's a good bill. But I also know, and I just want everyone to know, that the group that contacted me about this amendment, or that informs me, is a group of 3 children in my home that all participated and benefited from the flexibility in 8th grade, where they could then pursue, for my daughters, fine arts courses that would not have been available that way, and also because of that, were able to participate in a dual credit program, and my son, who was able to participate in CTE courses because of it. So it's about that. It's about mind and body. We can have both, and I believe this amendment does that, and I ask for your support on this amendment.
Mr. Speaker,
Ms. Gonzalez, for what purpose?
does the gentleman yield?
Does the gentleman yield for questions?
Absolutely.
Gentleman yields for questions.
Thank you, Chairman. I was also proudly on the HB3 conference committee where we're making some of these changes because I think we recognize that there are 5 million kids in our local public schools and over 1,000 school districts with different options for these kids. And so we were trying to allow for us to recognize the breadth of skills that these young people have. Does that feel accurate?
Yeah, absolutely. Our kids have, they need to be able to experience different things and try out different things. And that flexibility in the 8th grade year, you talk to local school folks, talk to your teachers and your principals. And that 8th grade year, that flexibility is crucial in a child finding their pathway to graduation, whether it be banking college credit hours or whether it be banking a credential of value. And so, there may be a time when we can rearrange the way we do school from 8th grade through 12th grade, but at this time it is important that we stay where we're at so we don't disrupt the really good things happening for our kids and the opportunities they have now.
And I do want to reframe something that was characterized that, is this about school districts getting money or is this about the health of the kids? And I don't think it's a binary. I think, in fact, healthy kids are happy kids who get to explore their futures. And when they don't have those opportunities, they are less even healthy. And so I want to push back on that narrative that this is about money and health. I don't think it's a binary. And I think just because the school finance formula will be impacted, does it mean that it's a binary? Can you help expand on that?
Absolutely. There is nothing that creates a healthier child than finding their passion, that finding their way where they finally have decided. Everyone that has kids knows when they're little kids, they walk in, they're going to play in the MLB or the NFL. Then they're gonna, then they want to, be a police officer, and some do, and then they might want to be a teacher or a lawyer or a veterinarian or a doctor. But nothing really, you never see a child thrive until they really have unlocked that passion of what they want to do, and it changes them. And I believe those options available in the 8th grade are just pivotal. You think about the age of an 8th grader, and I think that's why this is so important. And then we talk about the money part. That is a part of it. But what we know is that we have created outcome bonuses because we know that's what the Texas economy needs, and that's what our children should be able to access. And though I think the intentions of this bill are outstanding, I think this is an unintended consequence, and I just want to try to correct that so that we still have great opportunity for young kids or young folks in Texas schools.
I appreciate your leadership, and I do appreciate the author's leadership in trying to make sure we have healthy kids, and I think your amendment does that too. So thank you so much.
All right. Thank you very much. Members, I move adoption.
Dr. Buckley sends up an amendment. The amendment is not acceptable to the author. This is a record vote. The clerk will ring the bell. Show Dr. Buckley voting aye. Show Dr. Oliverson voting nay. Show Ms. Goodwin voting aye. Have all members voted? Have all members voted? There being 97 ayes and 36 nays, the amendment is adopted. The following amendment, the clerk will read the amendment.
Amendment by Goodwin.
Chair recognizes Ms. Goodwin.
Mr. Speaker,
Mr. Bryant, for what purpose?
I raise a point of order against further consideration of Senate Bill 25 under Rule 4, Section 32C3 on the grounds that the bill analysis is materially and substantially misleading.
Mr. Bryant, please bring your point of order down front. The point of order is withdrawn. The chair recognizes Ms. Goodwin to lay out her amendment.
Thank you, Mr. Speaker. Members, this amendment is pretty simple. It just would allow marching band to count towards the PE credit, and it just spells it out to make sure it's absolutely clear that it would count towards the PE credit. So imagine someone who's involved in marching band. Friday night football games are the beating heart of small towns across the Lone Star State. They're part of our identity and culture. Going to your first high school football game without your parents is a rite of passage for many Texas teens. Friday night football games bring communities together and are a reminder that even when screens dominate our world, nothing beats a Texas sunset set against a football field. But we all know football season begins long before Friday night football games. Most teams begin practicing twice a day in late July or early August, but they aren't the only ones preparing for the upcoming football season. Students who play in their school's marching band can often be seen practicing their routine in the stadium parking lot. But playing the halftime show at the games on Friday is only a part of what the marching band is preparing for. Most bands spend much of their time preparing to compete in UIL competitions across the state. To be successful, students have to put in countless hours learning their instruments and rehearsing their steps. This is why many marching band programs begin in the middle of summer and might involve weeks of 9 to 12-hour days. During the school year, many bands practice every day after school for at least 2 hours. Given the physical demands of marching bands, it makes sense that studies have shown that participation in marching band can improve cardiorespiratory fitness. Marching band is a serious blend of music, performance art, and athletics, and should be allowed to count towards a PE exemption. Move adoption.
Chair recognizes Ms. Hull to speak on the amendment.
Thank you, Mr. Speaker. Members, I appreciate what Representative Goodwin is doing. Most school districts already allow marching band. Under current law, dance and music that is taught by a certified PE teacher already counts toward PE and can count toward both the PE and fine arts TEKS. So this is not necessary to add this to this bill. Again, I appreciate what she's doing, but it's just unnecessary, so I move to table.
Chair recognizes Ms. Goodwin to close on her amendment.
So I recognize that it is possible that marching band might be counted as PE, but this just makes it, spells it out in writing, makes it extremely clear that it would be allowed to go towards a PE credit. And with that, I move adoption.
Ms. Goodwin sends up an amendment. Ms. Hull moves to table. The question is on the motion to table the amendment. If you're in favor of the amendment, vote no on the motion to table. If you are opposed to the amendment, vote yes on the motion to table. Record vote has been requested. The clerk will ring the bell. Show Ms. Hull voting aye. Show Ms. Goodwin voting nay. Show Ms. Leo Wilson voting aye. Have all members voted? Have all members voted? There being 71 ayes and 47 nays, the motion to table prevails. The following amendment, the clerk will read the amendment.
Amendment by Flores.
Chair recognizes Ms. Flores.
Thank you, Mr. Speaker. Members, a common theme of this session has been about a parent's exclusive right to decide what their children read, believe, and think. If you voted to support parents' rights, then this amendment is for you. Currently, SB 25, I guess it's CSSB 25, allows students who participate in private club sports to receive an exemption from the additional PE credit requirements. That means that students who can afford to participate in a private club or league sport will have time in their schedule to take up to 2 additional courses. This creates an unfair academic advantage for the group of students who already have an athletic advantage because of their ability to participate in a private sport. All my amendment does is say that if a parent believes that their child gets enough physical activity outside of school day by participating in other non-private league or club-related activities, then they should be allowed to request the same exemption for their child and give their child the same academic advantage as other students. Members, let's be honest, private sports leagues and clubs can be expensive and time-consuming to participate in. For parents struggling to make ends meet or who simply can't take the time off from work, private club sports are not within the realm of possibility for their kids. However, this does not mean that their children are not athletic or active outside of school. If you were to leave right now and drive down the street to a park in East Austin, I guarantee you'll find a group of sweaty kids running around playing soccer, basketball, or football. You'll also see plenty of kids on bikes or jogging around the track. Just because kids are not paying hundreds of dollars to play their chosen sport does not mean that they are not getting enough exercise outside of school. If parents have the exclusive right to, as Representative Patterson and many others have said, choose what their child reads and learns, then they should also be able to decide if their child needs to spend an additional year taking PE when they could be taking another class that would be better serve their academic career. Not every famous athlete had the resources to participate in a private club or league when they were growing up, but that didn't mean that they didn't have the talent or skill necessary to compete. Members, let's even the playing field and allow parents to decide. Move adoption.
Chair recognizes Ms. Hull to speak in opposition to the amendment.
Thank you, Mr. Speaker. Members, and while I appreciate what Representative Flores is doing, and especially an amendment about an exemption form, super great, but this bill extends the current exemption that high schoolers have to middle schoolers, not creating the exemption like this amendment would. I've just kind of seen this as of yesterday, so I haven't been able to review it with stakeholders. And again, they're getting an exemption. That amendment was put on, so it's back down to 2 years.
Mr. Speaker.
Mr. Rosenthal, for what purpose?
Does the gentlelady yield for a question?
Yes.
The gentlelady yields for a question.
Is this just a form?
It's just a form. Yes.
Thank you.
Thanks. So again, they could, the exemption could be any free sport, a YMCA, a letter from a YMCA, that would work too. So while I appreciate it, I have to move to table.
Chair recognizes Ms. Flores to close on the amendment.
As always, I'm just trying to make sure that folks that come from less affluent families have the same opportunities that rich kids have. So please, I'd ask for your consideration and ask for your adoption of this amendment. Thank you.
Ms. Flores sends up an amendment. Ms. Hull moves to table the amendment. The question is on the motion to table. If you're in favor, vote no. If you're opposed to the amendment, vote yes. This is a record vote. The clerk will ring the bell. Show Ms. Hull voting aye. Show Ms. Flores voting nay. Show Mr. Turner voting nay. Show Mr. King voting aye. Have all members voted? Have all members voted? There being 71 ayes and 56 nays, the motion to table prevails. Following amendment, the clerk will read the amendment.
Amendment by Turner.
Chair recognizes Mr. Turner.
Thank you, Mr. Speaker. Members, this amendment requires that the middle school and high school courses included in the bill, which I think are a great idea, include the effects of hormones and antibiotics in our food. Hormones and antibiotics in food can have long-term effects on human health, including potential links to hormonal imbalances and other health issues. Meat hormones, especially those used on red meat, have been linked to early puberty in young girls, leading to some young girls beginning menstruation at 8 or 9 years old. And it's 2 years below the average age. Additionally, health experts, including the CDC, have long warned that the overuse of antibiotics in agriculture contribute to antibiotic-resistant bacteria, which is a major health threat. Education is a key prevention strategy, and students deserve to be informed on how the hormones and antibiotics in their food affect their bodies and their natural immunity. This amendment simply requires that the instructional materials used for the required nutrition curriculum in the bill also include information on the effects of hormones and antibiotics used in food products on human health. This is a common sense, science-based update to the curriculum that benefits Texas students, families, and future health care for our state, and I move adoption.
Chair recognizes Ms. Hull to speak in opposition to the amendment.
Thank you, Mr. Speaker. While I very much agree and appreciate with what Chairman Turner just said. The nutrition curriculum and this bill is about ultra-processed food. So the stuff on the hormones and antibiotics, this is a conversation for a future session. While I agree, I'm going to have to move to table, please.
Chair recognizes Mr. Turner to close on the amendment.
Thank you, Mr. Speaker. Members, again, if the goal is to teach our young people, our school students, about the stuff we put in our bodies, that they put in their bodies, and what's good for you, what's not good for you, this is just a common sense addition to that curriculum to teach about the effects, including the potentially negative effects of foods that contain levels of antibiotics or hormones. That's all the amendment does. So I
Mr. Speaker,
ask that you vote no on the motion to table.
Mr. Wu, for what purpose?
would the gentleman yield for some questions?
Yes.
Gentleman yields for questions.
Thank you. Representative Turner, again, we're dramatically changing what is available to our citizens, what is available, what schools must do, and this is all happening around students, and they're not really given any explanation of exactly why this is all happening and what purpose does it serve. Is that fair?
Well, I think that, I think that this bill does represent a lot of changes to a wide array of aspects of our state, including in education. And my amendments focus specifically on K through 12 and more specifically grades 6 through 8.
Yeah.
That the instructional materials, the curriculum, include this additional information. So we're talking about foods that, whether they're good or they're bad, or and what effects they may have on a child's body now and as they grow into adulthood. That curriculum also include information on antibiotics, which we know is an issue in some foods, and hormones, which is an issue in some foods.
And I know the bill author has said that, well, we don't know if we need to do this right now. Let's wait for another session. This bill literally has a requirement that you cannot get a bachelor's degree unless you take an entire semester nutrition class.
That's true.
Right? And we're saying we're going to force college students to take an extra college class required before they can graduate to learn about nutrition, but we can't explain to younger kids why this stuff is happening. I think that's what she's saying.
Yeah. Well, and I think, and I'd have some concerns about the college level requirement in the bill as well. I do think, with respect to younger kids, nutritional instruction makes some sense. I just want it to be complete. And if we're going to do nutritional instruction, introduce a new requirement, a new curriculum for grades 6 through 8, that it be a complete curriculum, as complete as possible. And that's what I think this amendment helps to achieve.
And I know the author said that we should wait till the next session. The bill is already time delayed. The bill does not start for 2 years.
Right.
There's plenty of time for people to figure this out in that time frame.
Yeah, that's a good point.
We don't
I
need
think
to come back.
There's plenty of time for rulemaking and for TEA and SBOE to develop the curriculum on this. So I think there's plenty of time to get it right.
And there's nothing's going to change in the next 2 years. That says that we would have a different opinion about what we need to teach kids.
I don't think so. I think this is
Thank
going to continue. This is a health concern today, and I think it certainly will be years into the future.
Thank you.
Thank you. Thank you, members. I ask you vote no on the motion to table.
Mr. Turner sends up an amendment. Ms. Hull moves to table. The question is on the motion to table the amendment. A record vote has been requested. The clerk will ring the bell. Show Ms. Hull voting aye. Show Mr. Turner voting nay. Have all members voted? Have all members voted? Show Mr. Bojani voting nay. There being 75 ayes and 59 nays, the motion to table prevails. The following amendment, the clerk will read the amendment.
Amendment by Bojani.
Chair recognizes Mr. Bojani.
Thank you, Mr. Speaker. Members, I'm so glad that student health has been a focus of ours this session. We'll help protect our children from harmful social media, encourage schools to regulate cell phone usage, and now we are making sure they eat healthy and exercise. So the idea of this amendment came from my daughter, Raisha Bojani, at the beginning of the session, and y'all may remember that she came during spring break and spoke to many of you in your offices about this idea of having mindfulness as an elective course in school districts that may want to choose it. So it's permissive. It doesn't have any fiscal note on it as well, and so that's what this amendment is about. Anyone who has a teenager or remembers being one knows the stress they are under. And as adults, we know how closely linked mental health is to physical health. If our youth don't learn how to deal with life struggles in a healthy way, it impacts all of us when they become adults and act in unhealthy ways. This amendment would allow schools to have an elective course on mindfulness. For some reason, there is misinformation that this has something to do with religion. This absolutely does not have anything to do with religion. I have never heard of mental health or the generic term mindfulness being linked to a religion. This is science, and there's a lot of research that shows mindfulness techniques in schools can boost cognitive functions, improve academic performance, and reduce disciplinary issues. In short, these practices give students a stronger foundation to learn and grow. Let's ensure healthy minds are included when discussing healthy bodies. With that, Mr. Speaker, I move adoption.
Chair recognizes Ms. Hull to speak in opposition to the amendment.
Mr. Speaker, members, I respectfully have to ask for this to be tabled. This has nothing to do with this bill. It is not germane, and so I just ask that you move to table, please.
Chair recognizes Mr. Bojani to close on the amendment.
Thank you, Mr. Speaker. Members, again, more than 60 of you are joint authors and co-authors on this bill, and that made out of public education, but was placed or did not get placed on the calendar in time. So I would respectfully urge you to vote yes for this amendment. Thank you. Or vote no for the motion to table. Thank you.
Mr. Bojani sends up an amendment. Ms. Hull moves to table the amendment. The question is on the motion to table. This is a record vote. The clerk will ring the bell. Show Ms. Hull voting aye. Show Mr. Bojani voting nay. Have all members voted? Show Ms. Ward Johnson voting nay. Have all members voted? There being 73 ayes and 57 nays, the motion to table prevails. Please excuse Ms. Please excuse Ms. Y. Davis of Dallas on the motion of Ms. Thompson. Is there any objection? Chair hears none, so ordered. The following amendment, the clerk will read the amendment.
Amendment by Ward Johnson.
Chair recognizes Ms. Ward Johnson.
Thank you, Mr. Speaker. Members, as a former community college trustee, this one resonated with me. The average price of tuition at Texas Public Higher Education is around $5,200,000. With housing, course materials, and additional institutional fees, the number goes up to around $8,000 or more. For many Texas students and their families, that's a serious financial burden. SB 25, as written, would mandate an additional nutritional course regardless of a student's major career path. While nutrition education is valuable, making it a requirement adds yet another cost and another barrier to graduation. This amendment would make nutritional courses for college students. My amendment would make it optional, not mandatory. This would not remove access to nutritional courses and content. Instead, we are simply saying that students should be allowed to choose the class if it aligns with their goals, with their department goals, with their class goals, with their graduation goals. College is already stressful and demanding experience. Vote for this amendment to stand by your college students. Give them the freedom to choose what's best for their future and ease the financial strain. This class does not bring value to every department. This class does not bring credentials of value. I move adoption. Thank you.
Mr. Speaker.
Mr. Wu, for what purpose?
Would the lady yield for questions?
Yes, I would.
The gentlelady yields for questions.
Representative Ward Johnson, do you know if this bill contains any money for universities in Texas to offer this class?
No, I'm not aware of that.
Would you believe that there is not?
I would believe that there is not. I would say that there was not.
Does this provide any money to students who would be required? Every single baccalaureate student would now be required to take. Is there any money for them to take these extra hours?
No, there's no money for them.
Okay.
They would have to come out of their pockets.
If
to
a
pay for
student now suddenly has to be in school an extra semester so he can meet this single requirement imposed by this law, does anything in this bill provide additional funding for that student to be in school another semester?
No, it does not. As a matter of fact, a lot of parents are going to have to come out of their pockets. So a lot of you that pay for your kids to go to school, this will impact you.
There's nothing in the bill that says that a student wouldn't have to pay for this, right? There's nothing that says that the schools can't charge for this.
Right, nothing.
Right? And there's nothing in this bill that says the schools will be made whole if they offer this class for free.
You're absolutely right.
Right.
Nothing.
And if a student says, look, I've done everything, I've completed all my hours, and you guys just dropped this on me, there's no exception for them.
No exception.
Right? Even if it's a
Correct.
student that says, I'm already going into med school, I'm already going into a health field, I'm going to take like nutrition classes out the wazoo, they would not be exempted from this.
No, they would not.
And even if a student was in like a near health program, that they were in a science where nutrition was already an elective of some kind, they would not be exempted from this.
No, they would not.
This is adding an incredible, massive mandate to our schools and to our students, isn't it?
I absolutely agree. I was a technology major, and this class would have done nothing for me.
And your amendment would take a shall, a must, to a may, correct?
Correct.
I think this is a very sensible amendment that should be supported by everyone.
Thank you. I move adoption.
Chair recognizes Ms. Hull to speak against the amendment. Or, excuse me, backup members. Chair recognizes Ms. Hull to speak on the amendment.
Thank you, Mr. Speaker. So, members, the bill is not prescriptive in how the schools must implement this. So, no one in the higher ed community has come to speak about this as a concern at all, and it has been in the bill since March 5th. So, the bill is not prescriptive into what this course of instruction in nutrition will look like. This is also going to go through rigorous rulemaking at the Texas Higher Education Coordinating Board. So there is nothing in this bill that says that they have to pay for an additional class. That is not at all the intention. And again, no one in the higher ed community has raised a single concern. They can simply incorporate any sort of nutrition curriculum into already existing classes. So no one is required to pay for an additional class.
Mr. Speaker.
Mr. Wu, for what purpose?
Would the lady yield?
Yes.
The gentlelady yields for questions.
Representative Hull, does your bill say that it only needs to have components of it in other classes?
No, it is not prescriptive. And so the rulemaking, again, that is the, yeah, sorry.
In fact, on page 4, starting on line 10 through 17, is that requirement. It actually says that the THDCB, by rule, shall require institutions of higher education to require each student enrolled in an associate or baccalaureate degree program at the institution to complete a course of instruction. It doesn't say learn the ideas, it says it must complete a course, does it not?
Yes, again, that curriculum can be incorporated into any course where they believe that it would fit.
Does your bill say what you just said?
No, the whole point of it, and again, if you keep going, part of it is those guidelines, but there's further on, I'd have to find on the exact page, all of the rulemaking.
And again, Representative Hull, you're telling me that read between the lines. Me, as an attorney, reading the lines, this direction is complete. It says you must complete a course, and the course must have things provided by the Texas Nutrition Advisory Committee. established under this law. It does not say that it can be included in other classes. It does not say that other classes could suffice for it. It does not say that you're exempted from it because if you've taken these things, or it has these things in your course load, or if you're in this major. It just says that every single student who is seeking an associate's degree or a baccalaureate degree must take a course of instruction in nutritional education. If I was a school reading this, this is black and white. It says you must create a course that they must now take.
It doesn't say that they have to create a course. And again, with the rulemaking, that all of that is part of that process. And I go back to, this has been in the bill since March 5th, and not a single person in the higher ed community has had a concern about this section of the bill.
And again, Representative Hall, I'm not sure why people have to tell you something is bad when we're telling you something is bad.
Because I don't believe that it is.
You don't think requiring every single college student, these are adults, these are adults over 18, these are grown adults. You're telling them they must take this course for their own benefit or they will not graduate.
Again, it can be within a course that already exists. That's
even worse.
It is the new
If they
part
already
of the
have a
instruction.
nutritional program, that is a complete class, and you say you have to take this complete 3-hour class, that's even worse.
I am not saying that they have to take a new class.
But your law does. Your bill does.
It does not.
Your bill says must complete a course of instruction. What is
Yes.
a course?
And again, they can implement it, like I just said, where they are incorporating this curriculum into already existing classes.
And I'm telling you again that your bill does not say that. You should
Yes,
add
it is
that into
not.
your bill.
It is not prescriptive at all. Correct. It is not prescriptive.
How is it not prescriptive?
leading-
It says point blank what they must do. Like the word must and shall appears over 50 times in this bill. There is no may anywhere in this bill. Everything in this bill is a must or a shall.
Yes, they have to take a course that at least incorporates this curriculum. Correct. The curriculum has to be incorporated into a course that would make sense. All of this is done by rulemaking, which is talked about in the bill.
Where does the word incorporate show up on page 4?
Again, with all of the discussions with everyone within the higher ed community, that has been the discussion. And there has been, the concerns that you are raising today have never been talked about. That no one has been worried about a new course and kids having to pay for a new course. That is not how anyone has believed that the bill is implemented.
Who pays for it then?
The chair will remind the members that we are on the amendment.
We were talking about the amendment.
Who pays for what?
Who pays for this course?
Again, it would be a course that they would already take.
What if they don't have a course that they already take that has this component?
There's a lot of core curriculum core classes that they have to take that could easily, a lot of the different science classes, there's a lot of different things that can incorporate nutrition education.
And again, Representative Hall, the reason I keep asking you, where do you see the word incorporate, right? There's a reason for that, because you can say on the floor, again, you can say it's your legislative intent, but by the way, we passed HB 113 that says legislative intent doesn't matter anymore. So the only thing courts can go on is the black letter law that you have provided. The black letter law says they must take a complete course, right? That has the curriculum required. It doesn't say you can incorporate it, you can add it into other stuff. Your bill does not say that. And I know you say it's prescriptive. That's what prescriptive means. It's prescribing what you must do.
I am, again, sharing with you all of the conversations that have been on this bill about what that does. I cannot make changes to that without going back and having further conversations with higher ed community to figure out how that would change that. I can't do it.
We've just put a half a dozen amendments on. We're changing stuff right now. Why can't you change it right now?
A lot of these other things and the amendment that I put on had been discussed for weeks and weeks. So I cannot make changes to the bill, a significant change, without talking to the stakeholders that it would affect.
We've
I
made
can't do that.
significant changes today already.
Again, those changes had already been talked about and discussed. I cannot make a significant change without knowing exactly how it would affect how everything plays out. I can't do that.
So I'll tell you the easy way to look at this. If you take that provision of the bill and take it from a shall to a may, it would take the burden off
then
of
they
every.
wouldn't do
it would
it.
take the burden off of every college student in this state.
Then they wouldn't do it. And it's Texas Public Schools. Okay. I move to table.
The chair recognizes Ms. Ward Johnson to close on her amendment.
Members, thank you. Well, I do have respect for the author and the sponsor of this bill. I was a former community college trustee, and I understand the burdens of degree plans and the cost associated with this. And this bill currently would make it mandatory to take this class, which would cause an extra burden for someone that does not need it to reach their degree plan or their graduation. So I will respectfully ask for you not to table this if you care about the value of what your kids are learning. Thank you.
Ms. Ward Johnson sends up an amendment. Ms. Hull moves to table the amendment. The question is on the motion to table. This is a record vote. The clerk will ring the bell. Show Ms. Hull voting aye. Show Ms. Ward Johnson voting no. Show Ms. Collier voting no. Have all members voted? Have all members voted? Show Mr. Latterback voting aye. Have all members voted? There being 67 ayes and 70 nays, the motion to table fails. Is there anyone wishing to speak on, for, or against the bill? Is there anyone wishing to speak on, for, or against the amendment? Anyone wishing to speak on, for, or against the amendment by Ms. Ward Johnson, please come down.
Does anyone want to speak? What does Ms. Hull want to do? She needs to come.
Chair recognizes Mr. Wu to speak in favor of the amendment.
Members, look carefully at the fiscal note on this bill, right? The fiscal note, in my opinion, is very incomplete because you have a provision here that says every university must, by law, create a program or a program like it that is sufficient. Not only that, there is nothing in this bill. There is zero in this bill that provides them with funding. There is zero in this bill that says their funding will be protected when they create this. And worst of all, I love a little government overreach, but even this is too much. This is telling grown adult people people in universities, in college already, what's good for them. You can advise people to take a class, you can tell people they should be healthy, but to say that you cannot graduate because you didn't take a health course because we thought it would be good for you. I love if people would be healthier. I would love for more people to exercise, to eat better. I would love for people to eat fewer processed foods and have salty snacks and have too much sugar. But I don't want to hold a gun to people's heads and make them do it. That seems counter to everything that we've said we care about in Texas. That we try to let grown adults make their own decisions. We can recommend that these classes be taken. We can tell schools you should make them available if people want them. But to say that you cannot graduate, to say your child will not be able to earn their degree because, well, we want them to do a little better. And I know Ms. Hull wants to play with the words that are on this bill, but you can read it yourself on page 4. It doesn't say that you could swap out other stuff. It doesn't say that you can make stuff fit because that language doesn't exist. Our legislation, our laws don't work by what you think about and how you feel about them. They work by what's on the paper. Look at what's on the paper. It says point blank, they must complete a course. Does not say that you can substitute. Does not say you can satisfy it with other criteria. It says you must complete this course, and there's no limitation on how long this course could be. This could be a 1-hour course, or it could be a 6-hour course. It doesn't say. There's no limitation. There's no guidance. All it says is you must complete this course. I urge you to vote on this amendment. You can still accept the rest of the bill, but we don't have to make this bill so onerous on every Texan who's going to attend school or their families.
Chair recognizes Ms. Ward Johnson to close on the amendment.
I move adoption. Oh, members, the amendment is now acceptable to the author. I move adoption.
Ms. Ward Johnson sends up an amendment. The amendment is acceptable to the author. However, a record vote has been requested. Vote aye, vote nay. The clerk will ring the bell. Have all members voted? Show Ms. Hull voting aye. Have all members voted? Have all members voted? There being 114 ayes and 25 nays, the amendment is adopted. The following amendment, the clerk will read the amendment.
Amendment by Collier.
Chair recognizes Ms. Collier.
Thank you, Mr. Speaker. Members, the proposed Texas Nutrition Advisory Committee will have the power to influence and guide the state's health and nutrition standards for the next generation of Texans. This is a huge responsibility placed on the backs of 7 people, and we must ensure the committee's members possess the expertise, experience, skills, and training necessary to shape state policy. Given the purpose of this committee, we should have at least one licensed dietitian at the table. Their training, and expertise is directly related to the goals of the committee and will help improve their work. Dietitians are trained to use the principles of food, nutrition, biochemistry, physiology, and behavioral sciences to help people take care of themselves and maintain good health. In order to qualify for a dietitian license in Texas, applicants must have completed an approved pre-planned professional experience program or internship of not less than 900 hours under the supervision of a licensed dietitian or registered dietitian. Then they must complete a minimum of 12 hours of continuing education during each 2-year licensing period. Members, every session we pass dozens of bills that come from the advisory committee's recommendation, and these are the commissions that we establish. We rely on these committees to provide us with the expert opinions and input we need to make the best policy decisions for our state. Texas dietitians are trained experts in their field and should be represented on the Texas Nutrition Advisory Committee. I hope you'll join me and ensure that their invaluable perspective is represented. So this committee would move from 7 people appointed by the governor to 8 people appointed by the governor, with 1 being a licensed dietitian.
Mr. Speaker,
Mr. Rosenthal, for what purpose?
would the gentlelady yield for questions?
Does the gentlelady yield for questions?
Yes.
Gentlelady yields for questions.
Thank you, Rep. Collier. So are you saying, so first, it seems to me you're pointing out a flaw in this effort to make people healthy again, because it's all about food and we don't have a licensed nutritionist on the effort?
There is not currently a space at the table for a licensed dietitian whose whole field of expertise is in food and nutrition.
Okay, so the effort to make folks healthy and improve their diets, you think would be improved, would be aided, assisted by having a licensed dietitian?
Absolutely. That would be very helpful.
Well, that makes perfect sense to me.
Yeah, right. If that's what their goal is, the goal is to help people make choices that would improve their health with not only with lifestyle and food intake. Let's have somebody at the table who specializes and who is trained in that area.
I wish I had thought of this. Thank you.
Thank you. I move adoption.
Chair recognizes Ms. Hull to speak on the amendment.
Thank you, Mr. Speaker. Members, the advisory committee has 7 members, 1 physician in functional medicine, 1 pediatrician who specializes in metabolic health, the 5 other spots, a rural member, urban member, member representing Department of Ag if they choose, or a member who is an expert in metabolic health, and an unspecified person. So technically, a dietitian could be one of those people. This has been, the makeup of this has been, excuse me, highly negotiated and has been crafted very carefully to try and keep out all conflicts of interest. I know specifically that dietitians and their conferences are sponsored by Big Food. So I cannot put a dietitian on the list. That does not mean that one of these other 5 spots could not be filled by one. But again, this list has been very highly negotiated, so I cannot add anything else.
Mr.
Rosenthal, for what purpose?
Does the gentlelady yield for
Generally yield
questions?
for questions?
Yes.
She yields for questions.
So I thank you, Chair Hull. I do appreciate both the effort and the logic that you're presenting. Isn't it so that every other member of this commission? All right. Can you please again enumerate the commission? What are the positions again? You've got a physician, and please enumerate them
In
again.
functional medicine, a pediatrician who specializes in metabolic health, and then a rural member, an urban member, member representing Department of Ag, or a member who is an expert in metabolic health, and an unspecified position, which means those are very, very flexible positions.
I got it. So, And your logic for not wanting to have the dietitian is?
We have had, again, numerous conversations. This has been heavily negotiated on the makeup and language of this committee, so I cannot add anything.
I
And
got it. But the reasoning that you gave was that the dietitians have sponsors for their events, for their convention.
Yes, that is one of the reasons that was given, and that was, yes, they are sponsored by Big Food.
I got it. By that logic, isn't it also true that every other group you mentioned have their events sponsored by outside interests?
Likely not Big Food. When this whole bill is about ultra-processed foods. So again, the language of exactly who is on here, the positions, how they are listed, has been heavily negotiated.
Except for the one position that is unspecified. Is that correct?
Yes, and that
Okay.
is where the members, again, this governor appointed the members of the chair of Human Services, of Public Health, and the Senate chair of Health and Human Services, and there's others that can make recommendations to the governor.
So let me ask this. Is there evidence to support the assertion that that Big Food corrupts the dietitian body?
I'm sorry, say that again?
So the concern expressed is that dietitians have support from the food industry, Big Food, I guess you called it, and that could corrupt their judgment on a panel like this?
Some, possibly, others no.
But the support that all the other members of the body have will not corrupt their judgment on this commission.
Again, the language was crafted very carefully, and if you read about the conflicts of interest in the bill and who is allowed and the people that cannot qualify, I feel like that answers that.
I appreciate you indulging the questions. Thank you.
Thank you. I move to table.
Ms. Collier in opposition. You're closed.
Thank you,
Ms.
Mr.
Gervin
Speaker.
Hawkins, for what purpose?
Will the gentlelady yield?
Gentlelady for questions.
Yes.
Shields for questions.
Representative Collier, one of the things I was looking at, and I was hoping it would encompass in part of your amendment, do we talk about the civil penalty that's involved at all?
I'm not sure if that's in this amendment.
It's not in the amendment.
No.
I'll wait till the bill author comes
Okay.
back.
All right.
Thank you.
Members, I understand that Chair Hull is concerned about undue influence by outside interests, but they took the time to designate a physician who specializes in metabolic and culinary medicine, who would also, one could argue, be influenced by food and outside interests who specialize in food production and labeling and so forth. So I'm not sure if that is a strong argument when you're talking about not including a licensed dietitian. I do appreciate the opportunity to have one appointed, and I would be willing to amend my amendment to ensure that one of those spots of the 7 does include a dietitian, because it is very important that we have someone at the table who can discuss with confidence and with the expertise and experience about the types of foods that we eat and how they impact our lifestyle. And so with that, I ask that you vote no on the motion to table and provide a spot at the table for our dietitian. So no on the motion to table. Thank you.
Mr. Speaker,
Ms. For what purpose?
I do have, will the gentlelady yield for?
She has moved to table. Ms. Collier closed.
I was trying to reach you several times, but
Okay. Ms. Collier sends up an amendment. Ms. Hull has moved to table. The question's on the motion to table. It's a record vote. Clerk, ring the bell. Show Dr. Alverson voting aye. Ms. Hull voting aye. Ms. Gervin Hawkins voting nay. Mr. Wilson voting aye. Mr. Louderback voting aye. Have all members voted? Ms. Rose voting nay. Have all members voted? Have all members voted? 81 ayes, 55 nays. The motion to table prevails. Following amendment, clerk will read the amendment.
Amendment by Howard.
Chair recognizes Ms. Howard.
Thank you, Mr. Speaker. Members, this is similar to the previous amendment, though in this case, we're asking that one of the members of this Nutrition Advisory Committee be a licensed nurse who has received a certification or specialty training in nutrition, which actually is an avenue that a registered nurse can take, where you get additional training to get certified as a nutrition nurse. I think that has already been laid out, and I appreciate what Chair Hull has done here in terms of trying to create something that will help us get to a healthier lifestyle. I think we all want that. There's a lot in here that's good, but I think all the amendments we're hearing are just trying to make things better, take advantage of this opportunity to
Ms.
insert
Gervin-Huggins,
things
for what
that would
purpose?
make this.
Mr. Speaker, will the gentlelady yield
Generally yield for questions?
Yes.
She yields for questions.
Thank you, Representative Howard. You know, as a nurse, one of the things why this dietitian or someone who knows food is so important, because there's so many people on medications now, correct?
Yes, there are.
And there may be some unintentional consequences or some interactions that may be fatal to some people if you don't have a subject matter expert involved in saying if this is okay. Would you agree with that?
That could be the case. I know there are some healthcare professionals that are included on this, but it does not include the dietitian. It does not include a nurse.
And the difference between a dietitian and a nurse, along with the individuals that are listed there, would be what? What can they add? The dietitians and the nurse.
This amendment is not about the dietitian, though. Of course, that person has a unique specialty in that area and has unique expertise. Nurses, of course, also, if they have the additional 1,000 hours of training to become a nutritional nurse, would actually have very specific information, in which, of course, this bill is suggesting that all students are supposed to have this kind of education right now. This is somebody who's gone above and beyond that to get additional expertise and training. So it would be very valuable information as they're trying to determine what the guidelines are going to be and what the recommendations are going to be coming from this advisory committee.
Great. Thank you for that, Representative. It's a great amendment. Thank you.
Thank you so much. I move adoption.
Ms. Hull in opposition.
Thank you, Mr. Speaker. Members, this is not a medical advisory committee, and I don't want to tie the hands of the governor. Again, the language in this advisory committee has been very heavily negotiated. Several of them are they're intentionally not specific. So someone that was just described could be one of these positions. So I have to move to table.
Ms. Howard to close.
Thank you. I just once again will say that I think it would be important to expand the knowledge base of who's going to be on this advisory council, and I would move to vote against the table. Thank you.
Ms. Howard sends out amendment. Ms. Hull has moved to table. The questions on the motion to table. Record vote. Clerk ring the bell. Show Ms. Hull voting aye. Dr. Alverson voting aye. Have all members voted? Mr. Hopper voting aye. Have all members voted? 85 ayes, 54 nays. The motion to table prevails. Following amendment, clerk will read the amendment.
Amendment by Manuel.
Chair recognizes Mr. Manuel.
Thank you, Mr. Speaker and members. This is an amendment that basically makes sure that if someone is a social media influencer and 33% of their income comes from these kind of social media platforms where they're getting money, they can't be a part of the advisory board. We know that there are people like the Liver King who told people to eat raw meat and it was going to make them stronger and more hype, and found out he was on steroids. We had Bella Gibson, who was telling people that she had a brain tumor, or brain cancer, excuse me, and she was telling people to eat healthy. She had this app. There are documentaries on all of these. We put people's lives at risk. This is just to make sure that they're not a part of this system where they're able to influence, since they are already profiteering off of this. I hope you all support me on this amendment. Appreciate you. Move adoption.
Ms. Hull in opposition.
Thank you, Mr. Speaker. Members, this is already addressed in the bill. An individual must disclose all existing affiliations with a food, beverage, dietary supplement, or pharmaceutical manufacturing company or any other affiliations that could reasonably create a conflict of interest. So I cannot take this amendment because it already exists in the bill. And also, in the bill, it talks about no income is allowed. This amendment is 33%, and the bill is 0 to make sure there are no conflicts of interest. So I have to move to table.
Mr. Manuel to close.
I close.
Mr. Manuel sends an amendment. Ms. Hull has moved to table. Record vote on the motion to table. Clerk, ring the bell. Show Ms. Hull voting aye. Dr. Alverson voting aye. Mr. Hunter voting aye.
Don't stand that one.
Ms. Goodwin voting no. Have all members voted? Have all members voted? 83 ayes, 54 nays. The motion to table prevails. Following amendment, clerk will read the amendment.
Amendment by Goodwin.
Ms. Goodwin.
Thank you, Mr. Speaker. Members, this amendment would simply require the committee to examine the effects of harmful pesticides and chemicals used in the production or development of ultra-processed foods on human health. The Environmental Protection Agency regularly evaluates pesticides to determine the risks they pose to our health and well-being. According to the EPA, pesticide exposure can lead to both acute and chronic health problems, ranging from skin or eye irritation to cancer, neurological disorders, hormonal issues, and reproductive health issues. The agriculture industry is a major economic driver in Texas. Farming and ranching operations can be found in every corner of the state, from citrus crops in the Rio Grande Valley to cotton in the High Plains. And in between, there are rice paddies in the coastal plains, sheep and cattle ranches in West Texas, and timber harvesting in the piney woods of East Texas. In 2022, Texas's agriculture industry generated almost $25 billion in cash receipts, representing the 4th largest share in the country. Given the significance of this industry in Texas, I believe the Texas Nutrition Advisory Committee should look at how pesticides can impact our health. This is well within the scope of their mission and would provide Texas farmers with information to determine which pesticides to use. I move adoption.
Ms. Hull in opposition.
Thank you, Mr. Speaker. Members, I think you all heard my speech earlier on this topic, and I very much appreciate what Representative Goodwin is doing here. And while I do agree that is unfortunately not what this bill is about, and so this is a conversation for another day and another session, so I have to move to table.
Ms. Goodwin to close.
Thank you. Members, this bill is about our health. It's about the health of our children. It's about how food that we eat impacts our health. And the food that we eat that has chemicals and pesticides on it definitely impacts our health and our children's health. So members, I don't know why the author would say that this doesn't apply to the bill, why it's not pertinent to the bill, because it absolutely is, and I move adoption.
Ms. Goodwin sends up an amendment. Ms. Hull has moved to table. The question is on the motion to table. Clerk, ring the bell. Show Ms. Hull voting aye, Ms. Goodwin voting nay. Ms. Flores voting nay. Mr. Alcott voting aye. Have all members voted? Have all members voted? 86 ayes, 49 nays. The motion to table prevails. Following amendment, clerk will read the amendment.
Amendment by Flores.
Ms. Flores.
Thank you, Mr. Speaker. Members, if we're serious about nutrition, we cannot ignore food access. SB 25 creates new state standards for nutrition and wellness, but what good are those standards in communities where fresh food is nowhere to be found? This amendment ensures we identify and examine food deserts across Texas and make evidence-based recommendations to solve them. Members, this is about market access. Many Texans want to eat better, but live in areas where the free market hasn't followed. This is especially true for my rural communities and my community of Del Valley. Let's use data to empower communities with better tools, not mandates, to attract grocery stores, farmers markets, and food entrepreneurs. Residents in food deserts face higher rates of obesity, diabetes, and other chronic illnesses, which increases state Medicaid and emergency room costs. Addressing food insecurity upstream is fiscally conservative and smarter than dealing with expensive health crises downstream. Whether you're in Central Texas or East Texas, you should have a fair shot at putting fresh food on the table. We talk about protecting families, but families cannot thrive without reliable access to nutritious food. This amendment upholds Texas values by protecting the health and dignity of our children, seniors, and working parents. The Texas Nutrition Advisory Committee is already tasked with developing guidelines. This amendment simply asks them to study food deserts and suggest solutions. It's a low-cost, high-impact addition that strengthens SB 25 and shows we're thinking ahead. Thank you, Mr. Speaker, and I move adoption.
Ms. Hull in opposition.
Thank you, Mr. Speaker. Members, I understand and share the concern of food deserts. That's just not what this bill is about. This bill is about the dangers of ultra-processed food, so I have to move to table.
Ms. Flores to close.
This food is about good nutrition and good, healthy food, and my communities do not have access. It has
Wu, for
everything
what
to do with
purpose?
this. Yes, I will yield.
Would the lady yield for questions?
General yield for questions. She yields
I
for
will yield.
questions.
President Flores, your bill, your amendment is exactly the point of this bill, because in those food deserts, without access to grocery stores, without access to fresh fruits, fresh meat, what do people end up eating?
Junk food. They have Dollar Trees and you know, those kinds of stores, convenience stores that they have to resort to buy food at times because they have to drive all the way into town to be able to buy fresh food.
And we're talking about communities that many people don't have vehicles. People ride the bus, they ride their bike. Taking the bus an hour or half an hour one way and half an hour back another way to go grocery shopping, people just, they can't do that. They won't do that.
That's
right?
exactly right. And here in my community, we've been trying to attract, and we are making headway, but it's taken forever to try to get a good grocery store that has fresh food and produce available to the citizens of Del Valley.
And in fact, when people don't have access to proper grocery stores or even farmers markets or anything of that sort, they end up doing most of their shopping at the convenience store, correct?
Well, they have to do that because it's a real hassle to try to, you know, you get out of work and you want to put food on the table and you don't have things, so you're going to resort to junk food, drive-thrus, whatever, just to get something for your kids.
Yeah. And a lot of times those convenience stores, they say, oh, we have fresh fruits and vegetables, but they have like a banana and a avocado, right?
Yes, and if they're even good at that.
And a lot of times those are just, they're already rotting.
Right. So this is a problem, and I think this group this advisory committee would be a perfect opportunity to address the issue and look at food deserts and see where communities do not have access to fresh food.
And in fact, contrary to what Representative Hull has said, this amendment, this food scarcity issue is one of the core reasons that have been identified for childhood obesity.
It is, and it's a real problem, and it's happening right here in Southeast Travis County.
In fact, there are studies that have shown that in food deserts, in places where children do not have access to healthy foods, do not have access to groceries, that the rates of diabetes, the rates of cancer, the rates of all the things that Representative Hull has talked about in her layout, those are much higher in food deserts, are they not?
They are. They are.
So in fact, I want to be very clear. Your amendment, despite her words, your amendment is exactly on point with this bill, is it not?
It absolutely is, and I appreciate your comments and your questions. And members, I ask that you please table the, vote no on the motion to table.
Ms. Flores sends up an amendment. Ms. Hull has moved to close. The questions on the motion to table. Record vote. Clerk, ring the bell. Show Ms. Hull voting aye. Ms. Flores voting nay. Have all members voted? Ms. Jones voting nay. Mr. Alders voting aye. Have all members voted? Have all members voted? 84 ayes, 55 nays. The motion to table prevails. Following amendment, clerk will read the amendment.
Amendment by Jones of Harris.
Mr. Speaker, members, the amendment I've offered is simple. It says that before the advisory committee created in this bill turns in its report, it has to hold at least 4 public hearings. That's it. We're making decisions in this bill that will directly affect the food people can access in Texas. And that's especially serious for Texans living in food deserts, as you just heard. Places where corner stores or small grocery stores are the only option. These families already face limited choices. And if those stores remove products or shut down to avoid penalties under this bill, we're leaving people hungry and their children hungry. My amendment gives those communities a voice. It doesn't cost money. It doesn't delay the bill. It just ensures that the people we're trying to help, families, small store owners, parents, have a chance to speak before the committee finalizes its recommendations. We should not be passing policies about public health and nutrition without hearing from the very people who will feel the impact first, the public. I respectfully move adoption of the amendment and ask for your support. And to the extent the bill's author does not accept the amendment and moves to table, I ask for you to vote against the motion to table.
Ms. Hull.
Members, I have to move to table this amendment. The statute that creates the Sickle Cell Task Force does not include required public hearings, but they do post information on the public meetings on their website to discuss their annual reports to those meetings. This would be a very similar advisory committee, so I have to move to table.
Ms. Jones to close.
I respectfully disagree that the Sickle Cell Task Force is the same as this task force. Sickle cell is killing people. It's just different. And as a person who grew up not always having food options and with a mother who had a car sometimes and didn't have a car other time, getting to the grocery store was hard. And I'll say that again. We take things for granted here. Because we can go to the grocery store, because we can afford to get there, we think that everyone can. Everyone cannot. And at the end of the day, if you don't have money to get to a grocery store that has healthy food options, rather than have your children starve, you're going to buy them the food that's available to you, which unfortunately might be around the corner. But the other option is just to starve people to death. And I think that it is a lack of respect to the people that we're purporting to help to decide that we know what's better for them than to have them actively come to a public hearing and actually tell them their issues with it. And also, as a kid who grew up with a mom who didn't have enough money to even come to my after-school activities because she was too busy working overtime to try to get money, make money, to pay rent, to buy food, I'm certain my mother wouldn't have been paying attention to any public notice, assuming we had electricity for internet to know what's going on for any public notices. So I think there are things that this body may be taking for granted that actually don't exist. So I respectfully ask for you to vote against this motion to table, because I don't need people who have no idea and who have not walked in my shoes to tell me what's best for me and how I feed my children.
Ms. Jones sends up an amendment. Ms. Hull has moved to table. The questions on the motion to table. It's a record vote. Clerk, ring the bell. Show Ms. Hull voting aye, Ms. Jones voting nay. Have all members voted? Have all members voted? 86 ayes, 55 nays. The motion to table fails. Following amendment, clerk will read the amendment.
Amendment by Curry.
Mr. Curry.
Thank you, Mr. Speaker. Members, what this amendment does is take this food labeling piece to a study and let us try to understand what's really happening with these chemicals. There are 52 chemicals originally listed in this deal, and through a couple of amendments today, some have been removed. It certainly wasn't lost on me that a couple of the chemicals were ag chemicals that are used in the field that have never been food additives. It certainly wasn't lost on me and several of the constituents out there and stakeholders, as they've been discussed before, that such as saccharin, that was removed because evidently a stakeholder wanted that out. But when you have big stakeholders throughout this state, and none the least of which are Farm Bureau and HEB and some of the Cisco Foods and so many of these that have not been able to be at the table, then why? Why are they not at the table, and why can we not have discussions with them? And I will tell you that this is a serious issue. These are serious. These may or may not be serious chemicals, but they need to be studied. We don't want to make policy based upon guessing. We don't want to make policy based on what somebody else said or opinion. We make our policy based upon facts and the best facts we can find. If we're going to put food labels on a huge industry in Texas that doesn't want this, Waco, Texas, where I'm from, is the home of Dr. Pepper. It's the home of Big Red. We have a huge M&M Mars manufacturing facility there. They haven't been at the table. I know, Ms. T, you hadn't gotten any candy from my district, and we'll work on that. You hadn't been over by the desk lately. But I do have to say that when you look at these stakeholders and what it really means, and look at the labeling stakeholders that are out there as well, I have to tell you, we have got to think about what we're doing. And we've got to think hard about how to do this the right way. And so I stand before you to say, look, I don't have a problem. I want to make Texas healthy again, but I do not want to hurt Texas business.
Mr. Speaker.
We are in business to do business. We're in business to attract business, and I don't want to hurt Texas business. So I'll tell you, we need to do the right thing here, pass this amendment to make this part a study. It's a huge bill. It's an omnibus bill that we need to be careful about and do the right thing with this part of the bill and make it a study.
Mr. Wu, for what purpose?
Will the gentleman yield for questions?
Gentleman yield for questions?
Yes, sir.
He yields for questions.
Representative Curry, at the beginning of the layout, did you hear the bill author say that Bluebell was carved out of this bill?
I did.
Where is Bluebell located?
They're in Brenham, Texas, sir.
Okay. Whose Senate district is that?
I believe that's the author in the Senate, but I think that
Thank you very much.
encompasses that.
Mr. Speaker.
Mr. Canales, for what purpose?
The gentleman yield for questions.
Gentleman yield for questions?
Yes, I do.
Yields for questions.
So one, I'm going to tell you I appreciate your amendment because this is an omnibus bill and it's going to affect Texas businesses, as you said. Is that what you believe?
Yes, I do.
Now, are you aware that a bill this size didn't get heard in the full committee?
I was made aware of that late this afternoon, yes.
Are you aware that a bill this size only got heard in the subcommittee?
I was not made aware of that necessarily, but I believe you if you say that.
So there was no full committee hearing on this bill, and we're going to now impose all these rules, regulations. I'm almost think I was going to file an amendment, call this the Michelle Obama bill. But are you aware that all these businesses are going to be affected by this bill?
I am aware that a lot of businesses are going to be affected by this bill, and again, I think that if you're going to do something this big, that you have the education piece, you have the higher education piece, and I don't disagree with more exercise and making people more aware about situations. What my problem is that putting the kind of strong labeling that we're doing on Texas business, and are we still attracting business with this, or are we trying to run it out?
I support your amendment, Representative Curry. I think it is reasonable. I think it's sensible, and I think it's a good start, and thank you for your hard work.
Thank you, sir. Appreciate that.
Does the gentleman, Mr. Speaker?
Ms. Harris Davila.
Does the gentleman yield for questions?
Gentleman yield for questions?
Yes, ma'am.
He yields for questions.
Thank you. I appreciate that. And I just wanted to clarify something. Are you aware that the author of the bill mentioned that she had worked with Bluebell, but that she did not say they were carved out of the bill?
Yeah, I didn't say that they were carved out. I said I didn't. I just know that Bluebell was one of them that was a stakeholder that ended up at the table, and I know a lot of stakeholders did not.
I totally understand. I just wanted to make that clarification. And then my second question, if a business does not have these ingredients in their food, many of which we're already banning in school lunches, they're already going to be required to comply with the law. If these ingredients are not in the food, they will not have to comply with the labeling piece anyways. Is that correct?
I do understand it that way. I think the question is whether there's derivatives of them or not, and honestly, whether the list is complete and accurate, and whether we should be making law by using something that we haven't had a broad enough opportunity for the stakeholders to be involved with.
Well, I appreciate your concern, and I'll just add I've had a lot of conversations with stakeholders on my bill that I coordinated with Senator Hughes on, with making our school lunches healthy again, and I am more than happy to provide you with the studies that go through these ingredients and why we need to label them and how harmful they are. Thank you for answering my questions.
I appreciate that. Thank you. I move passage or adoption.
Ms. Hull in opposition.
Thank you, Mr. Speaker. Members, where do I start with the flat out half-truth, mistruth, and lies that were just spread? Bluebell is not carved out of this bill, and to insinuate what was just insinuated here is incredibly wrong. Actually, they have been working, because of this bill, have started to work to already remove some of these chemicals from their products, and they are still unhappy with the list that is in the bill. So to say that Bluebell is carved out is a flat-out lie. Also, the entire committee voted on this bill, and I, along with Senator Kolkhorst, have been working this entire session to talk to members and stakeholders. So to pretend like nobody has any clue, also this is probably one of the most heavy lobbied bills, so to pretend like nobody has any clue is absolutely ridiculous. Now, this amendment to turn it into a study. I believe the study has already been done. It's been done on our children and on the American people for decades. And based on the state of our nation and our state's health, I would say we already have our answer. We don't need to do a stupid study. The study has been done on the American people. I move to table.
Mr. Curry to close.
I don't believe that getting the facts straight is stupid. And I do believe that bringing the stakeholders to the table in a reasonable amount of time is smart. And I think that's the responsible thing for us to do. And I appreciate all the hard work to make Texas healthy again. I certainly want that as well. I just want to do it the right way. So I move passage of the amendment.
Please excuse Mr. King because of state affairs business on motion of Mr. Guerin. His objection, chair, is none so ordered. Mr. Curry sends up an amendment. Ms. Hull has moved to table. Questions on the motion to table. Record vote. Clerk, ring the bell. Show Ms. Hull voting aye. Mr. Vasut voting aye. Mr. Little voting aye. Ms. Isaac voting aye. Show Mr. Hefner voting aye. Ms. Flores voting nay. Have all members voted? Have all members voted? 49 ayes, 87 nays. The motion to table prevails. Mr. Curry on the amendment. Ms. Gonzalez, for what purpose?
Mr. Speaker, I raise a point of order against further consideration of Senate Bill 25, Rule 4, Section 18, and 4, Section 32 and B9 on the grounds that the committee minutes are inaccurate.
Bring your point of order down front. Chatsline, for what purpose?
Mr. Speaker, parliamentary inquiry.
State your inquiry.
Mr. Speaker, are you aware that there is a bill, SB 20, a bill that's going to save tens of thousands of babies' lives that's being held up by State Affairs Committee right now?
Parliamentary inquiry, Mr. Chatsline.
Mr. Speaker, parliamentary inquiry.
We're in the middle of a point of order. When we get down to the point of order, you can return to the back mic for parliamentary inquiries.
Yes, sir.
Point of order has been withdrawn. Mr. Hunter for a motion.
Mr. Speaker, I move that the House grant permission for the Committee on Calendars to meet while the House is in session today at 7:30 p.m. in room 3W9 to consider a calendar.
Members, you've heard the motion. Is there objection? Chair is none so ordered. Following announcement, clerk will read the announcement.
The Committee on Calendars will meet today at 7:30 p.m. in room 3W.9 in a formal meeting to consider a calendar.
Anyone wishing to speak on, for, or against the Curry Amendment? Ms. Hull, in opposition to the Curry Amendment.
Members, once again, our children and the American people have been the study. This amendment guts the entire bill and the purpose of the entire bill. I know the lobby is right outside those doors. I know the lobby, the big food lobby, is the one who brought this amendment. They are terrified of labeling. This is not anti-business that they are trying to make it out to be. This is pro-transparency, pro-consumer. We have had enough. Kids are sick, American people are sick, Texans are sick. That has been the study. Please vote no.
Members, strict enforcement has been requested on the amendment. Mr. Curry to close.
Mr. Speaker, members, just to be very, very clear, I am definitely for making Texas healthy again, but I'm for making good policy based on good decisions. And this, in my opinion at least, it does not gut the bill at all. If the whole bill is about food labeling, then they should have done a bill on food labeling. This bill has all kinds of educational components. It has all kinds of education requirements on it, even higher education requirements on it, and then a food labeling section that starts on page 8 or 9, maybe 10. I'd have to look and see. But the fact is that by taking this into a study, we can get down to this piece of it into a study. We can get down to what's real. We can get down to what's true and what we should be making law based upon. So make good decisions based upon good information that's factual, that has all the stakeholders involved. I move passage.
Members, again, strict enforcement has been requested. You can vote from your desk. Clerk, ring the bell. Show Mr. Curry voting aye, Ms. Hull voting no. Have all members voted? Have all members voted? Have all members voted? Strict enforcement has been requested. Have all members voted? 53 ayes and 62 nays. The amendment fails. Following amendment, the clerk will read the amendment.
Amendment by Van Dever.
Mr. Van Dever.
Thank you.
I don't either. Mr. Canales, for what purpose?
Parliamentary inquiry.
State your inquiry.
Are you aware there's a senator threatening to kill everybody's bills that's on that vote sheet?
Chair is not advised. Mr. Van Dever.
Thank you, Mr. Speaker. Members, let's take the temperature down a little, and I want to first of all say that I am supportive of this bill. I'm a joint author of this bill, but in my opinion, there is a little fix that needs to be taken care of in the bill. This amendment is a preemption amendment. It relates to the food labeling section of the bill. The bill has a long list of ingredients and additives. I don't know if you've seen the bill or not. On pages, on mine it's on page 10, 11, and 12, a lengthy list. And I'm not arguing with that list, but basically saying that any food product that contains those ingredients or additives, it has to be stated on the label. I support that totally. And this amendment is not about removing any of those ingredients or additives from that list. But the concern that I'm bringing is we know that President Trump has made it clear that he intends to roll out MAHA initiatives at the federal level. This amendment simply makes it clear that if the Trump administration does that, if we see federal regulations come out that deal with any of these ingredients or additives, then the federal regulation overrides the state regulation in SB 25. To be clear, if this bill passes, it will be the law of the land in Texas, and that's great. And if the federal government does nothing, it will still be the law of the land in Texas. But if the federal government enacts other regulations that affects this, we don't need conflicting labeling on our food products. I agree, we want to be very clear when we're labeling our food if there are chemicals in it or additives or ingredients in it that could be harmful or unhealthy. But I think one of the worst things we could do is have such a lengthy label or have two labels that are conflicting with each other that's only going to confuse the consumer. That's what this amendment is about. It's simply saying we're only going to have one food label. It's going to be very concise and clear, and it's going to inform the decisions of the consumer. And that's really the goal of this bill, and that's the goal of this amendment.
Does the gentleman, Mr. Speaker,
Harris Davila, for what purpose?
does the gentleman yield for questions?
Gentleman yield for questions.
I yield.
He yields for questions.
Thank you. I appreciate that. I just have a few clarifying questions on the amendment.
Sure.
My first question is, would this be giving state power over to the federal government in any way? Would your amendment be doing that in any way?
No, this does not give the state any power over the federal government.
Or I was asking in reverse, sorry.
Okay.
Giving the federal government more power over the state of Texas.
No, we have preemption in a lot of areas. You know, if the federal government enacts legislation that is in conflict with state law, that's not unusual. And again, you know, the key is to streamline and to be very clear, to clarify the label. That's the ultimate goal.
Gotcha. And then just another clarifying question. In your amendment, it says that a federal law, regulation, or guidance issued by the United States Food and Drug Administration or the USDA could have an effect on this list of ingredients. Can you give us a little more just background on what does it mean by guidance? I know, you know, obviously federal law is something that Congress would enact, but when we're talking about guidance, what exactly would that look like if for an agency to issue guidance on something?
Well, I mean, it could be FDA, it could be USDA, you know, it could be, you know, it's not unusual. You know, we know that RFK is very involved right now in trying to help us, you know, have healthy food, and so, you know, it could be something from the FDA, but, you know, it could be any of those things.
So are you aware that a mid-level bureaucrat in either of these agencies could issue guidance and that they could do so within a month if they wanted to?
I certainly don't think that is the intent of this amendment. I don't believe that we would envision that, as you say, a mid-level bureaucrat would be able to. I would assume that if it comes out of the FDA, that the secretary of that agency is going to know what's coming out.
Well, I have some more details on the guidance section, but I just also want to get clarification. If the Food and Drug Administration or the USDA says that one ingredient on this list is not bad, then does that make the entire ingredient list moot under your amendment?
No, it does not. And I don't envision the Fed saying that one ingredient is not bad. You know, what I envision would be that you know, different levels might be required, different labeling, you know, formats might be required, but no, each ingredient and each additive would stand on their own.
Could you understand a concern that a mid-level bureaucrat could put out guidance on all of these ingredients before this law even goes into effect, making this law completely moot by its effective date in Texas?
You know, I don't see that as a possibility. I mean, we can run with all kinds of theories of, people, that people might be bad actors in some way, but I really don't think that's a realistic concern.
Are you aware that the state of Texas has passed different regulations that are outside of USDA regulation and FDA regulation when it comes to all sorts of food-related things like custom meat processing?
I'm not advised.
Are you aware that in Texas, we do permit custom slaughtering of livestock for personal consumption, but the USDA does not? Are you aware of that?
I don't know that that's an accurate statement. I believe that as long as USDA inspects for human consumption and for retail sale, I believe that is all that's necessary.
Okay, I've got the law right in front of me. Are you aware that the FDA has oversight over certain other food and safety labeling standards, but that this body passed a law earlier this session preempting Texas from having to obey those regulations that the federal government put in place?
Not advised.
Are you concerned that this might conflict with the Healthy Texas Food bill that we already passed that bans some of these ingredients from being put into school lunches? And are you concerned that this create a patchwork of what ingredients Texas allows, what ingredients should be labeled, what we're banning, what we're not, based on, again, just some guidance from a mid-level bureaucrat in Washington, D.C.?
No, I think what this amendment does is actually prevents the patchwork and prevents the confusion that might come with different labels where one is, banned and one is not banned, and different level. What this amendment is doing, let's be very clear, what this amendment is doing is clarifying what must be on the label. It's clarifying that food products only need one label, and it's helping the consumer make healthy decisions, which is the spirit of this bill.
All right, I'm looking at the language of the amendment, and I just want a little bit more clarification. So it says that section 431.0815 has no effect if for a specific ingredient, so one ingredient, is determined safe by the FDA or the USDA. To me, that reads that if just one ingredient on that list is considered safe, then section 431.015 has no effect, and that's the entire section with all of the ingredients.
No, I don't believe that is the case. I don't believe that's an accurate interpretation of the amendment.
Okay, well, I'm reading it, and I appreciate you answering my questions. Thank you.
Sure.
Mr. Darby, for what purpose?
Will the gentleman yield for a couple of questions?
Gentleman yield for questions.
I yield.
He yields for questions.
Representative Mandeeper, I know our time is limited here, but what's the practical effect of your amendment?
It brings clarity. As I said, we know that the Trump administration is coming out with healthy standards and a MAHA from the federal level. The goal of this amendment is to bring clarity to the labeling process. It's to allow food manufacturers to have some certainty when they're labeling these food products that they're not going to have to choose between a state requirement and a federal requirement and choose which one they're going to disobey. And furthermore, it's to make the labeling very clear for the consumer. We cannot expect consumers to read through 2 or 3 labels on. Think about when you get a prescription from the pharmacist and you get this long list of all of these warnings and side effects. Nobody reads those. The label needs to be very concise, very clear, and to help allay some of this confusion that we see with consumers.
Does this amendment remove any labeling requirements that already exist in Senate Bill 25?
Absolutely not. This does not remove anything that's in Senate Bill 25. Again, I am a joint author of Senate Bill 25. I support Senate Bill 25. I commend Senator Kolkhorst and Chair Hull. Texas is leading the nation in trying to make our citizens healthy again. And we,
Thank you.
The gentleman's time has expired. Ms. Hull in opposition.
Thank you, Mr. Speaker. Members, I have to oppose this and ask to move to table. The White House, I've spoken with them. They want this bill. They want the states to act. The entire point of this bill is because of decades of federal inaction. I'm hopeful the feds will take action. They have already started banning some food dyes, in which case they wouldn't have to be labeled in this bill because they would not be allowed to be in the food itself. So therefore, the label would not apply. I know the HEB who brought this amendment only sells in one state, so they aren't worried about a patchwork regulatory environment. In fact, they comply with the Mexican government requiring them to add warning label stickers to everything they ship into Mexico from Texas. They can do it for Mexican citizens, so they can do it for Texans. Federal preemption is another attempt to kill this bill and prevent it or any change from happening, just like they've done in DC for years. I know that ending federal overreach is an RPT platform issue, but again, this is a bipartisan issue. Democrats and Republican parents are sick and tired of this. This amendment is Texas giving our rights away to DC. None of us ran for office to take direction from congressmen in Chicago, New York, Seattle, San Francisco. Texas is not waiting. That's why I brought this bill. I move to table.
Mr. Van Dever to close.
thank you, Mr. Speaker. Members, I hope this bill becomes law. And as Chair Hull said, the White House is very interested in this, and they take this to Washington and they just make this theirs. If that's the case, this amendment does absolutely nothing. This amendment is about bringing clarity in case it does get there and Trump decides he wants to change something and now we have conflicting regulations. Members, I ask you to stay with me on this and vote two on the motion to table.
Mr. Van Dever sends up an amendment. Ms. Hull has moved to table. The question is on the motion to table. It's a record vote. Strict enforcement has been requested on the remainder of the amendments. Clerk, ring the bell. Have all members voted? Have all members voted? "53 ayes, 76 nays. The motion to table fails. Anyone wishing to speak on, for, or against the Van Dever amendment? If not, Van Dever to close. Or Ms. Hull?
Members, once again, this undoes the bill. The language, part of the language undoes it. The other part is completely unnecessary. If an ingredient is banned by the federal government, it cannot be in any of these food items. Therefore, the label would not apply. If the federal government creates their own label, that automatically preempts our label. Once again, the White House wants this. They would not want something that is sitting here going to create all of this discussion of this patchwork and all of that. They know that if they create a label, it preempts ours. Please vote no. The rest of that part of the amendment guts the bill.
Mr. Van Dever.
Members, in all due respect, and I truly mean that to Chair Hull, I do not see how this amendment guts this bill. This is simply bringing clarity to our food labeling process. Therefore, I ask you to vote yes on this amendment. Thank you.
Question occurs on the Van Dever amendment. It's a record vote. Strict enforcement members. Clerk, ring the bell. Strict enforcement. Have all members voted? Have all members voted? 79 ayes, 48 nays. The amendment is adopted.
Mr. Speaker.
Ms. Doorkeeper,
Mr. Speaker, I have a messenger from the Senate. The door
admit the
passed.
messenger.
Thank you.
Following amendment, clerk will read the amendment.
Amendment by Curry.
Mr. Curry.
Mr. Speaker, members, this is simply a clarifying amendment. It does not gut the bill. It does not change the intentions of the bill. It simply ensures that the restaurant supply chain, wholesale and commercial restaurant food products remain exempt from labeling requirements. And just to be clear, the reality is they're not in that business, and it's not clear in the bill as to how this should be handled. And consequently, again, it just needs to be dealt with and clarified, and I vote for this amendment.
Ms. Hull in opposition.
Members, restaurants are already exempt from this bill. Anything that a restaurant gives out is exempt. If a distributor opens up a wholesale retail store, then there isn't much difference between them and Costco. So I am not going to take an amendment that could create an entire giant loophole in this bill. Again, restaurants and anything that restaurants give out are exempt. And the lobbyist that brought him this knows it. I'm not allowing a loophole to be created. Please vote no.
Mr. Curry to close.
Members, without this amendment, some distributors who are not manufacturers will be inadvertently pulled into labeling requirements in SB 25. I strongly suggest that you approve this amendment. It's a clarifying amendment. It's very simple. It was discussed before, and for some reason, they just don't want to talk about it. I'm telling you, please accept this amendment. I vote adoption.
The question is on the Curry amendment. As a reminder, strict enforcement on all of the amendments. You can vote from your desks. Clerk, ring the bell. Have all members voted? Have all members voted? 58 ayes, 71 nays. The amendment fails to adopt. Following amendment, clerk will read the amendment.
Amendment by Jones of Harris.
Ms. Jones.
Mr. Speaker, members, this amendment is what I call the Food Desert Mitigation and Delayed Enforcement and Support of Communities in Food Deserts Amendment. The purpose of this amendment is to make sure we don't unintentionally harm the very people this bill says it wants to help. It protects families living in USDA designated food deserts. Mr. Speaker, I can't hear.
Members, take your conversations outside the rails.
The purpose of this amendment is to make sure we don't unintentionally harm the very people this bill says it wants to help. It protects families living in USDA designated food deserts from immediately losing access to the limited food they can get simply because those foods may not meet the new labeling requirements. Members, here's the reality. It costs more money to buy healthy food. Poor people often don't have that money. And not only do they not have the money, they don't have grocery stores in their neighborhoods. That's why they're called food deserts. And on top of that, they don't have transportation to get to the grocery stores that do carry healthier food options. So when this bill removes the food they can afford and access and tells them to go somewhere else to buy something healthier that costs more, we're setting them up and their families for failure. We're forcing people to chase food they can't afford, can't find nearby, and can't get to. Let me be clear. While I believe the aspirations of this bill are noble, they are not realistic for Texans living in food deserts. This amendment ensures that, number one, the department identifies food deserts using USDA data. Number two, retailers in those areas receive technical assistance and grants to comply with the new law. Number three, the state works on a plan to preserve food access, not just enforce penalties. Number four, there's a short grace period until January 1st, 2028 for these specific areas to come into compliance. And it still allows the Attorney General to enforce the law everywhere else. This is not a loophole, this is a lifeline. Without this amendment, we are punishing the poorest Texans and their children for being too poor to comply with our policy vision, too isolated to reach a grocery store, and too under-resourced to meet a mandate they had no say in. I move adoption to this amendment, and if the bill's author moves to table, as she has with the other amendments, I respectfully ask that you vote no on the motion to table.
Ms.
Vote to
Hullen,
protect working families, vote to protect hungry kids. Please vote for this amendment.
Ms. Hull in opposition.
Thank you, Mr. Speaker. Members, and again, I know this is the second amendment on food deserts, and while I understand and I share those concerns and know that those need to be addressed, that is not what this bill is about. That is not germane, and so I ask that you please vote to table this amendment.
Ms. Jones.
Actually, it actually is germane. And I ask for you to vote no on the motion to table. Thank you.
Question occurs on the motion to table. Record vote. Strict enforcement has been requested. Clerk, ring the bell. Have all members voted? Have all members voted? 79 ayes, 51 nays. The motion to table prevails. Anyone wish to speak on, for, or against Senate Bill 25? Mr. Wu in opposition. Collier, for what purpose?
Mr. Speaker, I raise a point of order on CSSB 25 under House Rule 8, Section 1A1 and House Rule 8, Section 1B, because the caption fails to provide notice of a fee.
Bring your point of order down front. The point of order has been withdrawn. Mr. Wu in opposition. Please excuse Representatives Canales, Gerties, Harris, Hernandez, Hunter, Johnson, Leach, Lopez of Cameron, Romero, Rose, Tepper to attend a meeting on the Committee on Calendars on motion of Mr. Vasut. Is there objection? Chair is none so ordered.
Thank you, Mr. Speaker. I don't relish speaking against this bill. I actually had high hopes for this bill when it was announced, because some of the issues, especially dealing with chemicals, dealing with additives, are things that are important to me. And I've talked about those issues for a long time. What I did not expect was that this bill would turn into such a beast, that there would be so many musts and shalls just jammed down everyone's throats. If you look at all the things that are in this bill, a requirement that schools do this and that, without providing any additional funding, saying you have to go back to this, you have to provide extra time. What happens to that time? The students right now are already short on time to study. We talk about how much time they spend on testing. If we pull an extra half an hour from here and there, where does that come out of? There is a set amount of time students have every day. Students have to make choices on what they take. And we say, well, don't worry about it, just do it. The fiscal note does not even dig into what the school districts have to do. In fact, the fiscal note says, well, there will be a local impact because the schools will have to implement all this stuff, but we don't know how much it's going to cost. We don't know how many employees they're going to have to devote to this. We don't know how much classroom time they're going to have to do to take care of it, but they have to do it. The bill, before we fixed it, had a requirement that every single college student must take this course. That is incredible. It's beyond what I imagined. But at the same time that this bill goes too far, at the same time, a lot of it that is in here does nothing. The formation of this committee, if you look on page 8 and 9, you look at what this committee is designed to do, what they're supposed to do. It's supposed to provide an independent review of scientific studies analyzing the effects of ultra-processed foods. No need. I've done it for you. A 5-minute Google search will provide you with every scientific study on this topic. And then it says, well, we need to develop understanding of all these studies and see what all these studies, no need. Here it is, right here. A comprehensive meta-study of all the other studies and data sets saying what the results are. Point 4 says, hey, could you provide us nutritional guidelines on what we're supposed to do? What does the FDA do? Those guidelines have been out for decades. What's the point of this committee? That I've done all the work that's detailed in here with the Google search. And here's what's most frustrating to me. The things that actually affect childhood obesity, that actually affects the things that Representative Hull has talked about, those things are being ignored. Twice during this debate, members offered amendments about food deserts. If you know anything about this policy area, food deserts are one of the top items of why there is an epidemic of obesity across our nation. Because poor communities have no access to non-processed foods. Because those communities have no access to grocery stores. They have no access to good fresh meat, seafood, vegetables, fruits. So what do they eat? They eat trash. They eat junk food. They eat whatever they can buy for 75 cents, for $1.65. You know what those things are. You buy them on the way home. You feel guilty about eating them. But imagine if that was your diet every single day. That is significant for our children. There's teachers that you go and talk to teachers. Teachers talk about kids will just bring a bag of Takis to class for lunch, and that is their lunch. Instead of this bill, what we should have had is saying, we're going to provide school districts money to make sure that every child has a free lunch, and that every free lunch will contain fresh meat from Texas, fresh vegetables from Texas, fresh grains, fresh dairy from Texas, and to make sure that our kids have access to the foods that will not kill them. That's what this bill should have been. Instead, we have overreach and ineffective. I think we can do better than this. I'm asking us to vote this down, not because the intention is bad or the idea is bad, but I think throughout this whole process, it's been muddled, it's been confused, and I think we've lost the game. I think we should come back with fresh eyes next time and actually work on a bill that actually matches the intent and meets the goals of what we're trying to set out. I urge you to vote no.
The chair recognizes Ms. Howard to speak in favor of the bill.
So, Mr. Speaker, members, I'll be brief. This took much longer than I think any of us anticipated. Clearly, this is something that is of interest to all of us. And I'm actually very pleased that we are doing something to try to address, whether this is the right way to do it or not, the health of our society. Because we always talk about the fact that we have an illness system rather than a wellness system. And I think that the intention of this bill anyway, is to be looking at how do we actually do things that will make a difference in the healthcare system and get people healthier. Y'all know that I'm a nurse. You may not know that I have a master's in health education and that a lot of my work was in patient and community health education. Decades ago, I helped set up the Seton Good Health School. This is not rocket science and this is nothing new. We've known for a long, long time that there are a lot of factors that impact our health and that the chronic diseases that plague our society are the result of a lot of these factors, including food. I know Dr. Oliverson has been talking a lot in the past couple of sessions about food as medicine. Clearly, we know this is an issue. I'm very pleased what Chair Hull has done with looking at the social determinants of health, the non-medical drivers, whatever you want to call them, that now we have in our Thriving Texas Families program, where we're actually assessing what is going on in people's lives that we could do that would help them get to a healthier place. We know it's not just medicine. We know it's not just drugs. And clearly food is a big part of it. So, though I would like to see some things done differently, which I will say that a lot of the Democratic amendments you heard today were very sincerely put before you because we thought that there were things we could do that could make the bill better, take advantage of what is happening with this bill. But the fact is, I am going to be supporting this bill. I think it takes us in a good direction. I would like to see much more done. I hope that we will do that. But what we do in terms of providing healthy food alternatives for all Texans, including those that are in food deserts, including our children that go to our schools, will make a long-term difference in their health and well-being. And so I am here to say I'm going to be voting for this bill. Thank you.
The chair recognizes Ms. Hull to close.
Thank you, Mr. Speaker, members. I appreciate Representative Howard and the other Democrats in this chamber and the Democrats in the Senate because it was a bipartisan effort. This came out of the Senate 31-0. And again, this is Democrats and Republicans coming together to say we have had enough. RFK Jr. just called me and Senator Kolkhorst and said they want this bill. This is the best bill in the entire nation. They are watching and they want us to pass this bill. Members, this is about transparency. This is about informing consumers to make healthy choices for their kids. This truly is David versus Goliath, the mountain that we are up against here. I know. But Texas is standing up to big food on behalf of our children, and the whole nation is watching. Move passage.
The question occurs on Senate Bill 25, passage to third reading. This is a record vote. The clerk will ring the bell. Vote aye if you're in favor of the bill. Vote no if you're not. Have all members voted? Show Mr. Harris voting aye. Show Mr. Romero voting no. Have all members voted? Have all members voted? Being 105 ayes, 28 nays, Senate Bill 25 passes to third reading. The chair lays out Senate Bill 37 as a matter of postponed business on third reading. The clerk will read the bill.
SB number 37 by Creighton, relating to the governance of public institutions of higher education, including review of curriculum and certain degree and certificate programs, the powers and duties of a faculty, council, or senate, training for members of the governing board, and the establishment of the Office of Excellence in Higher Education.
Chair recognizes Mr. Shaheen to explain Senate Bill 37.
Thank you, Mr. Speaker. Members, SB 37 ensures degrees earned in Texas are of value and prepare students for sex both in life and in workforce. I move passage.
The chair recognizes Ms. Goodwin to speak against the bill.
Sorry. Thank you, Mr. Speaker. Members, thank you for welcoming me up to the podium here. This bill isn't solving a real problem. It is addressing a clash between state leaders and professors in recent years. It could be in part a result of the University of Texas at Austin faculty who angered Dan Patrick with a 2021 letter reaffirming their right to teach critical race theory. What is the issue with teaching critical race theory? It's an academic discipline which explores how racism has permeated America's institutions. Critical race theory has become a regular target of conservative criticism. UT professors also upset state leaders by condemning them for the excessive law enforcement response to the peaceful pro-Palestinian protesters on campus last year. The problem is that by rigidly reviewing degree programs in the way the bill describes could lead to the elimination of degrees in humanities and social sciences. An unintended consequence could be time and money spent by our universities having to respond to frivolous complaints sent to the statewide office. Another unintended consequence could be missing out on professors who universities want to hire, but who the Board of Regents may decide not to hire. The Board of Regents will now have the opportunity to overturn a hiring decision without a similar opportunity for the university administration to present the rationale for the hiring decision including any formal recommendations received from a faculty search committee or other representative faculty body involved in the hiring process. Members, this bill, like a number of other bills this session, is a solution in search of a problem. I urge you to vote no with me.
Ms. Shaheen to close.
Thank you, Mr. Speaker. Members, this is a great bill that's going to ensure our great universities produce a great
Do we know for what
workforce
purpose?
in the future.
Will the gentleman yield for a couple
Gentleman yield
questions?
for questions?
Sure, I'd be
He
happy
yields
to.
for questions.
Thank you, Representative Shaheen. I'd hoped to ask you about this yesterday, but I didn't manage to make it to the mic before your 10 minutes were up. You mentioned yesterday that you had worked with the universities on this bill. Is that correct?
That's correct, yes.
I want to know how many actual professors, people who are day-to-day teaching our students, you engaged with.
They were the leaders of the universities that we worked with, but we did have, I don't know, maybe 4 or 5 hours of testimony where we heard from a lot of the professors.
And I ask because I represent Texas State University. A lot of University of Texas at Austin professors live in my district, and I've heard a lot of concerns about recruitment. I've heard concerns about people leaving the state to teach elsewhere. Have you heard those concerns?
We did hear those concerns, although we did some research and found that there was polls that stated people were going to leave the state, but we actually haven't found that to be the case.
Unfortunately, I'm hearing differently in terms of recruitment and leaving as well. But I wanted to ask, you know, at a workplace, do you think it's valuable for the people who work there to have some sort of a voice in governance of that place?
Absolutely, and the individuals that work at our universities can go to their management. They have a faculty senate. So there's lots of venues where individuals that work at our colleges and universities will be heard.
And have you heard the concerns from university professors that the effectiveness of the faculty senate at representing the faculty is going to be significantly curtailed by this legislation?
I don't believe that's going to be the case at all. The legislation just made it clear that the faculty senates are advisory in nature, which was always the intent of those. But no, they're going to serve a very useful and strong purpose in our colleges and universities.
Now, the legislation is also changing the appointment of the faculty senate, is it not?
Yes, the president has the opportunity to choose the presiding, the president, the assistant president, and the secretary of the Senate faculty.
So the university leadership will have a lot more control over that body, even while it's just an advisory capacity.
Really what the legislation does is it says they have to follow some open meeting acts types of things. They have to post an agenda. They have to broadcast on the internet. It really had more to do with that. But again, the faculty senates, they're going to be able to serve the purposes that they were always intended to be.
But university leadership will be appointing the leadership of the faculty senate as well.
The vast majority of that body is going to be elected, but there are some appointments. That's accurate.
But the people who are appointed by the president are going to be in the position to control the flow of the faculty senate.
Well, they'll be the
often.
presiding officers, but again, you have, like this body, every individual here represents a constituency, and that will still be the case, and that was always the intent of the faculty senate.
Okay, well, I still have serious concerns, but thank you for answering my questions.
Okay, thank you. Mr. Speaker, I move passage.
Question occurs on final passage. It's a record vote. Clerk, ring the bell. Show Mr. Leach voting aye. Mr. Hunter voting aye. Ms. Bowers voting no. Have all members voted? Have all members voted? 85 ayes, 56 nays. Senate Bill 37 finally passes. Chair lays out Senate Bill 3070 as a matter of postponed business on second reading. The clerk will read the bill.
SB number 3070 by Hall, relating to the abolishment of the Texas Lottery Commission and the transfer of the administration of the state lottery and the licensing and regulation of charitable bingo to the Texas Commission of Licensing and Regulation, creating a criminal offense.
Mr. Guerin.
Thank you, Mr. Speaker and members. Senate Bill 3070 transfers the lottery and bingo operations to the Texas Department of Licensing and Regulation, TDLR, and I have a floor substitute I'd like to lay out at this time.
Following floor substitute, clerk read the floor substitute. Amendment.
Amendment by Garin.
Mr. Garin.
Thank you, Mr. Speaker. Members, I'll be happy to take questions after I lay it out, but it's quite a long layout. The Lottery Commission oversees both lottery and bingo, and the Lottery Commission was under sunset this session. As you know, there have been a lot of controversies surrounding the Lottery Commission. This legislation abolishes the commission and moves its functions to TDLR. The floor substitute is a result of meetings with TDLR and stakeholders. My goal in drafting this floor substitute is put guardrails around the operation of the lottery at TDLR while ensuring its continued operation without disruption. Members, let me be clear about this. The lottery provides about $2 billion per year for public education and about $27 million per year for veterans. The floor substitute creates a limited scope sunset review process for the lottery division at TDLR in 2029. If the lottery division is not continued in 29, the lottery division and the lottery will be abolished. The lottery operation changes. The floor substitute bans lottery courier services in the state. The bill prohibits having more lottery ticket terminals than would be appropriate given the retailer's location, and unless otherwise provided by TDLR, no more than 5 terminals will be given to any retailer. The floor substitute only allows the sale and purchase of lottery tickets in person at a licensed retailer and during the retail's normal business hours. The floor substitute prohibits playing lottery via telephone or internet. There's been discussion in the press and in this building about bulk purchases of all lottery drawing numbers. The floor substitute clearly prohibits such bulk purchases by prohibiting any individual from buying more than 100 tickets at a single transaction. There was discussion sunset about age verification of buyers of lottery tickets. The floor substitute requires retailers and their employees to use an age verification process as set out by TDLR rule to verify the age of the ticket purchasers. The current contract for lottery operations expires August 31st, 2026. The floor substitute requires TDLR to negotiate an extension on this contract for up to 2 years in order to allow for a full RFP and implementation of that RFP to occur. TDLR is required to review each existing contract to determine whether to renew, amend, or terminate the contracts. The bill makes a Class A misdemeanor for a Lottery Commission employee to purchase a ticket or claim a prize. A prize winner must submit to TDLR any form required by the IRS, and TDLR must independently verify the form before paying a prize. The floor substitute creates the Lottery Advisory Committee to advise TDLR on the needs and problems in the lottery, provide input on proposed lottery rules, brief TDLR on challenges in the lottery industry and similar tasks. The committee must meet at least quarterly, and those meetings must be open to the public. TDLR must provide annual reports to the legislature that includes a summary of prize and sales information, includes a comprehensive business plan, and addresses trends in the lottery. The report must also include specific information about bingo operations statewide. The floor substitute requires the state auditor's office to conduct an annual comprehensive audit of the lottery program. The state auditor's office must specifically identify any lottery program action or activity that varies from the previous year's audit. This is designed to make sure the lottery operates within the statutory confines we, the legislature, have set forth. TDLR must establish an Office of Security to address any security-related matter This office is authorized to coordinate with the Financial Crimes Intelligence Center. The floor substitute requires TDLR to maintain all department records related to the lottery for 5 years and prohibits TDLR from using a software program to auto-delete any records before that time period. The floor substitute requires TDLR to maintain a record of any formal meeting of the Licensing Commission related to the lottery or of the Lottery Advisory Committee, and these records must also be maintained for at least 5 years. TDLR must conduct a background and criminal history check on any employee or prospective employee who has or will have access to sensitive confidential data, and TDLR may fire or refuse to hire any individual who refuses to give their fingerprints for the background check. The floor substitute prohibits appointment as a TDLR commissioner if the person is not a U.S. citizen or has been convicted of a crime of moral turpitude. The differences between the Senate version and ours, the floor sunsets the lottery commission, TLC, on 9/1/29, where the engrossed version from the Senate was 9/1/27. This will give TDLR the additional time to work on the transition before the sunset review begins. The floor substitute removes proposed new section which would make the governor, lieutenant governor, speaker of the House, and attorney general TDLR inspectors entitled to inspect the operations of a lottery operator or sales agent. The floor sub creates the Office of Security within the department rather than specifically with the Financial Crimes Intelligence Center. The change also removes Section 73 of the engrossed bill, as that section is no longer necessary in light of this change. The change will allow TDLR to be more flexible and allocate security resources across the agency as needed, whether in the existing parts of the agency, within the FCIC, or within lottery and bingo operations. The records retention conforms to other TDLR standards. The floor sub proposes new sections and into one section and requires TDLR to preserve all records and emails relating to the lottery for at least 1 year and prohibits TDLR from using software to automatically delete these records. The recommendation would address concerns about language in the engrossed bill that would have prohibited TDLR from using an email product like Outlook that simply can be configured to automatically delete emails in a certain period of time. The floor sub makes changes to proposed new section 466031 to greatly reduce administrative burdens on TDLR and its staff. The engrossed version would have required TDLR to take minutes of any informal meeting of staff discussions of the program, which would have posed significant compliance challenges when placing an inordinate burden on the agency. The version in the floor substitute simply requires TDLR to make and retain a record of any formal meeting of the Commission or the Lottery Advisory Committee. Fingerprinting background checks. The floor subs incorporates changes to these sections to make it clear that not all TDLR employees would be required to undergo fingerprint and background checks. Only those employees with access to sensitive and confidential data relating to the lottery program. This would reduce the burden of TDLR to perform fingerprint background checks on all existing staff. Excuse me. The floor sub makes a change in Section 34 to provide TDLR's governing commission the authority to adopt rules to prevent a disappropriate number of lottery terminals or vending machines from being provided to a licensed location of a sales agent. Unless those rules state otherwise, license holders would be limited to 5 pieces of lottery-related equipment. This change will allow TDLR Commission to adopt rules allowing large retailers such as grocery stores to provide lottery ticket printing service at each checkout station, to have access to an appropriate amount of lottery equipment while prohibiting sham businesses from having access to equipment.
Mr. Wyatt, for what purpose?
Chairman Garin, yield just for a few minutes.
Yield for a minute.
Chairman Garin, the floor substitute in general contains changes made in consultation with TDLR to ensure that operations are able to continue at the as the agency is transferred over. Is that correct?
That is correct, Mr.
Okay.
Wally.
And then that ensures that approximately $2 billion per year for public education and $27 million per year for veterans will continue without disruption. Is that my understanding?
That is correct, because as you're well aware, being on appropriations, that $2 billion is a very important part of this budget.
Okay. And then what the floor substitute and the bill, are you aware that since 1997, the Texas Lottery Commission has contributed over $34 billion to the Foundation School Fund?
I'm aware of that number, and that is correct.
Okay. And then are you aware that it also provided over $270 million to the Texas Veteran Commission since 2009?
I did not know that number, but thank you, Mr. Wally.
And then if we don't pass this bill, there's no other bill to extend the operations. Is that correct?
That is correct, and they're not included in, I mean, the safety net bill obviously was held up in committee yesterday, and so there's nothing to keep the lottery going after September 1.
So this bill ensures that the operations and the funding attached to it is secured because there's no other option but to pass your bill. Is that correct?
There is no other option, Mr. Wally.
Thank you.
And let me finish here.
The gentleman's time has expired.
I've got my next amendment.
The following amendment to the amendment. Clerk will read the amendment to the amendment.
Amendment by Guerin.
Mr. Guerin.
Thank you, Mr. Speaker. The amendment to the floor substitute widens the scope of the sunset review. The amendments remove the requirement of TDLR to perform an investigation of current employees or the executive director and extend their requirement for fingerprint background checks to TDLR employees who either have access or any access to the bingo program. And this amendment ensures TDLR will have full access to the Lottery Commission's computer system rather than inquiry-only access. This amendment makes the agreement between the Lottery Commission and TDLR to transfer the Lottery Commission's property mandatory rather than optional. And this amendment resolves an issue with the floor substitute that would have allowed certain grandfathered licensed lessors to maintain their leases in a dormant state indefinitely, and this would limit it to a 10-year period. It would remove the firm deadline of 3/1/26 for TDLR to appoint members of the Lottery and Bingo Advisory Board, replacing that with as soon as practicable, and this would change the date of TDLR's first required annual report from 1/1/27 back to 12/1/26, and these amendments would address issues raised in HB 4122 regarding transfers of bingo equipment. And I'll be happy to answer any questions at this time, or I'll try to.
Mr. Guerin sends up an amendment to the amendment. Record vote. Clerk, ring the bell. Mr. Guerin voting aye, Mr. Turner voting aye. Have all members voted? Have all members voted? Mr. Schatzline voting no. Have all members voted? 104 ayes, 33 nays. The amendment to the amendment is adopted. Following amendment to the amendment, clerk will read the amendment to the amendment.
Amendment by Busey.
Mr. Busey.
Thank you, Mr. Speaker and members. Reluctantly, I'm going to pull this down. I just want to talk for 1 second on it, 1 minute on it. Everyone should know what we have done this session when it comes to couriers and the lottery. This amendment would have allowed Texans to order official lottery tickets through a mobile app or website from state licensed and regulated lottery couriers. By giving Texans the freedom to participate in the lottery through couriers, we could provide services like personal deposit and spending limits, responsible gaming resources, and other security measures that are better for consumers. With proper regulation, lottery couriers can be safer and more reliable than traditional brick and mortar stores, and we could provide more resources to Texans who might need help with addiction to gambling. Since Lieutenant Governor Dan Patrick began his crusade and the Lottery Commission subsequently and lawlessly shut down couriers contrary to OAG Sunset Commission advice, the Texas Lottery has experienced sharp declines in year-over-year sales. The total decline for the period beginning February 22nd, 2025 is $306 million, with as high as a 26% decline in April. If the legislature's aim with this legislation is to plug the $2 billion hole in the budget, it should include courier sales in that equation. If we pass this amendment, we could ensure that our public schools, veterans, and other vital services can receive the critical revenue they need from the lottery courier services, while at the same time preventing abuse and preempting bad actors. Without this, we will continue to see this decline, and the lottery's effectiveness in supporting our veterans and public schools will also continue to decline. We are moving backwards away from security and modernization by banning this, something that was done by the commission without any authority. And while Dan Patrick and I strongly disagreed on the status of lottery couriers, we both agreed that they did not have this authority, which is why we're doing it today. So members, by doing this, we are hurting the benefits of the lottery. We're going backwards, and it is a mistake. And with that, I pull this amendment down. Thank you, Mr. Speaker.
Following amendment to the amendment. The amendment withdrawn. The following amendment to the amendment. Clerk will read the amendment to the amendment.
Amendment by Money.
Mr. Money.
Thank you, Mr. Speaker. Members, my amendment to the amendment is simple. It would sunset the Texas Lottery on September 1st, 2025. Government-run lottery systems, when operated as they are intended, are shameful. The Texas Lottery, when operated as it has been, is scandalous. When operated as intended, lotteries disproportionately burden low-income Texans who spend a higher share of their income chasing false hopes. While Las Vegas casinos pay out 90 to 98% of wagers back to the players, the Texas Lottery pays out less than 70%. It's a terrible return on investment foisted on citizens who, by and large, don't have the money to invest in the first place. Its contribution to education is negligible, less than 2% of the education budget, hardly justifying the social costs of addiction and financial strain. As everyone in this chamber knows, the Texas Lottery Commission has not been run as it is intended. It's embroiled in scandal with allegations of fraud and mismanagement, which have shaken the public trust. Reports suggest the commission enabled a 2023 scheme where a group purchased nearly every ticket combination to win a $95 million jackpot, raising concerns of manipulation and money laundering. These incidents are under investigation by the Texas Rangers, Attorney General, and now the FBI, and they expose a lottery system that is vulnerable to exploitation, with some alleging ties to international actors and cartels. The Senate's unanimous vote to dissolve the commission reflects the urgency of getting this right. I urge the House to eliminate the Texas Lottery by adopting my amendment to the amendment. Let us restore trust and prioritize policies that uplift and don't exploit Texans. Thank you.
Mr. Little.
Mr. Speaker, does the gentleman yield for questions?
Gentleman yield for questions?
I yield.
He yields for questions.
Representative Money, I think if we have a long enough memory back to whenever that was, when we voted on the budget, the next day, my recollection was the House voted to instruct the conferees on the budget to defund the lottery, did we not?
Yes, we did.
And my understanding is that this bill is being brought in response to that. Is that your understanding too?
Yes.
I can only speak for myself, but I do not wish to make the lottery comfortable for 2 more years or 4 more years while we decide whether it can be rehabilitated into a vehicle that is useful for government. One of the concerns that I have is that we're going to spend another 2 years or 4 years wrestling the same problem as a state. And the problem being that this seems to mostly hurt poor people to the benefit of government programs. It seems to me that this bill is brought in response to the government's addiction to poor people's money.
That's exactly right. This is the most regressive form of taxation that there is. It preys on the people who have the least amount of money.
And I understand and empathize with the fact that this money is going to schools. I understood Chairman Guerin to say $2 billion to schools and roughly $27 million to veterans. And those are important things for us to fund as a state. And if they are so important for us to fund as a state, we ought to be looking elsewhere besides those people who are buying lottery tickets. Don't you think?
I do. And please understand, the schools are still going to get their money. The schools, the veterans are still going to get their money. And if this revenue stream stops, we're going to have to replace it with some different money. But we're talking about, once again, with education, less than 2%. Less than 3 days of instruction are paid for by the lottery. And I say to you, the cost to our society and to those families of people who are putting their last hard-earned dollar into false hope is more than that. It's not worth what we're getting through the funding mechanism.
Well, Representative Money, one of my concerns is that government has already demonstrably proven that it is incapable of running this program in a responsible and fair way. Do you share concerns that I have about simply handling the management of the program to another agency and expecting them to do better?
I do. I was listening to the radio this morning, and some of the people in this chamber may have heard this, but there is a person who has a winning lottery ticket from 2023 that still has not been paid and is now suing the state for $83.5 million. And there's an investigation. I don't know all the details, but we have someone who won. They bought a ticket through a courier service. Courier services are legal. They're not legal. I don't know. Someone out there has a winning ticket and can't even learn from the state whether or not they're entitled to that money or not. We just have tied up so many state resources trying to figure out how to swindle more money out of poor people, and I think it needs to stop.
Well, I sincerely appreciate Chairman Guerin's efforts to try to rehabilitate or reform the lottery. It seems to me that it is much simpler for us to just decide, for lack of a better word, as a state, not to play any longer.
Yes, and I admire and appreciate the efforts of Mr. Guerin and Senator Hall, but as we heard, I believe in his layout, the leases on these machines are up at the end of August of 2025 anyway. We either have to start over with some new system, or we can just let it die a natural death, let people keep 26. Let people keep their hard-earned money and spend it on taking their kids out for ice cream, going to the movies, paying their electricity bills or whatever it may be.
Well, one of the concerns that I have, Representative Money, is that Texas, I found this figure recently, Texans hold roughly $11 billion worth of credit card debt.
Wow.
As a state. It's one of the leading states in the entire country. And as a state, I think we are contributing to that problem and deepening it with programs like this. It doesn't seem like this is to the benefit of Texans, and based on recent news, seems like it has benefited people off of our shores more than it has the average Texan. I thank you for your amendment.
Thank you.
Hopper, for what purpose?
Mr. Speaker, would the gentleman yield for questions?
Gentleman yield for questions?
I will yield for
He
questions,
yields for questions.
but not for parliamentary
No,
inquiries.
you listen. Not good at asking those, anyways. It turns out. Well, Representative, I really appreciate you bringing this amendment because we have this inertia in our state. I think that we all felt it when we were running, that there is a mad push to expand gambling in this state, and this lottery was basically a first expansion of gambling years ago, long before we got here. And I think that there's an enormous amount of recoil to the idea that we would get rid of the lottery by many of the folks that are outside of this room. I think it's great that Senator Hall brought this bill, and I think that this amendment that you've brought gives us a unique opportunity to basically end it now. And let me ask you, are you aware that the Republican Party is against expansion of gambling in any form?
Yes, I am. It's one of the planks of the Republican Party platform.
So with your amendment, we have the opportunity to end the lottery. But if we don't do that, we are basically opposing our ideals embodied in our Republican Party platform. Would you agree with that?
Yes, and I think, but I really appreciate that, and I agree with that, but really I think this is not a partisan issue. I think this is an issue where we can all look in our neighborhoods and see that the lottery is advertised and focused on people who are poor. And most of the people that buy tickets are poor. And I just think a regressive tax is not the way that we need to fund our state. We need to fund our state. We need to fund our schools. We need to fund our veterans. We need to take care of infrastructure. But doing it this particular way, where the state takes 3 to 30 times more than Las Vegas hotels take, casinos take, of the people's money that they spend. It's unfair. It gives people who a false sense of hope that are many times financially desperate, and I think that we need to allow them to spend their money elsewhere.
Well, thank you for bringing this amendment, Representative.
Thank you.
Mr. Speaker.
Mr. Schatzline, for what purpose?
Would the gentleman yield for some questions?
Gentleman yield for questions?
I will.
So,
gentleman's time has expired.
Thank you, Mr. Schatzline.
Mr. Guerin.
Thank you, Mr. Speaker and members. As I stated, the lottery brings in about $2 billion that goes to our budget, and with that, I would move to table.
Mr. Speaker, before you move to table, would the gentleman entertain questions?
He has to withdraw his motion to table to answer questions.
Okay.
I will withdraw.
Thank you.
Okay, he'll answer questions.
And I'll answer questions.
Thank you, Mr. Speaker. If I heard correctly, the prior speaker, he was objecting to the lottery because he said it affected poor people. Is that what you heard?
That's what I heard, Mr. Dutton.
Well, I am so glad that we have finally gotten to the stage of the legislature where poor people are a priority.
You'd have to repeat yourself, Mr. Dutton, a little louder. I was unable to hear you.
I said, well, I'm just so glad we've gotten to the stage in the legislature where poor people are becoming a priority.
Well, thank you, Mr. Dutton.
Yeah, well, I think the prior speaker, I was going to ask him about that because I really wanted to know what else they may have had in store in the past or in the future for poor people in this state.
With that, Mr. Dutton, I move to table.
Thank you.
Money to close.
Speaker.
Mr. Harrison, for what purpose?
Will the gentleman yield for a quick question?
Gentleman yield for questions?
I will yield for questions.
He yields for questions.
Representative Money, are you aware that the topic of legalizing or the legalization of gambling is a rather hot topic in the city of Austin on a frequent basis, especially when the legislature's here?
That's my understanding.
It is. I want to say I appreciate you bringing this amendment because would you agree with me, Representative Money, that this should be a very uncontroversial and unifying amendment? Because would you agree that both people who support the legalization of gambling and people who oppose the further legalization of gambling should both agree that the government should not be the biggest bookie in the state of Texas?
I agree.
I do too. Thank you for bringing this amendment.
And just to quickly address Mr. Dutton, which I think makes a good, I know it comes from a sincere place.
Mr. Speaker, will the gentleman yield?
Gentlemen yield for questions.
Let me finish my point very quickly about Mr.
Not
Dutton.
at this
and then I
time,
will
Mr.
yield.
Toth.
An opportunity that we have to stop taking money away from poor people is something that we should all get behind. Sometimes we have a disagreement about how we should allocate state funds, in what way, and all of those kinds of things. And we have disagreements that sometimes fall across party lines. This is a direct opportunity to kill the most regressive tax that we have. And with that, I yield for questions.
Mr. Speaker, will the gentleman yield?
Gentlemen yield for questions.
I will yield for
He
questions.
yields for questions.
When you hear the advertising statement, $1 and a dream, what does that mean to you?
It means that they are trying to.
Who is that saying targeting?
It's targeting people who maybe only have $1 left and they're dreaming of a better life.
Do you know what taxonomy research is?
No.
Taxonomy research is the identification by market research companies to identify a different group or to identify the different people that use your product. I've been on, and I want to respond to Mr. Dutton's statement that all of a sudden poor people don't matter. I had been on appropriations 3 different terms. And 3 different times when the lotto came and stood before us, I asked them, can we see the taxonomy research that your advertising company has done for you? And every single time, Mr. Money, they say, we'll get that to you, and they never get it to me. Why? Because they are in fact targeting poor people in the state of Texas to play this. And I hope that your amendment is successful.
Thank you.
Mr. Speaker, for what purpose?
The gentleman yield for questions.
Gentlemen yield for questions.
I will yield.
He yields for questions.
Mr. Money, I appreciate you bringing this amendment. I think this is a wonderful amendment. I have been adamant about abolishing the lottery ever since I've been here. Let's talk a little bit about this system that supposedly helps our schools. Are you aware that the payout percentage to prize winners has increased from 45% when the lottery started to 68.7% last year?
Okay, I was close with just under 70. Yes.
So over this time, and you're familiar that if you got a percentage and it's the 100%'s the pie, as the percentage of prizes goes up, that the percentage that goes to education goes down. Are you familiar with that
That's
basic
correct.
math concept?
Yes, I am.
So this system over the last, I don't know, 30, 32 years, would it surprise you that almost every single year they have increased the percentage of prize payouts and decreased the percentage of education payouts?
That kind of does surprise me.
Sounds like a real winner. Would it surprise you to know that if they were paying out the prize percentages they were about 15 years ago, that would be about another $500 million to public education every year?
Maybe so. I would say, and I like where you're going here, but I would also say, you have to pay out a certain amount or people just quit playing. And I think that part of what we're seeing is lottery players are realizing that it's a rigged game.
Let's talk about that.
Yes.
You know what the odds are of winning the jackpot?
I know that it's less than getting struck by lightning.
It's 1 in 25.8 million. So you're saying there's a chance. Let's talk about the odds with that math. Does it surprise you that this legislature, in its infinite wisdom, would set up a system to fund education through a game for people who are not good at math?
That's exactly right.
Vote yes on your amendment. Thank you.
Thank you.
Mr. Speaker.
That's time for what purpose?
Would the gentleman yield for some questions?
Gentlemen yield for questions.
I will yield again to Mr. Schatzline.
He yields for questions.
Hopefully I can get a couple questions in. Hey, look, Mr. Money, would you agree that our current lottery system is just absolutely corrupt?
I believe that is true, yes.
I followed the story with our lieutenant governor and exposing the corruption, and I applaud what Senator Hall is doing with this bill because at the very least we need to rein this in and figure out how we fix it. The problem is, as a legislature, if we know that a system is corrupt, shouldn't we just abolish it?
We should, and a no vote on the motion to table is a vote to end the lottery, and I hope that my friends on both sides of the aisle will recognize the opportunity that we have here to stop a regressive, corrupt system and move forward funding education and veterans in a different way.
Could it be said that supporting your amendment is actually a vote to end corruption?
Yes, it could be said.
Could it also be said that voting against your amendment is a vote to continue corruption in the state of Texas?
It could. I would say that I think that Mr. Guerin and Senator Hall are working hard to try to change some things to address that. And so I think that they would, just to be charitable, say, hey, we're trying to get rid of the corruption side. But as I said at the beginning, when operating as it's intended, it's still shameful that we're taking money from poor people to fund education.
I've talked to a lot of members that are against gambling in this state. We clearly don't have the votes to pass casinos in this state. Would you say that voting for your amendment is saying, hey, we don't want to expand gambling in this state?
Yes.
And would you say that voting against your amendment is saying, I'm not just okay with gambling, sometimes I'm okay with gambling that leads to corruption that goes throughout our state?
It could be that for some people. I sure hope not, but it could be.
So within your amendment right now, if we do this right here and right now, we are going to answer the cries of the people to bring down a vitally corrupt area in our government that we have the full power to do. Is that correct?
That is correct.
Thank you for this amendment. I'll be supporting it.
Mr. Dutton, for what purpose?
Would the gentleman yield for questions?
Gentleman yield for questions. He yields for questions.
Thank you. Your principal argument against the lottery seems to be that it takes money away from poor people. Is that right?
It is an unfair game that is primarily played by poor people in order to fund an area of our government. Yes.
Is it voluntary or involuntary?
It's voluntary.
Okay, so if they choose to play it, you have a problem with that.
Well, and once again, I'm not up here saying we should get rid of charitable bingo and other things, but the government itself should not be running a system that intentionally takes money away from its poorest people.
Yeah, but I wish you would up there saying we need to get rid of poor people.
Well, I think this is one way to start doing that.
Well,
I do.
no, that doesn't get rid of poor people.
The poor will always be with us.
Are you fanning? Well, that's not what the Bible means.
That's what he said.
That's what it says, but that's not
Yeah.
what the verse means. If you'll go back and read and look at the verse, you'll get some. But are you for expanding Medicaid?
I think there's a fundamental difference between we need to take money and give it to people, which I don't really approve of, or we need to continue to take money unfairly from people. That's what I want to stop.
Well,
let's not take money from people.
You said it's voluntary, so it's not taking it from anybody. But I'm curious as to what other things do you think we ought to do for poor people around this?
Well, I would like to keep it on my amendment. This is the one thing that we can handle right now today.
Well, I understand why you're saying that, because there's not anything I can think of that you've done for poor people.
Well, I don't know that that's fair. You and I can certainly talk on the side, but right now we're talking about
Well, why don't you
this
name one?
amendment.
Why don't you name one?
Because right now we're talking about this amendment. We're
Wait,
talking about the
wait,
Texas
you can't
lottery.
think of one?
I really don't want to. I really don't want to subject you to that right now, and I don't want to brag about things that I have done or not done.
I'm a big boy. I'm a big boy. I can take it.
I'm talking about the lottery right now.
I can take it. Whatever you dish out, I got it.
Well, I don't want to dish anything out to you. You're very polite. I'm not. I don't need to do that.
Well, I'm not. Well, he said something about me. I didn't say anything about him. But what I'm trying to figure out is, if you're for doing away with the lottery because it affects poor people, did you just get interested in poor people, or is just this one issue?
Of course not. But I am.
The gentleman's time has expired.
Please vote no on the motion to table.
Mr. Money sends up an amendment. Mr. Guerin has moved to table. The questions on the motion to table, record vote. Strict enforcement has been requested. You can vote from your chairs. Ring the bell. Show Mr. Guerin voting aye. Have all members voted? Have all members voted? Have all members voted? Have all members voted? 71 ayes, 58 nays. The motion to table prevails. Mr. Guerin on the amendment as amended.
I move passage of the amendment.
Question occurs on the Guerin amendment. Record vote. Clerk, ring the bell. Mr. Bell voting aye. Have all members voted? Have all members voted? 91 ayes, 44 nays. The amendment is adopted. Mr. Guerin on the bill as amended.
I move passage.
Question occurs on passage of Senate Bill 3070. Record vote. Clerk, ring the bell. Mr. Bell voting aye. Have all members voted? Have all members voted? 110 ayes, 29 nays. Senate Bill 3070 passes the third reading. Chair lays out Senate Bill 22 as a matter of postponed business on second reading. Clerk, read the bill.
SB number 22 by Huffman relating to the Texas Moving Image Industry Incentive Program and the establishment and funding of the Texas Moving Image Industry Incentive Fund.
Members, please excuse Ms. Hull for a family matter. On motion, Ms. Lawson, is there objection? Chair is none, so ordered. Mr. Hunter.
Members, this is Make Texas Film Industry Great Again bill. Let's hear it. No, we're not going to be doing filming of oysters. We're not doing filming of shrimp. But TWIA, get ready. Members, I wanted to get your attention. This is one of the bills that has had more different interpretations than I can count. And so I want to be very, very to the point and tell you what this film bill does. Number one, this is not the money bill. That's in the budget. You already voted, or some of you did, for the budget. This money is placed in the budget. That's not this bill. You already voted. What does this bill do, Representative Dutton, which you and I talked? It provides safeguards on how Texas spends money on film. Why am I involved? I can't bear to see the Alamo, ranching, Texas, filmed out of Texas.
That's right.
Look at all the veteran movies. Why are they being filmed out of Texas? So what we have got to do is what President Trump tweeted. And I know I have both sides of the aisle here, but I agree with him. Let's let the states start taking control, because there are going to be tariffs placed on out-of-area films. So what this basically is a structure to create the safeguards when you use money in Texas. Now let me explain this. The criteria for doing filming, you do an application, the criteria is laid out. You cannot go into illicit areas. You cannot go into demeaning areas in the state. The governor's office has oversight. There are safeguards built in the bill. But I want to pull out different areas of the state. Waco, Texas, everybody, is one of the top 2 tourist destinations in the U.S. because of the Magnolia Network, like Fixer Upper. And all you no votes, don't tell me you don't watch HGTV, because we're watching. The Chosen, the life of Jesus, is filmed in Texas. Members, they spent $88 million in the small town of Midlothian, Texas, created over 3,400 jobs, Representative Romero. Taylor Sheridan, you've all heard of him, Miss T. He spent over $1.2 million a day over the course of a week in Strawn, Texas, which has a population a little over 500. What does the film do? If any of you have not had the film, my area doesn't, John Bryant. I don't get a lot in my area, these films, but it fills my restaurants. It fills the hotels. It gets electricians hired. It gets carpenters hired, Representative Jones. It provides retail and commercial business. This isn't Hollywood coming to Texas. This is Texas taking over Hollywood. We're doing our own thing. We don't need to be part of them. And they should be scared, because this bill brings it to our state, and we as a legislature should be the oversight of the Texas film industry. Nobody else. Some of you've met in the hallways. Dennis Quaid played Reagan. Let's don't forget that, from Houston. Then we've got Matthew McConaughey, Woody Harrelson, who are filming Brothers. I'm sure they'll do Sisters soon. But the bottom line is they live in Dripping Springs. These are Texans. Bring it on. Amen. Salina, my hometown, Corpus Christi. There's a film that should have been made in Texas, in my hometown. So the reason I want to make this impact on all of you, I get rhetoric, I get sound bites, but a lot of this is derivative of another bill, by the way, that was not this bill. All this bill is, as Representative Schatzline and I talked about, is a guardrail bill. All this is doing is putting in protections so Texas can develop its own film. And let me tell you something, Fort Worth, the Tarrant County, growing into Dallas, you're becoming one of the biggest film zones in the United States. So what I'm trying to encourage you is let's get some showing positive for the art industry, which film is part of. And my last comment is, Richard Raymond, my good friend, he had just informed me that he and Ryan Guillen, they are filming and producing a South Texas political film. And it's based on one of the historic figures in South Texas. And I'm just glad to see the focus. And I want you to know, I'm not offended on the robust commentary. You know what it's doing is, whether you're for or against, everybody in this world is seeing that we care. And the bottom line is, everybody that votes for this bill, I'm going to be with you. And everybody who votes against it, I'm still going to be with you. But I'm going to love the yeses more than I am the noes. Now, I'm going to finally end like this, Mr. Speaker. I want all the votes we can get, because, members, the last calendar's meeting is already ended, so I don't have any more control. So the bottom line is, make Texas film industry great again.
Thank you. Mr. Speaker, will the gentleman yield for questions?
Ms. Martinez-Fisher, with purpose, gentleman yields for questions.
Yes.
Thank you, Mr. Speaker. Thank you, Chair Hunter. I just want to clarify, because you had my support. Richard Raymond's not going to be in that South Texas film, is he?
No, it's an animation he's going to be in.
Okay,
so.
okay, perfect. And Ryan and Chair Guillen's going to be the stunt double, I guess. So, Chair Hunter, I want to talk. You talked a lot about guardrails. I want to make sure that we clarify. We had the benefit of hearing this in committee, and so we spent almost a full day on this hearing. And a lot of people don't know that this is actually a reimbursement for a film. Can you talk about that a little bit?
Yes. So let me give everybody a little bit of history because much of this is confusing, and I understand. I believe the film program, Alan and a few of us have been here a long time, was created in 2007. So I want you to know the program on the film, I believe, has been since 2007. This is creating a separate process with guardrails. And by the way, since you brought this up, some of you think this is 500 million. That is incorrect. It's my understanding that they're looking at the sum of 300 million. So that is an incorrect. But what this does, Representative, is you do an application process. The governor's office has oversight. You have to follow that criteria. If the criteria is you go forward and you only get reimbursed after an audit, and by the way, since you brought that up, if any editing.
The gentleman's time has expired. I'm so sorry. The following amendment, the clerk will read the amendment.
Amendment by Martinez Fisher.
Chair recognizes Mr. Martinez Fisher on the amendment.
Thank you, Mr. Speaker and members. This is an amendment. In the committee testimony, there were two things that struck me in this debate, and it had to do with where the films are going to be made. And so what I'm attempting to do in this amendment is we're doing two things. We are giving an incentive, an additional incentive for films that are done in front of historic sites. So we have battlegrounds, we have battleships, we have historic missions like the Alamo in San Antonio. And so for any project that wants to come and do a film or a project, they can look at historic sites as an additional incentive. The second thing that was a big priority for me in the committee, as well as other members of the committee, is you heard a lot about workforce pipeline. We were talking about jobs in this industry on the low end at $70,000 per employee. And so what we learned in the testimony that there lacks a pipeline. We do not have that workforce pipeline of students and folks who are going to study radio, television, and film. So this amendment also says that if you're going to do a project and you partner with a college to build that workforce pipeline, we will also give you an additional incentive. And so those are the two things this amendment does.
Mr. Speaker.
Building a workforce pipeline
purpose.
and historical sites.
Will the gentleman yield for questions?
Gentleman yield for questions.
I yield.
Gentleman yields.
Representative Fisher, thank you for that that amendment, and we want to do a lot of clarifying so people could get comfortable why this is a great opportunity for the state of Texas. I've been involved as a co-author on this bill for the last 3 sessions, so it has not been easy. So let's talk about the benefits. I want to know if you're aware that one of the things in talking and negotiating with making sure this happened, we involved the universities on the front end, because one of the things was how they developed programming so that we could keep our artistic young people in Texas. Right. Our design people, they could create a curriculum around there, our production folks, and then our makeup artists, all of those things that are a big part of that, and those are some of the jobs. And I know you shared some others. So what do you think of some of the other jobs that will be beneficial to our communities?
Sure. Well, first I'll say is a very good example. You have Tarrant County College that when they started their film school, they had 40 students in the initial class. Now they are producing a number of students who are going right to work in Tarrant County. As you know, because you have worked on this for several sessions, there are now sound studios in Tarrant County or in the region that rival like a Warner Brothers lot in California, and those sound stages are booked every day of the year. So we're talking about full employment, real jobs, real wages, and I know that in my conversations with our community college system, we have a radio, television, film program at San Antonio College. My advice was whatever they're doing in Tarrant, go copy it.
Right.
And for all of you who have community colleges or film programs at your schools, look to something like a Tarrant County College to find that program. But then there are the other jobs that you mentioned, right? Somebody has to build a set. Somebody has to drive the truck. If I'm not mistaken, the Teamsters are supporting this proposal because of the number of truck drivers they will have driving big commercial vehicles to build these sets. So somebody's building the sets, they're wiring these sets, they are running these sets. There are so many jobs behind the camera that people don't see that are paying real wages.
So we're talking about new university programming, we're talking about jobs, we're talking about economic development, we're talking that big umbrella of wonderful things that can happen here in the state of Texas.
I think the number in the committee was for every dollar that's invested in this program, $4.69 come back. So it is a multiplier. And again, we're just talking about the Texas spend. We're talking about the money that is spent here in Texas. And so it is doing wonderful things for our economy. You heard about Magnolia in McLennan County. There's also where The Chosen is been filmed in Midlothian, Texas. I can give you page and line what it's done for that community. I mean, there was a hotel that was going to close due to COVID, and now they're busting at the seams at 100% occupancy because of film projects that are being done in that area. So it does change below the line. That's the checks and money that people are taking home.
And so when we look at a model that exists, we're talking about the Georgia model also, which is a great one with Tyler Perry. So now we're talking Texan and real Texan stories, not those folks coming from out of Texas making up our own stories. Would you agree with that?
I would, and if you probably remember from the committee hearing, you had Matthew McConaughey saying, you know, don't make me go to Georgia. And in fact, those two filmmakers took a pay cut so they can convince the studio that they were serious about shooting this in Texas because they wanted to be here. And you heard Chair Hunter talk about his Selena Quintanilla, who had a big show about her, and the majority of the filming was done in Mexico, should have been in Corpus.
So we're talking about the investments that we're making are going to be 4 times that investment because of the dollar per and the return on investment. Would you agree with that?
I would, almost $4.69.
And finally, I would just say this. The state of Texas has the land space, it has the ambiance, it has the young people that we can keep here in our state. We're impacting the colleges and universities. So there is really no downside to this. I think what needs to be clear, though, people are asking, when we look at percentages of participations, that's pretty much laid out in the bill.
It is, and it will grow over time as we've developed the workforce pipeline. This is a start. It's a great start, and I'm grateful that Chair Hunter will accept this amendment. I believe it's acceptable. I'd like to move adoption of the amendment.
Thank you.
Chair recognizes Mr. Hunter to speak in favor of the amendment.
Members, I know this was discussed. Let me explain something. San Antonio's Alamo is heritage rather than fits under the historic definition. So what we're doing to help the Bexar County area is, since some markers and sites in Texas are defined heritage, they don't fit under historic. So bottom line, we're putting heritage in the criteria along with historic. Viva Alamo!
Great bill. Let's vote for it, everybody. It's be awesome.
Chair recognizes Mr. Martinez Fisher to close.
Thank you, Mr. Speaker. Move adoption.
Mr. Martinez Fisher sends up an amendment. The amendment is acceptable to the author. There is a record vote that has been requested. Clerk will ring the bell. Show Mr. Martinez Fisher voting aye. Ms. Yolanda Jones of Harris voting aye. Mr. Romero voting aye. Ms. Gervin Hawkins voting aye. Mr. Hunter voting aye. Ms. Gracia voting aye. Mr. Wally voting aye. And Mr. King voting aye. Ms. Johnson voting aye. Mr. Little voting nay. Have all members voted? Have all members voted? There being 105 ayes, 34 nays, the amendment is adopted. Anyone wishing to speak on, for, or against Senate Bill 22, Chair recognizes Mr. Lowe to speak against the bill.
Mr. Speaker, members, I rise today in opposition to Senate Bill 22. This bill provides tax...
Apologies, Mr. Lowe. Members, please take your conversations outside the rail.
This bill provides taxpayer-funded incentives to the film and entertainment industry. The same industry that once hailed Harvey Weinstein as a hero and turned a blind eye to his abuse for years. It took public outrage and national shame before Hollywood even pretended to hold him accountable. This is also the same industry that trashed us for supporting President Trump, mocked us for standing up for the unborn, vilified us for opposing gender transitions for children, and ridiculed our Christian faith at every opportunity. And now we are expected to trust them to produce family-friendly content and reimburse them $2.5 billion over the next decade? Let me be clear. Texas families are struggling. They're being crushed by rising property taxes. And instead of delivering them meaningful relief, this legislature seems to be more focused on picking winners and losers, reimbursing Hollywood subsidies while ignoring the people who sent us here. If we truly believe in a limited government and fiscal responsibility, then we cannot justify fueling tax dollars into an industry that mocks our values, undermines our culture, and refuses to be held accountable. Let's stop the Hollywood handouts, let's put Texans first, and let's vote no to SB 22.
Chair recognizes Mr. Hunter to close.
Move passage!
Mr. Chairman, Mr. Speaker.
Mr. Hayes, for what purpose?
Will the member yield for a question?
Gentlemen, you for questions?
Sure.
Gentlemen,
Thank
yields.
you. Mr. Hunter, this is Senate Bill number 22, which is the engrossed version of the bill from the Senate.
Yes.
An engrossed version means it's the finally approved by the Senate?
Well, I will tell you, Representative, I love the Senate and I love their bills, but I've learned nothing's ever final. But the answer to your question is yes.
All right, if I go to page 12 of your bill on line 3, does it not read, not later than the 30th day of each state fiscal biennium, the comptroller shall deposit to the credit of the Texas Moving Image Industry Incentive Fund $500 million?
Yes, but
you have not offered an amendment to lower $500 million to $300 million.
it could go up to 500. They haven't finalized the budget. That's what they're being discussed, but you'll have a ceiling of that.
So where did the $300 million number come from that I heard you reference earlier?
Because I've heard the conference committee is looking at those numbers.
So the only thing for the conference committee really to consider is the amendment that we just passed that had nothing to do with the dollar amount of this enabling legislation?
That's correct. That's correct.
Thank you so much for answering my questions.
Sure. Move passage!
Members, question occurs on passage to third reading of Senate Bill 22. Record vote has been requested. The clerk will ring the bell. Show Mr. Romero voting aye, Mr. Wally voting aye, Mr. Turner voting aye, Mr. Hunter voting aye, Mr. King voting aye. Have all members voted? Have all members voted? So Mr. Guerin voting aye. Have all members voted? There being 105 ayes, 34 nays, Senate Bill 22 passes to third reading.
Members, we have one bill on the items eligible calendar that needs to go to conference. So Mr. Wilson on the floor of the House. Chair recognizes Mr. Wilson.
Thank you, Mr. Speaker. Members, I call up House Bill 300 with Senate amendments.
Chair lays out House Bill 300 with Senate amendments and recognizes Mr. Wilson to explain the Senate amendments.
Thank you, Mr. Speaker. Members, the Senate decided to cut your Texas Armed Services Scholarship by half. By accident, they did not realize that it was actually appropriated, so we're just going to go to conference and make this, this correction that both sides realize. Mr. Speaker, I move that the House refuse to concur in Senate amendments and request the appointment of a conference committee.
Mr. Wilson moves that the House refuse to concur in Senate amendments to House Bill 300 and requests appointment of a conference committee. Is there any objection? Chair hears none. Motion is granted. Following conferees, the clerk will read the conferees.
House conferees on HB 300. Wilson, Chair. Buckley, Cortez, Lopez-Abear, Tenderholt.
Members, in anticipation of the next 2 days, please plan on being here at 10 a.m. tomorrow promptly. We will work well past midnight, and then the following day at 10 a.m. we will work till midnight. With that, the Speaker's desk is clear. The following resolutions on first reading referral, the clerk will read the resolutions.
HCR number 157 by Hunter, designating Rockport as the official red fish capital of Texas for a 10-year period ending in 2035. Referred to the Committee on Culture, Recreation, and Tourism. The following resolutions are being referred to the Committee on Local and Consent Calendars. HR 1327 by Perez of El Paso. HR 1328 by Goodwin. The following resolutions by Zwiener are being referred to the Committee on Local and Consent Calendars. HR 1329 through HR 1335. HR 1336 by Button. HR 1337 by Button. HR 1338 by Busey. HR 1339 by Slauson. HR 1340 by Martinez Fisher. HR 1341 by Gervin Hawkins. HR 1342 by Schofield. HR 1343 by Curry. HR 1344 by Lujan. HR 1345 by Verdell. HR 1346 by Bella Montgomery. HR 1347 by Allen. HR 1348 by Harris Davila. HR 1349 by Harris Davila.
Mr. Harris moves the House adjourn until 10 a.m. Monday. Is there objection? Chair hears none. The House stands adjourned.